welcome to Crime in Court. This is the 1996 Menendez brothers trial, and we are on the state's case, part 20, and we're going to continue on with Detective Leslie Zoller's testimony, and then we will, once we complete his, then we will move on to Lyle's friend, Glenn Stevens, and I am going to be doing a voiceover only today. My hips are really hurting, so that's what we're doing today. But you guys can still see the transcript and follow along on the screen. I still have Judge Weisberg and attorneys for the state, for Lyle, and for Erik up on the screen for visual reference for you. All right, so we are on week 4 now. We have just, or actually, I'm sorry, we're still on Friday because we're still finishing up Leslie Zoeller. He began on October 27th. I screwed that up. He started on October 27th, and he's going to continue through the 30th. So Amir Eslaminia, we just finished up with him. He was a little problematic for the state, but they didn't care. They impeached their own witness, so I don't know how good that does for them, but that's the route that they went. All right, so we're gonna just get right back to Detective Zoller's testimony, starting with cross-examination because that's where we left off. So, Ms. Abramson is going to be doing the questioning for Erik's team right now. Detective Zoller, have you marked a copy of your report? I don't believe so. Do you have a clean copy? I may. Yes, I do have a clean copy. Could we mark Detective Zoller's clean copy 144, Your Honor? Yes, says the court. Ms. Amerson says, thank you. Did you mark it? Yes. The witness says yes. Thank you. You're getting good at this. That report that you just marked 144 is what contains your narrative recitation of your conversations with Mr. Eslaminia. That's correct. It also has a narrative recitation of the service of the search warrant. That's correct. Correct? And when did you actually write the report? April 18th of this year. And before, and it's April 18th, 1995, correct? That's correct. And when you wrote the report on April 18th, was that the first time that you were writing any report to recite the conversation that you had with him from October 12th, 1994? Yes. So several months later, he's writing his report. And before you wrote the report that laid out that conversation, did you, in writing, only have a set of notes? That's correct. Your Honor, I have 3 sheets of handwriting. I'd like to mark them 145. The court says 145. Saberson says, thank you. Detective Zoller, is this a Xerox copy of the notes that you had of the conversations with Mr. Eslaminia of October 12th, 1994? It is. And that's a 3-page document, is it not? That's correct. But in fact, only 2 pages have any notes of that conversation. Correct. I want to read to you, Detective Zoller, or rather, I'd rather do this to save time and objection. Here is a magic marker. I would like you to highlight on these notes all the words that these notes contain which directly reflect the conversation you had in which Mr. Eslaminia is describing meetings with Erik or Lyle Menendez, construction of a scenario, the letter, all of the things that refer directly to the notion of creating a false story. That's fair. Well, so is this one indicating, he's indicating, so this one, he's asking a question. Um, she says, yes, right there. He says, and you like to, she says, no, I just want to make sure we don't disagree. That's all. Thank you. On the 2 pages, well, let me just clarify this. The 3rd page of the document is an address, correct? That's correct. So, on the 2 pages of the document that actually contain notes of the conversation, you have highlighted the following. Quote, "It was all what they thought he could do with." Is that one sentence? Correct. Yes. Why don't you get yours out? Thank you, says the witness. And then turning to page 2, you have highlighted letter from Lyle before trial. Correct. Then you have highlighted the issue was into the trial. That's correct. And you have highlighted Erik and Lyle had whole story, was in on it. Correct. Then you have highlighted 1 year too. Correct. And then you highlighted gun was due to fear. Correct. I note it doesn't say fear of parents. That's correct. And then you highlighted they added dynamics as they went on to fit the as time went on to fit the as time went on to fit the correct. And that's the total words in your notes of that conversation with Mr. Eslamania on that topic, correct? Correct. And I will just add in the left margin it says 7-page letter. Right. I will highlight that for you. He says thank you. That's where we identify the letter, that he had a 7-page letter. Correct. Now, he only showed you 1 page? The back of 1 page, correct. So you had called him and asked to meet with him to interview him about this case? Yes. He had agreed to meet with you? Yes. He came, that meeting was not at his house, it was at a restaurant, correct? Correct. He came to that meeting with a page of that letter. He did. Would you turn to the page that he came to the meeting with? I have it, the back page. Right. Did you discuss with him at that meeting the details of the back page? In substance, yes. Are there any notes that reflect a discussion about the details of the back page? No. So he didn't write any note. They talked about it in substance, but he didn't write notes about it. Now the final paragraph before the final paragraph before the sign off refers to me, does it not? It does. And it says, does it not, quote, "Do not fall for any of Leslie's tricks. She may say Erik told me that. This story is not true." End quote. Just maintain. Oh wait, no, that's not the end quote. Sorry. That's the end of her quote, what she might say. Just maintain that it's all true to the best of your memory. So he's saying to whoever, saying that it's, just pretend like it's true. Correct. Did you ever ask him? Well, strike that. You had asked him specifically, was Erik involved in this towards the end of his reciting how the story came about, correct? That's correct. And he said, oh, Erik had the whole story, correct? Correct. Did you ever ask him, how come if Erik had the whole story, is Lyle telling you that Erik's lawyer is going to say Erik told me that the story is not true? Did you ever discuss that with him? No. To the best of your knowledge, Detective Zoeller, was Robert Shapiro Erik Menendez's first attorney on this case? He was. And was it a matter of the couple of weeks before I was retained to represent him? That's correct. And so from some point in March of 1990 to the present, I have been Erik Menendez's lawyer continuously. Yes, you have. Thank you, sir. I have nothing further. The court asks Mr. Gessler, and he says no objection, Your Honor. The court says any redirect. I think he meant like no cross. I don't know. Any redirect, and yes, there is redirect by Mr. Khan. Your testimony today concerning the conversation that you had with Brian Eslaminia on October 12th of 1994, is that based solely on your notes in front of you, or is that based also on your memory, on your memory? These are just my notes. It's my memory also. That's correct. Thank you. I have nothing further. Court says, anything else? Any further cross? Ms. Abramson says, yes, one thing. If I may reopen my previous cross. The court says yes. Ms. Abramson says, you didn't write the report until 6 months after the conversation, did you? Correct. So you couldn't have read it to the witness until 6 months after the conversation. That's all. That's correct also. Was he taking notes during the conversation? During which conversation? The one in October. Not to my knowledge, no. Did you send him the report before you read it to him? No, it was as I completed it before it was handed in. I read it to him for accuracy. And that was sometime in April? I believe it was the same day that I completed it, on April 18th. And you called him in the morning? I believe it was in the afternoon. So he didn't even remember if it was morning or afternoon. Is that fair? That's fair. And that call was about 6 months ago, right? Correct. Did you know whether or not when you spoke to him he was sober? Other than the way he sounded to me, as far as what I consider to be normal, no. Do you know if he had taken any medication or drugs? No, I do not. Thank you. I have nothing further. The court asks, anything else? Mr. Khan says, no, Your Honor. The court says, thank you. You may step down. Ms. Abramson says, wait a minute. Excuse me. I do have something else. I'm sorry, Your Honor. Didn't this witness tell you on September 14th, 1995, that his memory was impaired by the fact that he was on medication? I don't believe he did. Oh, okay. She says, let me take a look. You took more extensive notes on September 14th, 1995. Did you not? Mr. Khan says, objection, misstates the evidence. Objection overruled. The witness says, I did. Ms. Abramson says, did he tell you on September 14th that he was mixed up between Leslie's calls, the boys' calls, Mama's calls, Beatrix's calls, Henry's calls, and he was on medication? Correct. Nothing further. So Brian has Laminia, Amir is Laminia, on medication, all mixed up, and couldn't tell you up from down. So how is he credible? She says, thank you, nothing further. And the court says, will you verify or clarify when it was that he was on medication when the calls occurred or when the medication occurred? Ms. Abramson says, I can't tell from your notes. And was he referring to any particular time period or his basic operational life? The witness says, if I could clarify the question before that. Well, before that. No, I know what the question was before that. The question is not written in here, correct? Correct. What was the question before that? The question was how many times he had actual calls or visits with Erik or Lyle Menendez. He said he was mixed up on the calls because of all of these other people's calls. Correct. And that he was on medication. That's what he said. But medication over what period? The whole period of time that he had any contact with Erik and Lyle? That information is in that one sentence. So you don't know what he was referring to. That's correct. And this is what he said on September 14th, 1995. Correct. I have nothing further, and I mean it. The court says, you sure? She says, I'm positive. Absolutely positive. She says, but if he's going to ask something, I might. We'll see. Okay. We're going to have some further redirect now. Now, Mr. Khan asks, that conversation on September 14th, 1995, did that take place in my office? It did. And was Mr. Eslaminia a cooperative witness by that date? Ms. Abramson says, well, I'm going to object to that. It calls for conclusion on the part of the witness. The court says, it's unclear what it means. Mr. Khan says, yes. Did Mr. Eslaminia indicate during that conversation that he was not willing to be a witness in this case? Yes. And what kinds of statements did he make during that interview in my office which indicated that to you? Ms. Abramson says, objection, Your Honor, that is hearsay. There's no foundation. The court says, well, it's not intended for the truth, just to show the attitude of the witness when he was interviewed. Ms. Abramson says, but it should have been confronted to the it's it should have been confronted to the witness first. Oh, or shown to the witness first, and it wasn't. The court says, well, it's been brought out by the nature of the cross-examination as far as the attitude at the interview. Ms. Abramson says, I don't believe so. I'd like to be heard on this, Your Honor. Court says, I think it has been overruled. The witness says he stated it was brought up just when he was testifying earlier that he would lie like a dog, that when it was a capital punishment case that he would most likely lie and that he would stand on the side of the defendants. It was that type of attitude that he had. Mr. Khan says, and did he say anything about his memory during that conversation? Do you remember? Ms. Abramson says, I didn't hear the question. I'm sorry. Can I have it reread? Court says the question was whether or not Mr. Eslaminia said anything about his memory. The witness says he stated that he would most likely forget things and that he wouldn't make a good witness. Mr. Khan says, and one of the things he also said was that Ms. Abramson interrupts and says, well, I'm going to object to counsel testifying. We weren't invited to this meeting. So the court says, without counsel editorializing here, the question is leading, the objection is sustained. Mr. Khan says, do you remember in reference to those various reasons why he would not make a good witness, how it came up, that the reference to medication came up? Ms. Abramson says, I'm going to object to leading. The witness just testified as to how it came up. Court says, overruled. Witness says, could you repeat the question again, please? Mr. Khan says, yes. During the discussion in which he was giving you various reasons as to why he would not make a good witness in this case, do you remember how that reference to medication came up? Yes. And how did it come up? It came up with us trying to pin him down of how many times he had actually had conversations with Erik and Lyle Menendez. Okay. Now, putting aside that interview with him in my office on September 14th of 1995 and going back to the earlier conversations that you had with Mr. Eslaminia, did he ever indicate to you during any of those conversations that he was on medication? No, he did not. And did you ever see any sign that he was on medication during any of those interviews? No. Thank you. No further questions. Ms. Abramson says, can I have a moment, Your Honor? The court says, further cross? Yeah. Ms. Abramson asks, just going back to your notes of October 12th, 1994, wouldn't it be fair to say, Detective Zoeller, that even if that interview, Mr. Aslamania was not clear and was not specific about whether he was talking to you, uh, just talking to just Lyle or Erik and Lyle or Erik about the scenario, you asked him a question to clear it up, didn't you? That's correct. He was saying they a lot, and I just wanted to verify that the they that he was talking about was the same they that I thought he was talking about, Erik and Lyle Menendez. Well, you specifically asked, and it's in your report, whether Erik was in on it, because your report reads, does it not, quote, I asked if Erik was involved in the creation of the scenario. That's what you wrote in your report, right? That's correct. And you didn't say not if Erik and Lyle were involved, if Erik were involved, correct? Correct. It was clear that Lyle was. Correct. So the unclear was about Erik. Correct. And then he said Erik had the whole story? That's correct. Now, this is on the day when he wants to swap something with you, correct? Correct. He wants you to take care of the warrants, and he will give you something in return. That's correct. I have nothing further. Mr. Gessler jumps in for Lyle and says, I have a few questions, Your Honor, based on the redirect. Certainly. Mr. Gessler says, Detective Zoeller, you said that Brian Eslaminio was uncooperative in this September 14th meeting that you had with Mr. Khan and himself. Generally, I would say that, yes. Now, this meeting was held at 6:30 or so in the evening? That's correct. And where was it held? At 210 Temple, downtown. District Attorney's Office? That's on the 18th floor? Alternate Juror 3 says, Excuse me, Your Honor, I'm going to have to leave for just a second. And the court says, let's take our recess. So a juror had to, I don't know, had an emergency. All right, the court says, we're back. The juror who had to take a break is feeling ill today and had stomach flu, so he feels he can be back tomorrow. So we will take a break right now and let everybody go home, and we'll be back tomorrow so we can get off the witness stand. The witness says, thank you. You can get them. The court says you can get them out, the jurors. So the jury enters the courtroom and the following proceedings are held. The court says, okay, you don't have to be seated if you don't want to. The jury is back. And because of the illness of one of the jurors, we will take a recess now, and hopefully he will feel better tomorrow. And again, don't discuss the matter with anyone. Don't form any final opinions about it. And we ask that you return tomorrow at 8:30. We'll see you tomorrow. So the jury exits the courtroom, and the following proceedings are held outside the presence of the jury. Court says, okay, you have a witness to order back. Ms. Nahara says, yes, Your Honor. We have Mr. Stevens in court today. If he could be ordered back tomorrow. The court says, Mr. Stevens, you are excused today and ordered to return tomorrow at 8:30 a.m. Are there matters that we can deal with while the jury is gone? Any issues or hearings? Ms. Nahara says, yes. Of course, there's lots to go over. So Mr. Gessler says, there's one issue brought to my attention by Ms. Nahara. I think that's what she is going to talk about right now. The Glenn Stevens offer of testimony. Ms. Nahara says, yes. The court says, so we can do that. And we have the deferred hearing of Pisarcik as well. Perhaps we can address that and any other issues. Any further word on the testimony of the pathologist for the prosecution? Mr. Khan says, we are still scheduled for for next Monday for him to testify, and he will be followed by it's Dr. McCarthy, and we will then rest. The court had instructed the people to submit two motions in writing, a motion concerning the admissibility of the prior burglary convictions and also a separate motion concerning the feasibility of laying a foundation for the testimony of the pathologist, and both of those motions will be completed. We will have that to the court by 1:30 today. As far as bringing in a witness, it is going to be our preference concerning laying the foundation for the testimony of the pathologist to do that. The bailiff says, Your Honor, the jurors will be walking through. The court says, yes, please. There's a brief pause. Court says, go ahead. Mr. Khan continues. Based upon the case law as we reviewed it, I think that an adequate foundation can be demonstrated through the testimony that has already been presented, and then also laying a further foundation through the custodian of records to establish the admissibility of the documents, or at least sufficiently establish them as reliable documents such that the pathologist can then testify to those documents. So we have a custodian of records who we had ordered subpoenaed to the court for today. She did not have all the materials with her, so I instructed her to leave for today and to come back later this week. I would ask that when we submit these two motions for the court today, the court will then have an opportunity to review them, and perhaps we can discuss the matter further perhaps tomorrow, so that perhaps by Wednesday we can determine whether the custodian of records would be sufficient to lay the foundation for the admissibility of the documents, or at least reliance by the expert upon the documents, whatever that means. Or if not, then if we will have someone from the coroner's office to establish a further foundation. The court says, let me ask a few follow up on what was said on Friday. Ms. Abramson indicated that she had spoken to Dr. Lawrence by phone Thursday and that it was her information from that phone call that the prosecution had yet to interview Dr. Lawrence. Have you done that yet? Mr. Khan says, I haven't spoken to him. He is out of town and he simply hasn't had an opportunity to come into town. I haven't had an opportunity to go meet him, but I have had brief discussions with him over the telephone, and I do know that he agreed with the analysis prepared by Failure Analysis, and I contacted him once again on Friday again after that conversation, and he basically reiterated that he has no problems with the reports of Failure Analysis. The court says, okay, what I would like before we get into a hearing dealing with admissibility of things is that you speak with him on the phone or in person, whatever, and verify not just the generalities that he has no problem with the report or that he is going to support what is in it that Dr. McCarthy said, but the specifics of the wounds that were described in Ms. Abramson's remarks on Friday, so that you are satisfied that the witness will in detail support your position. Otherwise, his testimony might not be presented in the way that you now envision it. So, I would rather hold off on a hearing until we know the testimony is going to be presented in a fashion you now envision it. And I would like to have that determined as soon as possible. Mr. Khan says, okay. Ms. Abramson says, Your Honor, with respect to any hearing, we haven't seen pleadings yet, so the court says, I understand that. You will get that this afternoon. Ms. Abramson says, sure. All right. The court says, all right, what is the issue then with Mr. Stevens? Ms. Nahara says, Your Honor, I had been discussing with Mr. Gessler what I would be going into with Mr. Stevens. Remember, Glenn Stevens is a former friend of Lyle's. Given the court's rulings and what came in the first trial, and there was one issue that came up over the weekend. Mr. Stevens testified at the preliminary hearing, but not in trial, that as part of the conversation that the court ruled admissible concerning between Lyle Menendez and Mr. Stevens on the plane coming back to LA the week of his arrest, they talked about the Oziel tapes. They also had a conversation about a concert promotion that apparently Erik Menendez had been involved in with a deal that he had lost some money on. Mr. Lyle Menendez told Mr. Glenn Stevens and another individual who was present that they wanted to find the individual involved with the concert promotion, and in the course of discussing it, Lyle Menendez, stated that if they couldn't basically be satisfied or get the money back, that they should take the life of the guy with a razor wire and dump his body somewhere off a cannon. I don't buy that for 1 second, but okay. Because this individual had been estranged from his family and they probably wouldn't get going his going missing wouldn't be noticed. And at that time, the two individuals, Mr. Stevens and the other individual, weren't really interested and didn't think this was a very good idea. Mr. Gessler informs me that he is aware of this and it has all been turned over in discovery. Mr. Gessler says, I informed her of a little more than that, Your Honor. I also informed her that I would be vociferously objecting, that I believe that this was gone into at trial. There was no evidence presented by the people before the jury at the first trial of this statement. It's highly prejudicial and totally non-probative. There is nothing concerning a piano wire in the particular homicide that we have here. It's uncorroborated solicitation of another crime. It's just The court says, let me just ask the prosecution, what is it supposed to prove? Ms. Nahara says, it was basically to show his criminal nature and criminal intent. This was part of the conversation wherein he was also talking about Dr. Oziel. The court says, where does that come in? Where is the legal authority for that? Ms. Nahara says, I think it's relevant to show his state of mind. What state of mind, says the court? The state of mind that he would be willing to basically take the life of this individual who was basically cheating him out of some money. Taking the life for money basically is what it all boils down to, and I think that's what the case boils down to as well. Court says, aren't there any rules that apply to that? Ms. Nahara says, well, there are, Your Honor, but I think in this case it is highly relevant and extremely probative of the issue of whether he would be willing to take a life for money. And that is the issue, for Your Honor, and that is what we would offer for the theory for. And the court says, well, there are rules of evidence and rules that are encompassed in Section 1101 of the Evidence Code, but beyond that, due process rights as well and 352 of the Evidence Code, and from what you have said, presented to me, there is no legally viable way that that evidence is admissible. Ms. Nahara says, for the record, Your Honor, we were putting it under 1101B analysis. I understand what the court is saying. It would go under 352, being very relevant of the issue of the defendant's desire to take the life for money. The court says, all right, well, I find it would not be admissible. Ms. Nahara says, okay. Court says, what is anything else regarding Mr. Stevens? Ms. Nahara says, we discussed it, and I believe that's it. Mr. Gessler says, I think so. The rest of it went to the proffer that the people had made originally and what they testified to or he testified to at the first trial. There are some other things that were out there, but they're not being offered by the people, and therefore I have no objection to the proffer as made. The court says, my notes indicate that his testimony was being offered only against Lyle Menendez. Is that correct? Ms. Nahara says, that is correct, Your Honor. The court says, okay, how about the Pisarcik hearing? Are you ready to proceed with that one? Ms. Towery says yes. Ms. Abramson says yes. Ms. Nahara says yes. The court says, okay, I have read the materials filed by the defense and the notes that were presented regarding the interview of Ms. Pisarcik. This is additional evidence that was not presented. Some of it was not presented during the people's rebuttal case in the first trial. Some of it was presented, but all of it was presented before the Lyle Menendez jury only. So, is there anything that the defense wanted to add to its written materials? Ms. Towery said, I would just add one argument, Your Honor, with respect to this issue. There are some other issues that I would ask to raise briefly, but not relating to this particular aspect of the testimony. The court says, okay. Ms. Towery says, and that is that, and that is, and that is that. And I don't think this argument was made in our brief, or if so, it was not made clearly. And it's a relevancy objection to the research aspect of the testimony based on the new information that we have received from Detective Zoeller's notes. Detective Zoeller's notes, which have since been reduced to a formal report and clarified to some extent, and the court says, I haven't seen that report. Ms. Towery says, we just received that on Friday. Still receiving reports from law enforcement in the middle of trial. Second trial, no less. Ms. Abramson says, would you like a copy, Your Honor? Ms. Towery says, and that is that Ms. Pisarcik now has indicated that the cases that she did copy were turned over to Jill, which presumably was Jill Lansing, one of his attorneys at the time. Therefore, the inference that the prosecution seeks to have drawn from this activity is false in the sense that the cases were never provided. According to their own witness testimony to Lyle Menendez, they were provided to Miss Lansing after copying. So he never saw them. He just gave her the sites according to her testimony, and then she copied them and gave them to Jill Lansing. So I would argue, in addition to the arguments already made in the brief, that the proffer is irrelevant on that ground alone. Ms. Abramson says, I would just also point out, Your Honor, just the overview of this evidence that there is nothing impermissible in researching your case, and to allow the witness to discuss this in the way that she testified last time and the way that as a layperson she is likely to do so raises the false inference that the defendant seeking to do legal research is seeking to fabricate, and I just think it's totally irrelevant if someone is doing legal research that plus that plus the fact that it involves references to other lawyers who worked on the case, and of course, I was on the case at the time. Take a shot at the time. I just think it's of zero probative value, only meant to confuse the jury upon what is and what isn't appropriate for a defendant and for his lawyers in preparing a case. So she's basically arguing there's uh, nothing wrong. So Lyle, in case you forgot or don't remember or whatever, little refresher. Lyle, in prison, asked Jamie, his girlfriend at the time, to research other cases of brother or people being, maltreated by their parents and uh, using that to help them in their defense, basically. The maltreatment that they endured growing up, can you use that as some kind of a defense? He asked her to look up these cases and give them to Jill Lansing, his attorney in the first trial. And that is what she did, apparently. And yet there's nothing wrong with that, but the inference that was made at trial was that they were doing something bad and like trying to lie. When really, in reality, there's nothing wrong with doing legal research, especially if you're a defendant. Like that would be the one time that you should be looking at other cases and trying to, do legal research if you're not a lawyer. So there's nothing wrong with it, and that's what she's arguing. Um, I mean, the notion, even that the fact that Paul Mones, who was an expert on CA and parricide, is is his lawyer, and that somehow, or was a lawyer he was thinking of hiring, and that somehow is wrongdoing or indicates a fabrication, flies in the face of the right to counsel. And there was a case, which I don't have the site for, called People versus Schindler, Your Honor. It was a homicide case in which the battered wife who took the life of her husband wound up hiring Paul Garagos, who had previously prosecuted the husband for the taking of the previous wife. And the fact that on the night of the shooting, she called Mr. Garagos, not to be confused with Mark Garagos, the brother's attorney now. Just wanted to point that out. So it was, let me reread this sentence because there's a lot going on here. So it was a homicide case in which the battered wife who took the life of her husband wound up hiring Paul Garagos, who had previously prosecuted the husband for the taking of his previous wife. That's a whole kind of love triangle, true crime love triangle right there. And the fact that on the night of the shooting, she called Mr. Garagos, who was then in private practice, was no longer a district attorney, to represent her, was admitted in the trial to show her clarity of thinking, if you will. It was reversed on appeal because her selection of counsel was being used to incriminate her in some way, and I think the same. I can get the Schindler site. I know the case well because after that appeal was granted, it was reversed and I wound up being her trial counsel. But I think it's the same implication here that because Lyle Menendez consulted with an attorney who was experienced in the field, somehow that connotes some wrongdoing. So I think it implicates federal constitutional rights as well as being irrelevant. And I think the court previously had responded to the prosecution's efforts in this case to claim that Mr. Moan's book was somehow a source of fabrication, and I know the court reviewed that material when the people were trying to use the book on its own and found no support for the notion that what Mr. Moans wrote pointed sort of in a copyright sense to the copying of this defense. The court says, all right, let me hear the people's response. Ms. Nahara says, thank you, Your Honor. In regards to the arguments made in the moving papers, and here regarding the subject of the research that Lyle Menendez asked Jamie Pisarcik to do, I believe that counsel is looking at that in a vacuum. The facts are that the first thing that the defendant Lyle Menendez asked Jamie to do was to research some issues involving cases that dealt with CA. After that, she will testify. A short time later, he asked her to commit perjury and accuse his father of SA. Now, following on the heels of that is when he holds up the letter and confesses and says that he wants, as to the reason that he took the life of his parents, was basically all involved with SA. So it shows when you don't look at it in a vacuum, but when you look at it in terms of all of her communications with Lyle Menendez, one after another, how it ties into a theory that I think the people should allow to be argued in this case and present evidence to which is the defendant, Lyle Menendez, is in fact trying to connote a defense, and that has been our theory. So basically, he tells her to look up cases on CA. She comes back with SA. So now he changes his defense, and that's what they're trying to argue. Like he changed his defense because she came up with cases of SA, or maybe he realized that. But even so, like, aren't they still one and the same? Like SA of a child is still CA. Like, are we really picking apart this defense so much here? I mean, it's like the same thing. This is really a dumb argument. Anyways, I believe that Mr. Khan even argued that in opening statement, not argued that, stated that was what the facts would show in this case. With regards to the second issue, which is the issue of Mr. Moans, I have reviewed the reports, the notes, and the moving papers of counsel, and I will admit that they are very vague comments and references to Mr. Moans, and in terms of whether or not they would be relevant to the case in their present form, I would have to agree that they would not be. And we would not be proffering that statement that she made for the simple reason that it is too vague and it doesn't really, in its current state, doesn't appear to add any relevancy or any light of this particular subject. Ms. Towery says, may I respond briefly, Your Honor? The court says yes. First of all, with respect to the series of incidents that counsel refers to, in fact, the defense that was presented at the trial was a defense of A, including SA and fear of their parents by both Lyle and Erik Menendez. What the prosecution and Jamie Pisarcik did testify to a single incident in which Lyle Menendez asked her to fabricate an incident not relating to SA or Lyle or Erik Menendez and not relating to A of Lyle or Erik Menendez at all, but relating to behavior of Jose Menendez towards Jamie. The prosecution seeks to leap from that single incident to an argument that the entire defense has been fabricated and seeks to use proper conduct on the part of Lyle Menendez and his counsel in researching and preparing a defense, which they have. Lyle Menendez has a constitutional right to do and piggyback the inference of fabrication into an inference that the entire defense was fabricated, not only by Lyle Menendez, but by all of his attorneys. Now, they have drawn in Miss Lansing and Mr. Moans, who subsequently was retained by Lyle and Erik Menendez to represent them both, not as a trial attorney, but as an expert and trial consultant, and in fact did represent Lyle and Erik Menendez throughout the entirety of the first trial and still has provided consulting for the defense teams in connection with the second trial. So, without any foundation, without any basis, the prosecution seeks to have the jury draw the inference that what Lyle Menendez was doing was wrong in seeking to research the defense, that he, in fact, was prevented in seeking to hire an expert in the field of his defense, which would be Mr. Moans, who is nationally renowned expert in the field of parricide cases. There is nothing wrong with what he did, and the prosecution has no evidence of anything. The court says, but she says she is not going to refer to that. Ms. Abramson says that's because we can impeach her. Ms. Towery says, Your Honor, that's because she can be impeached on that issue, and we would be required to impeach her on that issue because Jamie Pisarcik's statement was that Lyle Menendez told her in early December or late November of 1990 that he had read Mr. Moan's book, and Mr. Moan's book wasn't written for almost a year after that. It wasn't in the bookstores until September of 91. He hadn't even written it yet. So, it's not possible that Jamie or Lyle Menendez could have told Jamie Pisarcik that he had read Paul Moan's book. It didn't exist. Similarly, the research that she says she conducted on his behalf was about cases that also did not exist. And we had testimony at the last trial about that. And there is no such thing as acquittals of children who claimed CA, and took the lives of their parents. There are no such cases. There never have been. Unless the principles of our justice system have changed, there won't ever be any such cases. There probably should be. So she can be impeached in both of those areas, which reduces the probative value of the proffer even less than it would have been otherwise. But it raises the prejudicial effect, not only because we will be required to bring these facts out, most specifically with respect to Mr. Moans, but we will be required to go into the whole issue of Lyle Menendez contacting Mr. Moans, perhaps Erik Menendez retaining Mr. Moans. It will raise a hornet's nest of irrelevant issues which the defense will have to go into to rebut these unfounded inferences in the first instance. The court says, any response by the prosecution? Ms. Nahara says, just to clarify the issue, Your Honor, I think counsel misspoke when she stated that Jamie Pisarcik stated absolutely that Lyle Menendez had told her that he had gotten some of this information from Paul Moan's book that he wanted her to research. In fact, what she says was that she wasn't sure where she got that information that he wanted her to research, but she was speculating that it possibly could have come from Paul's book, but she doesn't know and didn't remember, and I believe that's reflected in the report as well. Ms. Towery says, well, Your Honor, again, Ms. Nahara's own notes indicate that when Lyle Menendez asked her to do research for him, he explained that he was working on his own defense. He also stated something about a man named Paul Moans, that either he had read his book or that he wanted him as his lawyer, and he wanted Jamie to look up some of this Paul guy's cases. Again, there are no such cases. Paul Moans had no such published cases and had none at the time, so all of these things could not have occurred. Detective Zoller's version of the conversation, the same conversation, indicates that Ms. Pisarcik would, after copying the cases, she would then give these cases to Jill. This was done in approximately November, December of 1990. One of the books that Lyle talked about was the book written by Paul Moans. So, in version of what he said is more definite. His version is that Lyle Menendez, in fact, talked to her about a book that had not yet been written for another year. So clearly, it's impeaching and would be something that the defense would have no choice but to bring out. The court says, all right, anything else? Ms. Nahara says, nothing from the people. Your Honor, the court says, okay. My view, after listening to the argument, having read the written motion objecting to the introduction of the evidence, I haven't read the portion of Detective Zoeller, or the report of Detective Zoeller. It was just presented to me this morning, but I did read the rough notes that were the basis of this report. It's my view that at this point, and especially at this stage of the proceedings when the people are still on their case in chief, the reference to research of cases and providing that to Ms. Lansing in reference to Mr. Moans, if it was offered by the prosecution, is not relevant at this stage of the proceedings, and if there was any probative value in it, it's substantially outweighed by a potential prejudice. However, if Lyle Menendez testifies, I cannot foreclose this, as an area of inquiry during cross-examination. I don't recall whether it was an issue brought up during his cross-examination in the first trial, whether or not the people were aware of this information until after he testified. I have no knowledge of that one way or another, no recollection of it. I don't think it came in until the rebuttal case, to be honest, if I remember correctly. However, at this stage, bearing in mind that the people have yet to rest, they're putting on their case in chief, and at best, the type of evidence would relate to impeaching a defense that has yet to be proffered. The court finds that it is not sufficiently probative to outweigh its potential prejudice. Therefore, the objection is sustained. Ms. Nahara says, "Thank you, Your Honor." Ms. Towery says, "Thank you, Your Honor." The court says, "Any other issues at this point that we can deal with today that otherwise will have to be dealt with at some other date so we don't keep the jurors waiting?" Ms. Towery says, "There are a couple other brief issues relating to Ms. Pisarcik that we can deal with today. The prosecution had indicated that they intend to show, I presume, to the jury as an exhibit during the course of Ms. Pisarcik's testimony a clip from the movie At Close Range, which I presume is the scene between or the scene referred to in the conversation between Lyle Menendez and Jamie Pisarcik back in December of 1990. I haven't seen the clip that the prosecution proposes to show to the jury. I did watch the movie on Friday night, and I would ask that if the court is inclined to show such clip, which I would object to, because at the time that Jamie Pisarcik gave her statement under oath to the deputy district attorneys handling the case in 1992, she did not indicate that she had seen the movie, and most particularly did not indicate that she had seen the movie with Lyle Menendez, as she now indicates in 1995. The court says, "Was she asked?" Ms. Towery says, "Yes." Well, I don't know if she was asked that specific question, but the court says, "Did she say she had not seen it?" Ms. Towery says, "What she said she had seen the film. She said, 'I saw the film.' And in the same sentence, she said, 'I had not seen the film,' in connection with describing the movie. And I don't have all of my files with me, but I have that. It's at page 57 of the transcript of that conversation. The question is, what happened in the At Close Range movie? Question by Mr. Kuriyama. Answer: I didn't. I had seen the movie before. I did not go home and watch it. I had not seen it, but in that movie, the father, I guess, makes passes, or I don't believe he R's the one character, Sean Penn's girlfriend. He had asked me to say that that's what happened. And then Ms. Bizanich says, "Jose made a pass at you, just as in the movie?" She answers yes. She indicates, I guess she was specifically asked in a manner of speaking, and she indicates that she had seen the movie and she hadn't seen the movie. Now, in her more recent version of the event, she says that she and Lyle had seen the movie together, although she described in Detective Zoller's report, she describes the scene as an aggressive come on by the character's father towards Sean Penn's girlfriend in the movie. What I would ask, number one, is that it be precluded both as irrelevant and as more prejudicial than probative under 352 of the Evidence Code, and if the court is inclined to permit the plaintiff's playing of that scene, then I would ask that the court play the entire movie for the jury in order to place that scene in context, because it's important in understanding the scene that it be placed in context in the movie. I would ask that the court watch the movie to make the determination if you don't want to take my word for it. But I think that if any portion of the movie is played, the entire movie should be played for the jury. That's weird to play a whole movie for a jury. I also wanted to make sure that the prosecution does not intend to proffer any evidence regarding Ms. Pisarcik's purchasing of a book about the Billionaire Boys Club for Lyle Menendez as both irrelevant and raising issues that are more prejudicial than probative, and I would point out that in her most recent interview, she indicates that she went back, I believe, to her original statement that she didn't really remember what books she purchased for him other than one relating to sign language, and she couldn't recall any other books in particular. So I would object to any reference to that under both relevancy and 352 grounds. And last but not least, I would object to any additional evidence on spending on the part of Lyle Menendez without further discovery. There is a portion of Detective Zoller's report which also appeared in his handwritten notes indicating, and I will read it to the court. It's a page 4. It's at page 4 of the police report, the third paragraph down, and it states, quote, after the homicides, then Jamie was living with Lyle at the Marina City Club. Lyle bought suits and a lot of furniture. He made furniture for the dining room, living room, bedroom, and office. He also bought a complete stereo system. Lyle wanted all new things. He wanted nothing from the old house. Without more, we don't know what it is that he bought. We don't know how he paid for it. We don't know if it was rented or purchased, and we don't know if Jamie Pisarcik had any personal knowledge of those things. We just have a conclusionary statement that pops up in a police report of October 12th, 1995. So I would object to any testimony along those lines without adequate discovery. The court says, all right. Do you intend to offer the movie or a portion of the movie? Mr. Khan says, yes, Your Honor. We would offer to play that portion of the movie dealing with that particular scene, and I don't think counsel has made a sufficient showing as to why the court should review the remainder of the movie or why the remainder of the movie is relevant to that one particular scene. She is simply saying she feels if the jury watches one portion of the movie, they should watch the whole movie, and I think that unless counsel makes some showing establishing why that is necessary, I just don't see any reason to do that. We would offer to play that one scene, because regardless of when or regardless of whether or not Jamie Pisarcik had seen that movie prior to the time that she had made the statement to the police concerning that movie, the scene is still relevant because it graphically depicts something that Lyle Menendez wanted the witness to see and wanted the witness to testify to. So we will review during the lunch hour the portion of her prior interview in which she seemingly makes a conflicting statement about whether she had or had not seen it. I think it was one of those statements that appears impossible to determine just from reading the transcript what she was attempting to say, but very likely when we listen to the tape, we will be able to get a better idea of what she was attempting to say. Regardless, I think that the single scene is admissible and we would offer to present that scene to the jury. Ms. Towery says, may I respond very briefly, Your Honor? The court says, first of all, if you can prepare that for showing so I can see it. Mr. Khan says, yes. The court says, if you have it. Mr. Khan says, we have that ready and we could give the court that excerpt from the movies this morning. Ms. Abramson says, the problem is that we have never been given a copy of it, so I think seeing it in court is the way to. The court says, we will do this afternoon if you have it. Mr. Khan says, we will bring it down at 1:30 and we will play it. Ms. Abramson says, we have to come back this afternoon to see a clip from the movie. The court says, you might have to come back this afternoon just to continue on with what was going on this morning. I don't want to lose time. Whoa, okay. Okay there, buddy. It's not like she's in the middle of a trial or anything and couldn't be doing like a bajillion other things when she's not in court. But yeah, make her come back in the afternoon. Ay, ay, ay. He says, I don't want to lose time. As I said, if there is other things that are going to require us to litigate outside the presence of the jury, I would rather do them now while the jury has a good reason not to be here. Ms. Abramson says there is nothing else we are prepared to do here. The court says we haven't finished our discussion here about the movie. Ms. Towery says, I just had another comment with respect to the movie. The only evidence that Lyle Menendez saw the movie as opposed to having heard about it from somebody is with regards to her prior testimony in trial, the prior testimony in the trial when she adopted this statement. The court says, what statement? That Lyle Menendez had not seen it? Ms. Towery says, no, that she had not seen it or was equivocal about her answer. The court says, I thought you said there is no evidence that Lyle Menendez has seen it. Ms. Towery says there isn't. There is no reference that Lyle Menendez had seen it. The court says apparently it was a source of reference. Ms. Towery says, we don't know if he saw the movie or not, or knew what it was about. We don't know if he saw the scene or heard there was a scene or what had happened to do with the father attacking the son's girlfriend. Also, Jamie Pisarcik, the court cuts Ms. Towery off and says, is it the same movie that is referred to in the letter to Mr. Eslaminia? Ms. Towery says it was the same name. I assume it is probably the same movie. And again, we don't know if he saw that or if somebody told him about it. He was in jail when he was making those comments, and obviously he didn't have a VCR a VCR in his cell. And I believe the movie came out in 1985, as best as I have been able to determine. So it wasn't a new film. They didn't have iPads in their cells like they do now, although they can't just watch movies and stuff because they don't have internet access, but they can access certain apps and things that are available to them on their iPad. And also, Jamie Pisarcik herself said in her statement under oath in 1992, again, which was adopted in her testimony at the previous trial, that, quote, Lyle had asked me to watch a movie called At Close Range. He didn't ask her to watch that scene, he asked her to watch the movie. I think if the prosecution wants to play a portion of the movie under 356, the entire film must be played for the jury. The court says, all right. As far as reference to the BBC book, did you intend to bring that in? Ms. Nahara says, no, Your Honor, we didn't. The court says, and as far as additional spending evidence, did you intend to bring that out? Ms. Nahara says, yes, Your Honor. The court says, and as outlined in the report of Detective Zoeller? Ms. Nahara says yes. The court says, all right, it seems to me that this was referenced to in the people's proffer of additional spending evidence. I don't recall if this was the witness who was to prove it up, but there was reference to purchasing of furniture and things. Ms. Abramson says, that was with respect to my client, Your Honor, but it was supposed to be Perry Berman. Ms. Towery says Perry Berman about the stereo. And the reason the court did not allow it was because it was vague as this is. It was as vague as this is. It is too vague. There was no information about how much anything really cost or exactly when it was purchased and exactly how the transaction happened. So the court had indicated that it wasn't admissible with respect to my client. The court says, was this identified then? Let me back up then and ask whether it was identified in the people's proffer of additional spending evidence. Ms. Nahara says, if I may, Your Honor, the stereo was identified as to Lyle Menendez, and at that time, there was a question whether or not there would be any direct evidence of it, and the court asked the direct question whether or not Jamie Pisarcik was living with Lyle Menendez at the time, and at that time, I didn't have an answer. And so the court said, that was something that the court would need to know to make a determination whether or not there would be somebody who could testify to it directly. So there was some argument, not specifically about the stereo, but the Sony and the TV and all of that. The court says, okay, why don't you find that in the records? Ms. Nahara says, okay, of the transcript, says the court. Ms. Towery says, well, in addition, Your Honor, this information that we have been provided doesn't indicate when these purchases were made, and Ms. Pisarcik stopped living with Lyle Menendez at the Marina City Club in January of 1990. So she lived there from November and December and then moved out. So we don't have a time frame given for any of these purchases the people are now proffering. The court says this is while she was living with him? Correct. She doesn't say that, says Ms. Abramson. The court says that's what the court asked when she was living with the defendant at the Marina City Club. I assume the reference to all of these purchases was during that period of time. Ms. Nahara says that's correct, Your Honor. The court says is that what the testimony would be. Ms. Nahara says that is correct. That is her testimony. We haven't asked her The court says, well, that answers your question. Ms. Towery says, I think it's very hard to prepare for cross-examination of a witness when we don't know where these purchases were made. We don't know what they were. We don't know how much was spent. We don't know how they were paid for. We don't even know if she was present. She may have been told by someone that Lyle bought these things. He may have rented them. The point is, it's very difficult to know. The court says it might be that she was with him when he bought them. Ms. Terry says, well, we don't know that. We don't have any discovery. The court says, do you know how she purchased these items? Was she there when these items were delivered or what? Ms. Nahara says, I'm not sure whether she was there when she bought them, but she was definitely there when they were at the Marina City condo, and her and Lyle and he declared his ownership of them. Ms. Towery says, well, again, this is not in Ms. Nahara's notes of her conversation with Jamie Pisarcik. This is conspicuously absent. So I am assuming that this is Ms. Nahara's recollection of her conversation with Jamie Pisarcik, but we haven't been provided any discovery of any of these recollections. The court says, what I would do is ask this material before it is introduced be identified more specifically as to how she knows those items were purchased rather than leased, that whether she was present when any purchases were made and things of that nature, and description of the items is in more particularity. Ms. Nahara says, okay. The court says that all can be done before she testifies about that in front of the jury. Any other matters that counsel wants to or are capable of discussing now that relate to things that we have to deal with outside the jury's presence? Ms. Nahara says, all right, Your Honor, as to Mr. Heffernan, I had left it downstairs, but the court wanted me to find the reference to the pages. I did find that, and that's something we can do this afternoon. The court says, okay, that's Mr. Heffernan's testimony, regarding a certain conversation that he didn't recall. Ms. Nahara says, that is correct, Your Honor. Ms. Amerson says, can we have the cites, Your Honor? I have to get the transcript from Mr. Gessler's office. Ms. Nahara says, I will have to call counsel. I have the thing looked up and it's downstairs. Court says, okay, if you can provide it so we can have testimony about that this afternoon. And any other matters that counsel are ready on or can be ready this afternoon to litigate. All right, one other thing here. We have an exhibit list that is just, I don't know if the clerk has been doing something in the computer to prepare a separate list. I doubt she has. In the first trial, we had a list prepared by the district attorney that was subject to some negotiation as far as how certain names or items were described. As you can see, we have a sequential list of exhibits without reference to the origin. As far as people versus defense exhibits, just in numerical sequence, and it is of assistance to the jury during deliberations to have such a list available so that they can pick out the items that they want to look at rather than just going through all of the exhibits. So I don't know if the parties are doing anything along those lines now for your own purposes. Are you? Mr. Khan says, yes, I have been maintaining my own list. The court says, okay. What I would request is that if you can maintain a list that could be placed on a separate floppy disk and subject to being given to the defense after you remove whatever things are there that are confidential or your work product that you don't want to disclose, and then if the defense can also assist in preparing a uniform list that would at the end of the trial be given to the jury. Mr. Khan says, okay. Court says, all right, anything else now before we take our break until 1:30? All right, we will be in recess until 1:30. All right, so we come back and there's no jury. The court says the defendants are in court, all counsel and jury is not. What do you want to do first here? Mr. Khan says, well, The first thing we could do is get back to the Pisarcik motion, and we have the tape here to be played for the court of that segment of the movie. The court says, all right, if it's ready to go, we can do that. You want to mark it as an exhibit? Mr. Khan says, yes. We would ask that this be marked as, court says 141. Mr. Khan says 141. Thank you. The exhibit was played. The court says, all right, the video was played. Do you wish to argue the matter further? Mr. Khan says, yes, we would ask that the court allow us to play the tape recording either during the testimony of Jamie Pisarcik if, in fact, she has seen the video and had seen the video at the time of the request. And if not, then we will play it through her or through the investigating officer after she testifies. The court says, all right, anything further from the defense? Ms. Towery says, yes, Your Honor. As the court can see from the clip that the people have sworn the actual clip of the movie is different from how Jamie Pisarcik testified her recollection of the film was, and as to how she testified regarding what Lyle Menendez asked her to testify to in trial again. And the court cuts her off and says, did she testify in the first trial on this subject at all, or was it just done by stipulation or by the reference to the taped interview? Ms. Towery says it was not done by stipulation. I think the stipulation was that she would not be examined, nor would Lyle Menendez be cross-examined about this issue. But yes, she did adopt her previous statement under oath, her previously sworn statement that was given to the district attorney in 1992, and that portion of the statement was the transcript of that portion of the statement and was marked as an exhibit. And I believe what happened in the trial was Lyle Menendez listened to the tape of her statement and said, yes, that's essentially what happened. And then she adopted the written version of the transcript. The court says, that's what I mean. She never described it herself in her testimony. She just referred to what was in some other conversation. Ms. Towery says she adopted previously sworn testimony. That's correct. However, again, there was no deviation from that testimony, and that testimony was given under oath, or that statement was given under oath, and she did adopt it. Court says, do you have that statement? Ms. Towery says, her statement? Yes, I do. I marked it up. I don't have an extra copy of it. The court says, what exhibit is it? Ms. Towery says, it's exhibit 248. Excuse me, it might be 246. I can't read the photocopy. I can tell you in a second. I think it's 248. Yes, it's exhibit 248. Exhibit 227 was the tape itself. The court says, let's see if we can get the exhibit 248 then. The court says, okay, I've read the portion of the transcript. Ms. Towery says, in that portion of the transcript, Your Honor, although it's not perfectly clear, she does indicate that Lyle asked her to say that Jose made a pass at her as in the movie. And then she again reiterates that in Detective Zoeller's October 19th, 1995 report, she says she described the scene as an aggressive come on by Sean Penn's father towards Sean Penn's girlfriend in the movie. Her understanding in the conversation with Lyle Menendez was that he was asking her to testify to an aggressive come on by Sean Penn's father in the movie. Again, she never watched the movie. There's no indication other than her revision of her prior statement that Lyle Menendez watched the movie, and certainly there's no indication that Lyle Menendez had a recollection of the movie different from hers. To the contrary, the inference would be that the discussion related to Jose Menendez making a pass at her. By showing this clip of the film adds nothing to the people's case other than inflaming the jury. There's no benefit this evidence becomes more relevant because it didn't happen. The relevancy is in the request for fabrication, not the specific act requested or the specific statement that she requested to make. The relevancy is in the fact that it didn't happen, and that she will say, showing this clip to the jury is simply designed to inflame the passions of the jury, to somehow inject an R scene into the trial to suggest that Jose Menendez, or to suggest that Lyle Menendez was suggesting that Jose Menendez behaved in this fashion towards Jamie. And in the content of the movie, the reason that the father character assaults the girlfriend of the Sean Penn characters because the father character wants her to stop seeing his son, which is unfortunately parallel to other issues in the case in which other witnesses have and will testify that Jose Menendez, in fact, did not want his son to see Jamie Pisarcik and other women who Lyle Menendez or girls who Lyle Menendez was dating. I guess some of them were women, and even though that aspect of the film had nothing to do with the reality that Jose Menendez offered his son to stop seeing some of the women he was dating, the jury will make that connection. So it has nothing to do with the fact that it's true in this case. So it will throw a taint on the fact as well. It simply adds nothing except prejudicial flavor to the entire incident with Jamie Pisarcik, which is inappropriate and should be excluded under 352. Again, I ask the court, if the court has any inclination to permit this one short scene from the movie to be played in front of the jury, I ask that the court review the entirety of the film and to permit the jury to see the entire film and not just the out of context scene, because that's what Jamie Pisarcik testified that Lyle Menendez asked her to do, was watch the movie, not just that scene, right? So that makes sense that they want them to see the whole movie. Ms. Abramson points out to me that I have failed to indicate to the court that the rest of the movie explains why the father character in the movie behaves as he does towards the son's girlfriend. I've never seen this movie, so I have no idea. Which is the point I was trying to make, that it's taken out of context. If it's going to be played in front of the jury needs to know the context within the confines of the movie because, again, it was the movie that Lyle Menendez asked her to watch. I'll be happy to explain the plot to the court. The court says, no, I don't want to hear that. Let me hear the people's response. First of all, there seems to be a contradiction in Ms. Pisarcik's initial interview with the prosecution and the one that was given to the prosecution in October of the year as to whether she had seen the movie before. Mr. Khan responds saying, yes, we haven't listened to that tape to determine what she was attempting to say in that location, but it's our position that it's not relevant as to whether or not she had seen the movie before. What is relevant is that Lyle Menendez had testified to his father SAing you, and you can base it upon a scene. Lyle Menendez had asked her to testify to my father essaying you. These are like his words. I don't know. And you can base it on a scene that appears in the movie. So it doesn't matter whether she had seen the movie or not. Court says, well, but in the interview with Ms. Pisarcik done by your predecessors, Mr. Kuriyama and Ms. Bazanich, the reference is to, as it reads in the transcript, the defendant asked her to watch a movie, and then somehow in that movie there was a scene where it was clear that the defendant wanted her to say. And then she asked, or she said, I didn't. I had seen the movie before, which is contradictory, and said, I did not go home and watch it. I had not seen it, but in that movie, the father, I guess, dot, 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 dot. So that is speculation because she says she hasn't seen it, but then she also contradicts herself because she says she had seen it. So which is it? Um, kind of, important to differentiate what the answer is. And then she says that the defendant had asked her to do this, say this. First of all, at the point, it's unclear exactly what it is that she was actually presented with, this conversation at the jail, as to what exactly it was that was told to her. That's number one. But in addition to that, and beyond that, there is the question of whether this portion of the movie is relevant to the trial here. The issue is what it was that Lyle Menendez told her, not what's on the movie or in the movie. If all he if all he said was watch the movie and look at the scene in the movie and nothing else, that and she had never had before or since seen it, then we would have one set of circumstances. But if she had seen it at the time, or he explained to her what it was that he wanted her to say, or if she subsequently saw it, then we have a different set of circumstances. At this point, I'm not convinced that there is any probative value to the playing of this tape, or if there is, that my view is that at this point it would be outweighed by its potential for confusion or of issues and bringing extraneous matters that really don't relate to this case. In essence, a plot of a movie that has nothing to do with this, other than the limited relevance of an attempt by Lyle Menendez to fabricate testimony and evidence. So at this point, I'm not convinced that the tape is admissible. That's a good win for the defense so far. So we can't take some further testimony from this we can take some further testimony from this witness, but I'll tell you right now, I'm leaning strongly in favor of not allowing it under any circumstances, from what I've heard so far. Damn. Okay. Mr. Khan says, Ms. Nahara just pointed out to me the latest statement to our office where she clarified it there a bit, and I should read it to the court. The court says, I read it that they had seen it together and watched it beforehand. Mr. Khan says, right. The court says, at some point. I saw that. Mr. Khan says, right. The court says, but is that what she said before? And assuming she had seen it, then why did she say to Mr. Kuriyama and Miss Bizanich that there wasn't an R scene in it? It was just a pass. Clearly, this is a scene that intended to depict a essay, an R word that we can't say on YouTube. And is that what Lyle Menendez was asking her to say? Mr. Khan says, no, it's my understanding that he asked her to testify to an essay by his father and that she would premise it upon a scenario such as that which appeared in the movies, so they say a picture is worth 1,000 words. What he was saying, in fact, is come up with a scenario somewhat similar to this. The court says somewhat similar doesn't mean it's this. Why do we need that versus that he told her to fabricate a story about SA? What does that add to it? You have some actors in a scene and a director told them what to do and a writer told them what to say. But that does not add to her testimony that the defendant said fabricate a story about SA. Mr. Khan says, this shows closer in mind of what his intent was. When he spoke to her about that, obviously he had something in mind. This was what was in his mind. He said, fabricate a situation which is based upon this scenario. So this reflects his statement. He wanted her to use this as a starting point for what happened. So rather than getting up there on the witness stand and saying, well, I understood it to be kind of like this and kind of like this, that's more speculative than the movie because this is what he told her to do, to use this as a starting point. So this is going to be the best evidence of what he intended. The court says no to put before the jury. The court says, I suppose using that analysis, what we could do is ask Miss Pisarcik to sit down and tell us what she would ultimately have come up with. And whatever that would have been what the defendant asked her to do, and that's what she could testify about, what she came up with in her mind as a story. And again, that wouldn't be admissible. It would just be her creation of a scenario. Right. I'm like, why would that be allowed? Mr. Khan says, I agree that would be totally irrelevant because that would be her own speculation. What we have to go back to is what was on Lyle Menendez's mind at the time he conveyed this communication to her, and this is the piece of evidence that essentially he was providing to her. He said, "Use this. It's just as good as if he had handed her this videotape." In fact, that's what he was doing. Well, then you just proved the point that it should be the whole tape and not just that scene. In fact, that's what he was doing. He was saying use this as a starting point and create something. What she would create is totally irrelevant, neither here nor there. This is what he had in his mind, and he wanted something like that before the jury. The court says, all right, well, if you want to pursue it, I'll permit you to have her testify outside the presence of the jury on this subject. As I said, I'm leaning against it. I just don't see how it outweighs the potential prejudice for confusion of issues when the evidence is being offered to show that he solicited her to fabricate evidence and create a story, and that is accomplished. The people accomplished that purpose by her testimony, and you have the defendant's admission that he did this. I don't see at this point that you've met the burden to admit that and evidence. Are we ready to proceed on Heffernan? Are we ready? Are we not? Or are we not? Ms. Nahara says, people are ready to proceed. Ms. Nahara says, sorry, I just read that. Rereading the same line already. Great. All right, so the court says you were going to see me in the transcript, you were going to show me in the transcript what it was that it was offered for. Ms. Nahara says, I did, and I called over lunch and told the defense as well. In volume 229, starting on page 38199, I specifically, starting with line 3, is when I first broached the subject of refreshing this witness's collection on what was prepared with the prepared report. And specifically, I called their attention on page 38199, line 26, quote, calling your attention to this document and specifically calling your attention to paragraph, and I count 1, 2, 3, 4, 4, starting at line 3 and going down to the end. It goes down to 38,200. Quote, would you tell me if this refreshes your memory? And we go into that conversation, which goes over to 38201, where I ask the specific question, quote, does your wife work in an attorney's office? And that is the questioning that preceded the 402 motion. We have a 402 motion, Your Honor. We came back from the 402 motion at page 38207, starting at line 1, and that is where I go into refreshing his recollection. And at line 26, Ms. Abramson points out, quote, excuse me, Your Honor, the witness is saying yes, but shaking his head no. And then the witness said he didn't recall, and that's how we went with the conversation. So then I asked him the foundational questions. Would it have been accurate at the time? Would that have been the best of his knowledge? That goes on to page 38209, line 8. The court says there is also an objection in relation to the wife working in a lawyer's office and some communication with the lawyer. Ms. Abramson says that's right. The court says, as I indicated, I thought we had discussed that in the bench conference, and my recollection was that I said that it could be brought out. The defense recalls otherwise. Mr. Gessler says, I believe you did say it could be brought out. I think that was part of our in-hall conferences. The court says, Ms. Abramson thought on Friday, she said she thought it was not. I'm just saying my recollection what it was. Ms. Abramson says, we didn't have this over the lunch hour, Your Honor. The court says, I'll give you a minute to look at it. There's a brief pause. The court says, what volume again is that? Ms. Nahara says it's volume 229, Your Honor. Court says, could you give me volume 229 from my chambers? Ms. Abramson says, he was probably talking to a clerk or something. Ms. Abramson says, Ms. Nahara, do you have the cite to the description? Or blah, blah, blah. Do you have the cite to the discussion? Ms. Nahara says, when we start discussing it, Ms. Abramson says no to the discussion about the lawyer. Ms. Nahara says, it starts on page 38202, and I believe it starts with line 1. And I believe, Ms. Abramson, you bring it up. Ms. Abramson says, this is the discussion where the court ruled it was admissible. Ms. Nahara says, this was the 402 conference in between. She says, yes, okay, let me read. Then there's a pause, and Ms. Nahara says it starts at 38201, outside the presence of the jury. She says, I see that, thank you, and now she's reading. Ms. Nahara says, and the court's ruling is 38283, lines 18 to 21. Ms. Abramson says, I'm sorry, Your Honor, I'm confused. In this segment that counsel just cited to me, you didn't rule on the admissibility of the attorney's statement at all. You never ruled on that objection. The court was saying you were preventing the prosecution from getting into it unless there's an establishment of refreshed recollection. But there's no ruling on the gravamen of the objection. which is reference to an attorney and a prejudicial effect of that. The court says, well, this statement is by the court. What I would do is if the witness has recollection, I would limit it to Lyle Menendez. That's 38204. And I don't know what the statute of limitations. Ms. Abramson says, we're talking about, I don't either, Judge. The court says, that sounds like a mistype of something. Ms. Abramson says, maybe it was the statute of liberty. Court says it was none of the above. Whatever it was, the reporter got it down as, Ms. Emerson says, maybe it was a statement if limited. I don't want to guess. I think there's two different components for the statement. There's the I want to go back in the house component, and there's the I want to talk to a lawyer component. And I think that it was never segregated out which is which. Moreover, it's not clear, meaning the problem is using the refreshing of recollection or the past recollection recorded procedure for that portion of the statement having to do with wanting a lawyer. I don't know if Mr. Heffernan didn't remember that part. It's the wanting to go back into the house for some purpose part that he was saying he didn't remember. The wife asking the lawyer part that was never made clear that that's what he didn't remember. Mark Heffernan, if you don't recall, is the coach of the brothers. He was kind of a friend of Lyle's. He started coaching them, and yeah, he coached Lyle for a short time, but he continued coaching Erik for a little bit. And he also showed up to the house when the police were called, or he showed up at the police station. I don't know. I think he met them there because the police brought them there. So he met them at the police station the night of the homicides, and I believe he brought them home, or not home, but he took them home to his home and took them in for a night, and but they didn't stay. They like left and went back to the house or something, is what he testified to. But yeah, so that's what they're arguing about his testimony, just in case you're wondering. Mr. Gessler says. Did I read that last part? I think so. Um, Mr. Gessler says, we object to the latter part, even if it's been overruled on the first part about contacting a lawyer to get into the house as being irrelevant and 352. Ms. Nahara says, for the record, Your Honor, I don't believe I know he was shown the portion that had both statements in it. He was then specifically asked, do you recall the conversation? Said yes, but shaking his head no, but then said he didn't recall it. Ms. Abramson says it was a compound conversation, so we didn't pursue which part he didn't recall, and I spoke to the witness before he testified, and we talked about the wife conversation. He remembered that, but I think it's sufficiently ambiguous being shown a paragraph and then being asked what was the conversation. Let me see where he says that. Ms. Nahara says, well, as the court knows, when asked if he remembered the conversation, he stated that he didn't remember the conversation, and I believe all of our understandings were if he did not remember the conversation, I was not to ask what it was that he didn't remember. Ms. Abramson says, well, Ms. Nahara says, I was very clear. Ms. Abramson says, there was at 338-200, he asks, did he tell you something about the house 722 North Elm? The witness said at line 26 that he wanted to go back to the house. Quote, it can't remember exactly what I said in that transcript. He wanted to go back before the police were there to do something. Then Ms. Nahara says, do you recall whether or not he told you why he wanted to go back? And he said, I don't recall that now. No. I'm not sure if he said into it or back to the scene. I can't remember that. And that ends the inquiry. Then Ms. Nahara switches subjects. Did he discuss with, quote, was your wife present when this took place? Answer, I can't remember. I'm not sure. Then he asks, does your wife work in an attorney's office? Answer, she does. And then we stop it there. So there's no indication of if he does or doesn't remember the wife discussion for a lawyer. All we know so far is he has partial failure of recollection about whether Lyle Menendez said he wanted to go into the house or to the house, and that's all that was established, at least up to that point. Now, let's see where we are with the witness again. Ms. Nahara says, I believe at 38-207, his memories once again refreshed as to the whole statement, and he recalls he doesn't remember. Ms. Abramson says, well, he's talking about what happened. He's not talking about a conversation. The court says, all right, getting back to the initial discussion here, there's no way for me to know what it is that he did not remember and what he did and did not remember. You spoke with him. I have no way of knowing that. If you had underlined it in the report as to what specifically he remembered or didn't remember, that's a way of doing it, but it was never done in a way that brought it to my attention. There's no way I can resolve that dispute. But as far as the admissibility of the overall statement, Ms. Abramson outlined first Ms. Nahara's and Ms. Abramson each articulated what it was that the witness said in the report. That's at 38-202. And at 38-206, the court quotes, as far as this question about what Lyle Menendez said, I will have him look at the reports and see if it refreshes his recollection. If it does, then it will be a statement limited only as to Lyle Menendez, period. I was referring to the entirety of the statement. I wasn't limiting it to the portion of it. Apparently, it didn't refresh his recollection, but what portion it didn't, I don't know. What? Ms. Abramson says, right. The court says, but as far as the reference to the lawyer, if there is an objection under Section 352, I don't see that there's any potential prejudice there. This is not a relationship he had with a lawyer, not anything he had other than a statement he made to somebody. Ms. Amerson says, but Judge, the court says, we don't know who Mr. Heffernan's wife was working for. I assume it was anybody involved in the case. Or nobody involved. Sorry, nobody involved in the case. Ms. Abramson says, except we know from Detective Zoeller that lawyer Shaliff showed up the same day. Who did have a prior relationship? So this lawyer Shaliff, who had a prior relationship with people in this case, showed up. The court says, did Mr. Heffernan's wife work for Mr. Shaliff? No. What was that? Well, that's what I'm saying. There's no relationship between the two. He was no intent on getting into the house that he was going to contact a lawyer to help get in the house. That's not getting into an attorney-client relationship or anything privileged. It's just a state of mind. So I don't see there's any valid objection to it being admissible against Lyle Menendez. My only concern is as to whether or not it's been refreshed or whether he did not have a recollection of this. I can only say, again, I have no idea from what was presented to me whether he remembered it or not. Mr. Khan says, he was shown the paragraph that showed the conversation, Your Honor. This is reflected in the transcript. The court says, but did he remember any of it or none of? And Ms. Nahara says, I asked him if he remembered the conversation and he shook his head and said no. And he shook his head no and said, I really don't. And that was, as to the paragraph, it's very clear he didn't. And it was very clear when Ms. Abramson pointed out he's shaking his head no, and the witness stated on page 38-207, line 29, quote, I just don't know exactly what happened. I read it there, and to be honest, I can't remember, but if I said it, I did. If I said I did it, I did it. That's why I'm responding. Ms. Abramson says, and Ms. Nahara says that he read the paragraph and did not remember. Ms. Amerson says there's no excuse for not making the records specific enough. That's a very fuzzy record. Anytime a witness looks at a police report and says, I don't remember everything in there, doesn't mean every statement comes in as past recollection recorded. The court says, we're not talking about every statement. We're talking about a specific statement. And at that time, the prosecution was operating under restrictions that they couldn't bring this matter out if it wasn't recalled by the witness. So they had limited options. One of them, as I said, you could have asked him to underline what it was that they were specifically asking whether he remembered any of that. Ms. Abramson says he could have circled what he did remember or that which he didn't. The court says, I guess we could have done that. There's a brief pause, and then the court continues. All right, as far as the objection by the defense that there is no foundation for past recollection recorded, that there's no indication that the witness does not have a recollection of this based upon the people's representation, that paragraph was shown to the witness and the answer given by the witness at page 38207, line 28, followed up on 38208, lines 1 and 2 and 3. The court finds that there has been sufficient foundation established that he doesn't have a past recollection, and therefore that objection's overruled. There's still the issue of Detective Zoeller's testimony to establish this. So, is he ready to proceed? Is he here? He is not, Your Honor. Not here, Your Honor. Court says, okay, he's not going to be here today or this afternoon. No, Your Honor, says Ms. Nahara. Court says, all right, that was one of the reasons we wanted to take advantage of this time. Ms. Nahara says, I realize that. The court says, at this point, I've made a finding that there has been sufficient showing of lack of present recollection of the part of the witness, and the next step is to take testimony from the person who took his statement. And I also, based upon the rest of the testimony following 38208 and the following pages 38209, there has been, and 38208, like seriously, do we have to keep naming page numbers? There has been sufficient showing of foundation for the fact that the witness made the statement at a time when it was fresh in his mind and the events were fresh in his mind and the information was accurate that he recounted to the police. So we still need Detective Zoeller's testimony. Mr. Gessler says that would still be under the 402 foundation aspects before it goes to the jury. Court says yes, before that. All right. Any other matters that counsel are ready to litigate out of the presence of the jury? Mr. Gessler says, I don't think so, Your Honor. Just to give the court notice, we did inform the district attorneys we are willing to stipulate, and I believe they have accepted it. As to handwriting expert Kuhn, as to the document received by Brian S. Laminia being written by Joseph Lyle Menendez. The court says, all right, and that will be stated in front of the jury. Mr. Gessler says, we will state it in front of the jury, Your Honor. Yes. Court says, that's a stipulation by both defendants. Ms. Abramson says, we don't have to enter it into that stipulation. I don't have first-hand knowledge that my client wrote the letter. The court says, you don't have to stipulate to it, but the people have a right to establish that it's admitted as to both defendants. Ms. Abramson says, we'll agree that he wrote it. The court says, they're asking for a stipulation that the expert would testify that that's the handwriting of Lyle Menendez. Ms. Abramson says, I think they're going farther than that. I don't think they're just stipulating to the fact that the expert would testify it's his handwriting. I think they're willing to stipulate that he wrote it. That's why you don't need me there or my client. The court says it still requires your agreement. She says, we agree he wrote it. The court says, all right. There's one other thing, says Ms. Nahara. I had spoken to all counsel for the defense a while back, and it was agreed that with regards to Ms. Maher, Ms. Abramson says, Ms. Nahara continues, that counsel agree to stipulate that the American Express report account was that of Jose Menendez, and I talked to everybody about that, and everyone agreed that we have that stipulation. Mr. Gessler says that's true. Ms. Abramson says, in exchange for that, can we have a stipulation on the one for best products for the rifle, since the serial number is on the receipt? Ms. Nahara says, I believe we talked about that. Yeah. Ms. Towery says, as long as we're talking about stipulations, I had asked the prosecutors if they would stipulate that Perry Berman never testified in response to questions about the content of his conversation with Lyle Menendez on the afternoon of August 20th. That is, the conversation at 4 or 5 o'clock in the afternoon, that he had never testified prior to the court's inquiry at the end of his testimony, that Lyle Menendez told him that he had been at the Beverly Hills shopping center. And the prosecution at the time was unwilling to so stipulate, and we did not excuse the witness so that, if necessary, we could have him review his testimony in front of the grand jury, review his testimony at the previous trial, and come back and testify that he never so stated. And the court, I think, at that time indicated that counsel should discuss it. So far, we have still been unable to reach an agreement among counsel. The last time I asked, I think I told Mr. Khan that that question was never asked, and I think it's self-evident that that question was never asked because it's impossible to be specific about what was discussed in the conversation until the witness tells you what was discussed in the conversation. You could spend the rest of your life asking if this was discussed in that conversation. So, the specific question: did Lyle Menendez tell you that he had been at the Beverly Hills shopping center? Was never asked. However, the witness testified about that conversation on two occasions. He also gave several statements to the police about the conversation and never mentioned the aspect of the conversation until his testimony before the jury in this trial. So I would ask, if we're unable to reach a stipulation on that point, I would ask that the court take judicial notice that he never before testified to the part of the conversation that Lyle Menendez in his prior recorded testimony. I think all the court can do is take judicial notice of the record of the fact that the witness testified about the content of that conversation on two separate occasions and never mentioned the portion of the conversation until this trial. Ms. Teresa continues after a brief conference with Ms. Abramson. She says, I should say that he never mentioned those things having been said, as opposed to saying he never mentioned that portion. The court says, let's not have these little conversations. You can talk, or you can have little strings like a puppet, whatever you want to do or how you want to do it. What? What is the court saying? Ms. Amerson says, I just wanted to be accurate and not give the jury the mistaken impression that we all agree there was such a portion of the conversation that he merely overlooked saying it. He was asked what was said, and he never offered the information that he testified to. Ms. Towery says, and I think she's correct. The semantics such that the way framed it would imply that there was that portion of the conversation. He just didn't mention it, as opposed to him never having recounted that as the conversation that he had between himself and Lyle Menendez. In any event, it's an issue. He's out there and we might have to bring him back. The court says, okay. Well, let me hear the people's position. Mr. Khan says, I have no problem with the court taking judicial notice of one portion of the transcript as long as the court gives it to the jury in such a way that it makes it clear that we want the jury to understand that he was never specifically directed to the specific issue before, and that I think that is significant. Perhaps what counsel should do is go through the transcripts of Mr. Brennan and find the location where he was asked the questions that they feel would have elicited the response which they are saying that he failed to come forth with. Until we have that, I don't think that the court is in a position to take judicial notice of the statement. Like, what? You can't even take judicial notice of the statement, even though, I don't know. I think he should be able to, but okay. The court says, was he ever asked in the trial any questions other than what was said before the grand jury or in trial? Did anybody say to the witness or ask the witness, well, what did Lyle Menendez say on the telephone? And was that all he had to say? Were those types of questions asked? Was that all that he said to you on the phone? Ms. Towery says, I'd have to go look and see if there was a follow-up closure question, such as the court suggests. I don't know the answer to that. I can tell the court that he was not asked, did you discuss whether or not Lyle Menendez had been to the Beverly Hills Center? He also wasn't asked, did you discuss what Lyle Menendez had for lunch? Did you discuss what you were both wearing that day? The court says yes, but the issue only had any relevance or significance, let's put it that way, significance, after the defense presented the case in the first trial. The prosecution most likely wouldn't have had any reason to focus on what Lyle Menendez told Perry Berman about his activities that day, where he went, whether or not his father was truthful in what the father said Lyle Menendez was doing that day. None of that had anything of any significance to do to the prosecutor or the police or the time that he was initially interviewed or at the time that he was initially examined before the grand jury or in the people's case in chief. It would have had significance for the defense in cross-examination of Mr. Berman. But until the defense put on its case and the defense made such a point of the fact that the father lied to Mr. Berman about where it was that the defendants were that day, did it become significant in any fashion whatsoever as far as the prosecution or the police were concerned. So whether or not that question was asked, I don't know. Ms. Towery says, well, that may explain the failure to ask that specific question, or questions along those lines by the prosecution. It still doesn't explain the failure of the witness to testify about that as part of the conversation. The court says, that's all appropriate impeachment. It's a question of whether he was ever asked the question. I know this was an area that was followed up by the defense in this trial during recross examination. After I asked the question just to see what his responses were to whether he'd ever said it before. It's my recollection that he didn't remember one way or another whether he had said it before. He sort of went back and forth on that. I think perhaps you ought to look at the record and see what questions were actually asked of him as to whether or not this was really pinned down, either during interviews or during his testimony. My feeling is that probably, at least in the people's questioning, it wasn't. Whether the defense asked it, I don't know. I don't have a recollection of it. So before I go further, I think you have to perhaps look at the record a little more carefully. Ms. Towery says, we'll do that. The court says, are there any other issues that we can discuss? Ms. Nahara says, Your Honor, yes, before the break we were discussing the issue of Ms. Pisarcik and some spending which had been discussed previously. Court says yes. Ms. Nahara continues, and the court earlier today said there were several questions that the court would need answers to before the court would feel very comfortable with whether or not with ruling on this. Previously, I did find the part that I was thinking about earlier when we were discussing that with Ms. Pisarcik. That was in volume 185, and it starts around page 29514. And basically, at that time on that page, um, starting at line 25, basically the court stated the same thing the court stated earlier, which was there was certain questions that needed to be answered, and until or unless such time as they were answered, the court would at this time rule it inadmissible until the court got an answer of those questions. Basically, they're the same questions the court had asked earlier, and I'm trying to elicit the answer to those questions, and if I get them this morning, I will give them to counsel or first thing in the morning. Ms. Towery says, which part? Ms. Nahara says, the spending. Ms. Towery says, okay. Court says, this was in an earlier hearing related to Ms. Pisarcik. Ms. Nahara says, correct, not relating to spending, and Ms. Pisarcik came up in that along with Mr. Berman. Court says, during that discussion, her name was mentioned. It wasn't just more recently, but during that time? Ms. Nahara says, yes, it was, Your Honor, and at that time the court, and I didn't realize that, and the court stated that the same thing the court has stated today, and that's what we need answered if we want to offer this evidence. Ms. Towery says, the problem is, Your Honor, she's scheduled to testify this week, and we still haven't been provided with the information that we asked for months ago, and I don't have the ability to investigate whatever she tells the prosecution now in response to those inquiries to see if it's true. We know that something, or sometimes Miss Pisarcik says things that don't turn out to be true, and certainly it would be prudent for defense counsel to investigate purchases that she claims that Lyle Menendez made, what those purchases were, how much they cost. I think we need to be able to look into that and to determine whether or not it's true. So, at this late date, we can't possibly conduct that kind of investigation. The court says, let's first see what it is that she knows and how she knows before we go further. Anything else? Mr. Khan says, there is one additional thing concerning the diagrams that we had prepared illustrating the wounds to the bodies of Kitty and Jose Menendez. We provided counsel. It's been 10 days now. We've provided them with the illustrations, and they were objecting to them. And we need to resolve this before the pathologist testifies on Monday. If there's an objection, I would like the court to rule on that. Ms. Abramson says, I don't know what the pathologist has to do with the diagrams. They're not the pathologist's diagrams. Oh, you mean those other ones. I understand. Court says, the ones that were shown to you. Ms. Abramson says, I don't have them with me, but I'll be happy to deal with that tomorrow. I have to compare them to Dr. McCarthy's diagrams and to Dr. Golden's diagrams, and that's what's been taking a little while. I'll be happy to deal with all of that tomorrow. I don't have all 3 sets with me. Court says, as I say, what I want to do is have this time without the jury to take care. Miss Abramson says, I didn't know the juror was going to be sick when I left the house this morning. Or I might have brought it with me if he had told me. I thought we were going to deal with these matters after we run out of witnesses this week. But I'll be happy to deal with it tomorrow if counsel needs to. The court says, if we do have a full complement of jurors and witnesses, I really don't want to interfere with that unless it can be done very quickly. I don't want to take more than 5 or 10 minutes here that will take us away from testimony in front of the jury. Ms. Amerson says, I think a great deal with respect to the pathologist has to do with whether or not he's going to be able to offer any opinions on an autopsy that was not any part of, nor from any office that he was never worked for, in order to lay the proper foundation. He's doing diagrams based on the coroner's report, and we haven't gotten to the point yet to where that's at. The court says the people filed something today. Ms. Amerson says, I know, but I don't think it answered the problem. Court says, I didn't expect you to do it today, but I would expect by tomorrow that you will have reviewed it and prepared to tell me when you will be able to respond to it. And it just cites basically 3 or 4 cases that are familiar, all of the cases we talked about last time that we discussed it, where a different medical examiner from the same office takes the witness stand and can authenticate the procedures, et cetera, which is not the case here. Doesn't need any research. There's no case to support bringing in an outside pathologist to testify to the results of a county coroner's office. All right. Any other issues? Anything we can deal with that we can take up at this time and finish now that we don't have to interrupt the jury. Ms. Abramson says, can we just deal with an ex parte matter dealing with access to our client, which is between little and nil at this moment? The court says, okay, anything else? All right, let's do that. We'll be in recess until tomorrow at 8:30, and we'll deal with this ex parte matter. Ms. Nahir said, I missed that. Ex parte. The court says, something to do with the jail. Ms. Nahir says, okay. Ms. Towery says, could we inquire of the prosecution as to who their ex parte, just by the way, means one party. So it means Leslie Abramson's going to go up and talk to the judge without the prosecution next to her. And she can do that because it isn't about the case necessarily. It's about contact with her client in the prison. So that's why it's allowed, in case you were wondering what that little exchange was. Ms. Towery says, can we inquire of the prosecution as to who they're calling tomorrow so we know again what notebooks to bring? The court says, well, we had Mr. Stevens here. Ms. Nahir says, right. The court says, who else? So we have Glenn Stevens and Detective Zoeller. We have to finish Detective Zoeller, says Ms. Nahara, and then a stipulation, Mr. Stevens and Ms. Pisarcik. See how far we get. Ms. Pisarcik's going to be on the stand for a while. So will Glenn Stevens, but we're going to try to get through as much as we can of Glenn Stevens' testimony today. We're going to finish Detective Zoeller for sure, and then we're going to try to get through as much of Glenn Stevens' testimony as possible. All right, so he says, sorry, Ms. Tari says, so I assume we'll get that information about the spending sometime today so we can be able to prepare to litigate that. Ms. Nahara says, yes, I'm having somebody make a phone call right now. The court says, we'll be in recess and we'll resume ex parte with the defense. And that part we don't have on the transcript. That's not on the transcript. That's fine. All right, so that ends October 30th, if we're following along with the Menendez case. So we've completed October 30th, which was the end of week 3. We are now starting week 4, which is where Detective Zoeller is going to be back on the stand. Let's actually, I'm not on page 1. Hold on. Let's get to page 1, and there we go. All right, so beginning of October 31st, it is Halloween of 1995. The following proceedings were held in court outside the presence of the jury. The court says the jury is not here, the defendants and lawyers are here. Is there something counsel wanted to discuss before? Ms. Abramson says, 3.5 minutes ago, I was handed a police report written by Detective Zoeller. 3.5 minutes ago. I'm going to highlight that because the prosecution has a pattern of handing over discovery the day someone's going to be testifying, and this is another example of that. So 3.5 minutes ago, I was handed a police report written by Detective Zoeller concerning interviews that he had on October 26th and October 30th, so just days prior, with 2 women who were real estate salespersons for the development in New Jersey, where we've heard evidence that Lyle Menendez attempted to purchase a patio home, a condominium, and where he closed the deal on the condominium that his parents had begun to purchase for him before their homicides. Now, Detective Zoeller, 10 minutes ago, showed me his copy of this report. Just to make sure this record is perfectly clear, I've had 10 minutes discovery of this. This report is full of information I have never heard before. What? Wow. Talk about trial by ambush. This whole trial has been trial by ambush. If you haven't noticed, the way that they are, oh, we're not going to do that, and then they do that, or trying to, ambush them with discovery that they've never received before. Over and over again, this keeps happening. And ambushing them with different witnesses every day, and they're so that the defense attorneys aren't prepared because they don't know what defense, or they don't know what witnesses to prepare for ahead of time because it keeps changing. So this is crazy, and it's ridiculous that this is allowed. She says there was a claim. My client was not only present for some of these negotiations and discussions, but that there are statements by my client and by Lyle Menendez indicating that my client was supposedly going to be the owner or occupant of one of these units. There's all kinds of statements attributed to Lyle Menendez having to do with my client. This is the kind of discovery that should have been proffered at least 3 years ago. Why is this coming up now? There's already been a trial. There shouldn't be new discovery unless something came out between the last trial and this trial. There shouldn't be new discovery from the investigation. But yet here we are. And Nathan Hawkman wants you to believe that the brothers got a fair trial the second time around. Just FYI. But at least a year ago for this team, sorry, let me back up. So this is the kind of discovery that should have been proffered at least 3 years ago, but at least a year ago for this team, and we are objecting to these witnesses being called at all. There is no way that we can, in the middle of this trial, investigate this new information and recreate my client's whereabouts. We need to litigate each and every statement that's attributable to either of the two defendants. And I just think it's incredible in a 5-year-old case that we can get this kind of discovery while the witness is on the airplane. Ms. Towery says, there's more. Ms. Abramson says, and the reason I bring it up now, let me just indicate why I'm bringing it up now, because I had no intention and was not prepared to do anything with Glenn Stevens, who's a witness solely against Lyle Menendez based on all the proffers and pretrial rulings. But I understood that he had some information about these real estate shopping trips. And at this point, I may want to ask him some questions if this other evidence is going to be admissible. So that's why I brought it up now. Mr. Gessler says there are additional objections based on the discovery that has so far been given us as to Lyle Menendez, what's called at this point the patio home, the condo. I believe further discovery will be coming on Thursday or Friday when that witness comes into town. But as to the patio home, the person called, although on some initial, in other words, the showing of it and some of the negotiation, I do not believe, from what I've seen, from what I've been told so far, has sufficient knowledge as to whether the transaction went through, why it did or did not. All she apparently knows is that he entered into the transaction, and perhaps she knows that he put down a down payment. So I'm not sure that she has sufficient knowledge, personal knowledge, to testify to relevant material as to the purchase or attempted purchase. The court says, all right, just let me get a little background here. As I understand it, there are two witnesses here now to testify about the purchase of homes. Ms. Abramson says they're en route earlier today or tomorrow or the next day. The court says they haven't arrived yet. Ms. Nahara says, Your Honor, there is one witness present as to the purchase of the patio home. There is a second witness en route who should be here, I believe Thursday, with regard to the purchase of the townhouse. Ms. Abramson says, now there are two townhouses, Ms. Nahara. Would you tell the court what you mean, just so the record is clear? The court says, the witness who's here is someone who has interviewed Wynn on October 26th, on October the 30th. Which one? Ms. Nahara says, Your Honor, the woman who's present here, Ms. Abramson interrupts and says, I'm asking that the witness step out while we're having this discussion. Court says we're not getting into the substance. Ms. Nahara says, for the record, Detective Zoeller informs me he interviewed this witness on October 26, 1995. So the record is clear about this. My understanding is that when he wrote the report yesterday, he called Mr. Gessler and gave him this information. I did not receive this information until this morning, so actually this is discovery that the defense had before we did. Court says, well, the police were in possession of it at least on October 26th. Is that right? Ms. Nahara says, that's correct, Your Honor. Court says she was re-interviewed yesterday. Is that right? Ms. Abramson says, no, that's the other witness. The court says she was interviewed by phone. The other witness? Ms. Nahara says, yes, Your Honor. The court says, and this witness was also interviewed by phone before she came in, and she was interviewed on October the 26th. Ms. Abramson says she was re-interviewed this morning, apparently in person, and added another statement by one or both of the defendants to the report that deals with her prior statements. The court says, okay, yes. Mr. Gessler says, I received a phone call at approximately 5 yesterday afternoon. I think after Ms. Abramson had left the office, it had been my impression from talking to Detective Zoeller that both interviews had just been completed and he was typing them up rather than it was October 26th on the patio home. And the idea of Erik being involved was first told to me at about 5 yesterday afternoon, as was the interview with, I believe, this Bunny Sugarman. I believe that's the witness who's here today. That's the first I had knowledge of this at all. Wow. This is wacko. Wacko. Like, what is this investigator doing still investigating this case. There's a second trial and you are still on the witness stand and you're going and you're getting more testimony against them or getting more evidence against them, supposedly. Ms. Abramson says, I didn't get a call last night. I'm not as popular. The court says, let's start with the fact that the interview was conducted on October 26th. Why did it wait until today for it to be turned over? Ms. Nahara says, Your Honor, the report was not completed until today. It was completed last night, and I did not know about the information until this morning. The court says, well, you knew that the witness was coming in, and you knew she was being interviewed before she came in. Yeah, exactly. Ms. Nahara says, Your Honor, I'm informed by Detective Zoeller that the reason he had not turned over this information is he was informed by Ms. Towery that the defense wanted the reports on both of these individuals that were involved in the sales of the home, Bunny Sugarman and Luann McHugh, basically together, and he had been unable to get a hold of Luann McHugh until last night. This was his understanding, and that is why he waited until he had both interviews done and a single report generated on both of them before he gave it to me and gave it to the defense. Ms. Towery says, if I can just respond to that, Your Honor. Court says, wait 1 second. There's a brief pause. Ms. Nahara, okay, so Ms. Towery wants to respond. She's not allowed. Then there's a pause and Ms. Nahara just takes over. I'm not on camera, but I just rolled my eyes real big. Detective Zoeller also informs me, says Ms. Nahara, that he had spoken to them and then asked when he could have the report, and he told them Tuesday morning. That Ms. Towery told him they had discussed it. They, I assume meaning the defense, I don't really know, and that Tuesday was fine. Ms. Abramson says, I'd never heard of this. Ms. Towery says, I have no earthly idea what Ms. Nahara is talking about. I just want to highlight that because that's a funny sentence. I've never had a conversation with Detective Zoeller about any of these people. I didn't even know what their names were until yesterday afternoon, just before he talked to Mr. Gessler. I talked to him about additional discovery about Ms. Pisarcik. I asked Ms. Nahara to have Detective Zoeller call me directly because she didn't know anything about Detective Zoeller, but about his conversation with Ms. Pisarcik. Detective Zoeller then called me. I spoke with him. He mentioned that he was working on additional discovery about these patio homes or townhomes, and I said, you need to talk to Mr. Gessler about that because he's handling those witnesses. Mr. Gessler was on the other line. I took down Detective Zoeller's number, and Mr. Gessler called him back. That's it. I don't know what you're talking about. I've never had any such conversations with Detective Zoeller until yesterday afternoon. Ms. Aronson says, certainly nobody ever told me starting on October 26th or any other date that somehow now this evidence involves my client that could have been done verbally. I talk to Detective Zoeller every day. He never said one word about it. And so this morning is the first I've heard of this evidence and that they're seeking to use against my client. Moreover, the court interrupts her and says, I assume Detective Zoeller had some handwritten notes last week. Is that right? Ms. Nahara says, I don't know, Your Honor. Ms. Nahara says, Your Honor, I've just spoken to Detective Zoeller, and he reminds me that when we were in court, he had some notes from the first conversation on October 26th. We were all present in court at that time, and at that time, Ms. Towery in court said, when can you have the report? And he said, Tuesday, and that's what he did. The court says, I didn't say anything. Court says she's laughing about it now, but he took this as meaning what it meant. Ms. Towery says, the reason I'm laughing, Your Honor, is that I do recall that it was a cross counsel table. I recall it being directed toward Ms. Nahara, and she had indicated that she would be calling additional witnesses this week with respect to the patio home. I was just trying to make a list of witnesses, and I said, when will you have the report? And they said, whatever day. I had no idea they had notes. I had no discussion about the information that they had at that time. Court says, my question is, or was, whether or not Detective Zoeller had notes. Ms. Nahara says, he had notes, Your Honor. The court says he still had those notes, and those notes were prepared on October 26th. Is that right? Ms. Nahara says, that's correct, Your Honor. Court says, and all that needed to be done would have been to have turned them over to the defense on October 26th. That's one option, said Ms. Nahara. It would have been a very difficult thing to do, would it? Says the court. Ms. Nahara says, it would not. The only problem was there was a miscommunication. Detective Zoeller thought they wanted the report because they complained about his notes in the past. The court says, has it ever been the case when he had notes and later prepared a report that the lawyers didn't also look into the notes? Ms. Nahara says, I could be wrong. I don't know. I believe there have been instances that they haven't cared for the notes, but I could be wrong. Court says, have you seen the testimony in the last few days in court? Ms. Nahara says, yes, I have. Are you paying attention? The court says, did it give you the idea the lawyers might want to have the notes? Ms. Nahara says, I agree with you. The court says, I assume Detective Zoeller even got that idea after listening to and being questioned by the lawyers that perhaps the lawyers for the defense would like the notes, even though a report would later be prepared. I'm operating in the dark here because I don't know what the contents of the reports, what their contents are. I don't have a feel or how it would impact upon the testimony of Mr. Stevens. Ms. Abramson says, I just handed the clerk, Your Honor, my only copy, so just so you can see it. The court says, my initial response is, as far as Mr. Stevens, that is, there is new material that the defense needs time to investigate. That doesn't have to be introduced. That he could be subject to being recalled so that if there is something that the defense needed to explore with him relating to this particular information, he could be recalled for that. My concern is that at this point is to deal with the fact that we have the jury in the jury room. We had a witness on the witness stand who's still being cross-examined. We have Stevens here. I assume there are other witnesses here other than this particular witness dealing with the purchase of this condominium. We can discuss it further later. Counsel can digest the information more and still not abandon the opportunity to question Mr. Stevens at some point that if time at some point later if it's significant at some time later if it's significant. Blah. Can't get those words out. Ms. Amerson says the problem is Mr. Stevens has never been willing to be interviewed by the defense, so I don't know what he's going to say. Court says, I'm not saying question him now. Ms. Amerson says, I think it might be useful for us before he leaves to be able to ask him about this. I don't know if the people based on this information are going to try to elicit any information from Mr. Stevens that we haven't been given discovery or since we are never able to talk to him. That's another aspect of my concern, whether they're not now going to do a circle and bootstrap this stuff into some statements by Mr. Stevens. We should have an ample opportunity to deal with this if they are. Ms. Towery says there's also additional discovery that has not yet been disclosed in any way except by Ms. Nahara to me just before the court convened this morning with respect to Jamie. Oh my God. So now there's more discovery for Jamie that we just got this new discovery for Lyle and Erik from Detective Zoeller. Like, this is wild. This should not be happening in the middle of trial. And I was going to say something else, and now I lost my train of thought for a second here. Oh, the fact that Glenn Stevens refuses to speak to and cooperate with the defense just goes to show you, like, he was a friend of the brothers, and now it shows you that he seems very biased and one-sided, that he's only going to be speaking for he's only going to speak to the prosecution. He's only going to prepare for trial with the prosecution. He's only going to give his information that he has to the prosecution. So it's very telling that he doesn't want to cooperate with the defense. And here he is, testifying against people that, he did once consider his friends. So it's crazy how people just will turn on you in a flash. And who knows what was in it for these people. Fame, something they got out of it from the prosecution's office or the law enforcement that were involved. I don't know. And I'm not insinuating that all of them got something out of it. It might have just been like they got their 5 minutes of fame on the stand, and even if it was, against the brothers, it was an opportunity for them to, be famous or something. I have no idea, but it's just odd. A lot of their close friends, or, I say friends with air quotes because especially in the rich life, like you don't know who your real friends are. So I say that lightly. They're friends. You don't really know who your friends are. Ms. Towery continues, saying, Ms. Nahara indicated to me that the prosecution was withdrawing their request to present spending evidence here in California by Lyle Menendez, but now apparently intends to elicit testimony regarding Lyle Menendez's activities in New Jersey, about which we have never received any discovery. And again, we have a situation where Ms. Pisarcik is a witness who has steadfastly refused to be interviewed, again, not cooperating with the defense or even have any contact with the defense, whoever in this case whatsoever. So again, Jamie Pisarcik and Glenn Stevens, it's very telling. And also, what's his face, Perry Berman, all of the people that were friends with the Menendez brothers, they've turned on them. Ms. Nahara indicated that Ms. Pisarcik would be testifying about Lyle Menendez's purchasing of some kind of items, I don't know what, in New Jersey, and also going with him to look at one of those homes. I don't know which one. So that also may tie into whatever this discovery is with respect to the patio home or the townhouse. And again, we have no discovery whatsoever with respect to any of these activities during which time Ms. Pisarcik accompanied Lyle Menendez. The court says, well, obviously, if there's any testimony to be elicited from Ms. Pisarcik on this subject, disclosed to the prosecution in interviews with her, then the prosecution will have to disclose that to the defense. Ms. Towery says they haven't done so. Court says before any such reference is made in testimony, it will have to be turned over. Ms. Amerson says when? The court says if not turned over in a timely fashion, it won't be something that she can testify about. Ms. Amerson says, our position is we're way beyond timely here, Judge. We were way behind any conception under the statute of logic or timeline for any of this evidence. Like, no kidding. Trial's in session. How are we allowing new discovery in of this nature? The court says the statute doesn't talk about a situation in which a witness is interviewed and information is obtained from the witness that was not known to the party before. Ms. Amerson says, but Judge, court says, let me finish. The discovery cutoff date of the witnesses, witnesses called by either side can be further interviewed and more information developed. So the discovery statutes don't deal with this situation per se. Ms. Amerson says, but court says, other than the extent that it works an unfairness on the opposing side when material is developed at the last minute, or if there are indications that there is legitimate delay by the proponent of the information designed to obtain strategic or tactical advantages. Ms. Amerson says the thing is, none of these issues or areas are new. They have known about them for all the time that this case has been under investigation and preparation for trial. And when we're talking about witnesses like Ms. Pisarcik, to whom the defense never has access, who they can call and do call and interview and re-interview, there has to be a point at which if they were interested in this area, they should have asked the question at a time when it was timely, when the defense would have been in a position to investigate it. She's not wrong. Like, they can't just in the middle of trial decide they're going to change tactics and be like, well, we're going to ask her some more questions and now the defense has to deal with it. That's not how it should be. You should have already completed your interviews with her before trial began. Whatever number of days we were to be given now between the revelation and new information and the presentation We are in court every day. We cannot adequately prepare and investigate a case when we're here all the time. As you know, we even have difficulty accessing our clients to discuss new information with them. It's not appropriate to first present your client with new information at the counsel table in the trial court while you're in trial. These reports having to do with one of these two real estate witnesses implicates other people who we now have to go talk to and interview about these issues. So it's just at some point, I think the prosecution, knowing this is an issue, the prosecution, knowing such witnesses do exist or dealing with witnesses they have interviewed numerous times, have to be held to a standard of reasonableness under a due process concept. We think in the middle of trial, within days of wanting to present these witnesses, it is just too late. The court says, all right, well, let me hear from you, Mr. Gessler. Mr. Gessler says, I have additional problems, Your Honor, in that my understanding Glenn Stevens will be a witness today. I am prepared to cross-examine Glenn Stevens based on statements he had previously made and testimony from the last trial, some of which was elicited by the people and went into the patio home in either the townhouse or condominium, depending on the description that is used. Given this new information, I'm not prepared to cross-examine on that topic until I check out the new information from Jamie Pisarcik and from the real estate agent, whom we also have not had a chance to talk to because we just arrived in the court a few minutes ago. I hate to bring Mr. Stevens back, but I see no alternative. I can't see that the people should be allowed to ask him about those real estate transactions in any form until we have had a chance to investigate all of the new information which has just been given to us, which ties into the subject for potential cross-examination. Similarly, I don't see how Ms. Towery can cross-examine Jamie Pisarcik on any of these topics until we know what each of these witnesses has to say about it, particularly the real estate lady who's the new person newly sprung on us and who impacts on cross-examination of two other witnesses that the people are intending to present today. Court says, okay, let me hear the people's response to all that. Ms. Nahira says, thank you, Your Honor. First, with regards to the new witness, my understanding, Your Honor, in the first trial is all of this information that we're getting from the witness, the reason we originally called her was stipulated to in the first trial, which was to establish the documents that were put in evidence in the first trial were true and correct copies and that the defendant, Lyle Menendez, attempted to purchase a patio home and a townhouse for cash. In the new trial, my understanding was that there wasn't supposed to be any stipulations, and we had hoped early on in the trial, if I may, that Mr. Baralt could testify to all of this. Mr. Baralt was also one of the most forthcoming of witnesses. We didn't really have much of an opportunity to interview him. When we finally found out he could not do with these documents what we had hoped, there was, quite frankly, a mad dash to find the individuals involved in these sales so we could bring in all of the records we had tried to bring in for Mr. Baralt. And counsel for the defense quite rightly objected to, and the court quite rightly sustained those objections. When we found out that those individuals who were involved in the purchase of these homes, first we found the names and immediately gave these names to counsel for the defense. With regards to Mrs. Sugarman, counsel is stating that there was, for some reason, this revelation that came to them in the court or in the report. Your Honor, the only thing that came into the report, I believe, quite frankly, counsel for the defense is overstating the issue, what it says. Ms. Abramson says, I don't want to have, and Ms. Nahara cuts her off and says, if I may, Your Honor, I believe I have the floor. Ms. Abramson says, excuse me, counsel, I just want the witness excused if you're going to get into the details. The court says, let's have the witness wait out in the hallway. All right, you may continue. Ms. Nahara says, thank you, Your Honor. With regards to the witness that we are referring to, Ms. Sugarman, my understanding is that there's a line in her report, which I just saw this morning, which stated that it was her understanding that from what was said in her presence and what Lyle Menendez said, that the patio home was for him and the condo was to be for Erik. That's the whole extent of what we have here. I don't quite see how that impacts on Glenn Stevens, except perhaps to ask him one question, which is, when you went to look at these things, was Erik there or not? That's the whole impact on Glenn Stevens. They say they need days to investigate. It's one question. The court says, what is the answer to the question? Ms. Nahir says, I don't know. I have to ask him that. The reason is I just spoke to this woman in court and found out what the discussion was and wanted to tell everybody. I haven't had a chance. There was a statement that she heard the conversation between Lyle and Erik Menendez, and for the record, Your Honor, I just found this out. I don't believe that Detective Zoeller knew this, and basically, what she said was that she heard Lyle talking to Erik and saying that they wanted the patio home was for him and that for Erik, they were thinking about purchasing two condos, maybe a breakthrough to make a suite, knocking down the wall and making a breakthrough to make a suite. And they discussed that in her presence, and that is the whole statement. That's all she would say. Her response was she did not recall any response from Erik Menendez, and that I just learned this morning, had we not flown her out here, we wouldn't have known that. Once again, they discuss the impact this has on the testimony of Jamie Pisarcik and Glenn Stevens for purposes of cross-examination. Once again, what this all boils down to, Your Honor, is the question of when they went to look at these places with Lyle Menendez, which is already on the record. The issue is, was Erik there or wasn't he? And we can get to the bottom of that very quickly. I believe we have Mr. Stevens here. We can ask him so with regards to that. I don't know why counsel would need to investigate that or what they could investigate, quite frankly. And that is how this new evidence impacts on these two witnesses, where they are sitting here and telling the court that it would take they need to digest it and study it and learn more about it to investigate it. That is the full impact of it, Your Honor. And with regards to the information that we found out, once again, I just found out that this morning, and this was information, as the court knows, because the court has been asking us all, along with witnesses we're calling. These were witnesses we had hoped never to need to call. There was an original plan on getting these items into evidence. When that plan failed, we moved to a backup plan. The backup plan failed, and this was a third plan. So I don't know why counsel would be going on and on about this, all something that we should have looked at years ago. They saw the genesis of this just as simply and easily as we did, and the court, I'm sure, did. With regards to Ms. Pisarcik, if I can change gears, with regards to Ms. Pisarcik, I have spoken to her. We get new information each and every time we speak to her with regards to, Your Honor, would you ask counsel? The court says, I'm listening to you, just talk. Ms. Nahir says, thank you. With regards to Ms. Pisarcik, my understanding, what I intend to elicit with regards to spending is with Mr. Winskowski, the bodyguard, Lyle's bodyguard specifically. He stated that Ms. Pisarcik was present when they went shopping. And Ms. Pisarcik tells me that she went shopping with Lyle Menendez in New Jersey and New York. Now, as to the specifics of what was bought, she does not know. And that's what we would be eliciting from her, and we'd be asking the court's permission to do that. That's it. He purchased. Ms. Abramson says, where did they go? Ralph's? Ms. Nahira says, various accessories and things like that, which also corroborates what Mr. Winskowski said. Court says, okay, as far as the lady you have here from Jersey, did you tell her? I'm sorry, did she tell you? And did she tell first of all? Did you tell Detective Zoeller that Erik Menendez was present when Lyle Menendez spoke with her about purchasing the unit? Yes, that's in the report. So that was known last week? Correct. And she didn't tell Detective Zoeller the details of the conversation Lyle Menendez had? My understanding is no, Your Honor. I elicited them this morning. Ms. Abramson says, there's another conversation that she did tell Detective Zoeller. I gave you my copies. The court says, what is it? Ms. Abramson says, one of them is a corrected copy by Detective Zoeller where she was told, and it's not clear by whom, that they were paying cash and the money was coming from a large inheritance they had following the deaths of their parents. Do you have that in front of you? Court says, I do, but I haven't read it yet. Ms. Abramson says that's the handwritten part on the top page. That's the correction page for the second page. She apparently told that to Detective Zoeller yesterday. I just want to indicate, just to try to straighten this record out, that since no one ever told me my client was in any way involved in any of this, I have not been a direct participant in the discussions about how they were going to prove this. I am unaware, however, since we've had some discussions about stipulations of any refusal on the part of my co-defendant to stipulate to the real estate documents. Beyond that, when Ms. Nahara tells this court they haven't had much of an opportunity to interview Mr. Baralt, Detective Zoeller picked the Baralts up at the airport. Well, that's interesting. I met them at the hotel where they were staying. The prosecutors weren't there to interview them. They could have been. I was there to talk to them, and they did have an opportunity to interview interview Mr. Baralt before they put him on the witness stand. I don't recall any time when the prosecutors came to us and said, will you stipulate to the real estate documents, etc., etc. It never happened. So to say there was a refusal to stipulate to not the reason why the information is being put on. It's because these prosecutors, as the court has noticed, simply want to stretch out the spending evidence to maximize every single act to the extent that they can. But when it comes to knowing, first of all, they gave us the name of these two witnesses on Friday. They never said to me or to any of us, because we do talk to each other all the time, that Erik Menendez was not somehow implicated in these spending transactions. Not one word about that. And they gave us the two names, no indications of what they've been testifying to. And that was it as far as discovery goes, and that was Friday. And we were told on Friday these witnesses would be coming in on Thursday. Unless I'm mistaken, today is still Tuesday. But I realize Ms. Nahara may not understand what it means for us to get this kind of information and what investigation it requires. Exactly. She's a prosecutor. If you don't understand what the duties are of a defense attorney, then really shut your mouth. Because the defense attorney is supposed to be investigating any evidence that might be relevant to their case. But I don't intend to tell her that. So she kind of insults her with a side insult there to the judge. The court says, all right, let me read these reports. But before I do, let me find out which witnesses are here today for the prosecution. We have Detective Zoeller. Ms. Nahara says, correct, Your Honor. The court says, I assume his testimony isn't extensive. Correct. We have the stipulation, Your Honor. We have Ms. Sugarman, we have Ms. Glenn Stevens, and we were intending to have Ms. Pisarcik. The court says, is she here? She's not here. We did intend to bring her in today, and we have Ms. Abramson says, Sugarman, is that right? Ms. Nahara says, I said that. You said, Sugarman? The court says, I'll read these reports and take a short recess. It does seem to me that counsel are falling down in their responsibility to the jury and the court. I'm talking to the prosecution now. You had all day yesterday afternoon, morning, and afternoon to bring all of these issues that could easily be analyzed as potentially subject to defense objection and bring it to the court's attention yesterday, and to wait until this morning when the jury is sitting here. They've been here since 8:30 is unfair to the jury, it's unfair to the court, and it reflects sloppy work on the part of the prosecution to say Zoeller had the report on Thursday or his notes on Thursday, but was waiting to type up a report to give it to the defense on Tuesday. Doesn't really cut it. It doesn't make sense, quite frankly. Finally, yell at them, but he's probably not going to do anything. Ms. Nahara says, Your Honor, for the record, and I'm going to have to take responsibility for this, I was told Ms. Sugarman could come in and verify the records, and that is as far as I pursued it. That was a mistake on my part, and I take responsibility for that over Detective Zoeller. The court says, You're saying Detective Zoeller didn't tell you last week that Erik Menendez was implicated? By last week, I mean, Ms. Nahara says, No, he didn't, and I didn't ask him, and I probably should have. That is where I failed in my responsibilities. I did not learn this until this morning. As counsel have been saying, we've been in court a lot. That is no excuse. I should have found out that information and I didn't. Court says, Detective Zoeller, when did you first tell the prosecution that Erik Menendez might be implicated in this? Detective Zoeller says, I didn't at all, Your Honor, until they received the reports this morning. Yikes. Is that a Brady violation? I mean, it's kind of I don't know if it's technically Brady. He turned it over, but he turned it over late. So I don't know, but that's pretty bad. He didn't tell the prosecution anything about Erik being implicated. The court says, did anybody ask for your notes? No, sir. The court says, is it reflected in your notes that Erik Menendez is implicated in some fashion that he was present when some Detective Zoeller says that he was present, period. Ms. Nahara says, so once again, it's the part of the prosecution team that is responsible for this. I should have asked him and I didn't. I left it with him verifying the documents. Court says, I'm going to read this report, and while I'm doing that so that we don't have any more time wasted, if it hasn't already been done, Detective Zoeller's notes should be copied and turned over to the defense and to the court as well. Ms. Abramson says, thank you, Your Honor. Could the court ask the clerk to make a copy of that after you finish reading it so I can have it back? The court says, yes, sure. Thank you, Your Honor. A recess was taken. All right, I've read this, says the court, these reports, and yeah, a recess. Okay. I read, we're back. The court says, all right, I've read these reports, and we'll have the clerk make copies for counsel in a moment. Did you get the notes from Detective Zoeller? Ms. Abramson says, yes, we did, Your Honor. The first word was brothers came in. The court says, all right, well, again, could you give me some information as to how this new discovery affects the testimony or cross-examination of Mr. Stevens from the perspective of Lyle Menendez? Mr. Gessler says, well, I haven't had a chance to talk to Mr. Stevens because so far he's been unwilling to talk to us. I was talking to Ms. Sugarman trying to gain information during the break that we could. Cross-examination of Glenn Stevens in most areas won't be affected at all, but as to direct examination that he gave at the first trial that I anticipate will be asked again, he's saying he went to these condos or condo and patio home on one or more occasions with Lyle Menendez. Since this involves different trips, as far as Ms. Sugarman is concerned, different people coming in, I need to find out some more information as to how this all ties together. The court says, you mean whether she saw him, Mr. Stevens? Mr. Gessler says, and whether Mr. Stevens was with anybody else. Are both witnesses in the courtroom at this time? Okay. It would depend on Mr. Stevens' recollection as to whether he ever went there with Erik Menendez, whether he ever went into the office and was mistaken for Erik Menendez. A lot of different things involving now this new information. The court says, weren't these matters developed during his earlier examination as to whether he was there with anybody besides Lyle Menendez? Mr. Gessler says, I don't believe so, Your Honor. There was no reason to. Ms. Abramson says, right. Mr. Gessler says, it's simply that he went with Lyle Menendez and the talking that they did about the condos and the patio home. Court says, what is the people's understanding as to Mr. Stevens? Would he indicate that Erik Menendez was present? Ms. Nahara says, Your Honor, I spoke to Mr. Stevens and he tells me that he went and looked at a patio home. He did not go and negotiate for them. He looked at the patio home once and looked at the townhouse, and Mr. Menendez was not present when he was shown these places by the defendant Lyle Menendez. And I believe Ms. Abramson asked him that as well, and he told her. Ms. Abramson says, asked him. I have never talked to the man in my life, Carol. Some of these answers without the jury present are hilarious. Like, I have no earthly idea what you're talking about. And I have never talked to the man before in my life, Carol. That should be on a shirt. I have never talked to the man in my life, Carol. Sorry, it's just funny. I'm sorry. I have to laugh because some of this is just ridiculous. especially when they're still trying to bombard them, ambush them with new discovery and new witnesses. The court says, okay, one person speaking at a time here. Ms. Nahara says, he says that, no, that Erik Menendez was not present and that he was shown these places by Lyle Menendez. Okay, says the court. Ms. Nahara says he was not involved in the negotiations of these places. The court says if that's the people's offer, how would Stevens' testimony be affected by this revelation? Mr. Gessler says, I would also like to know if he went to the office at any time, if he talked with any of the real estate people involved, the circumstances of these visits, and I also believe it's a mischaracterization to call one of these things a townhouse. I believe it truly is a condo, and I think it's so set forth in the paperwork. The court says, I'm not so much concerned about what the unit was or how it's described. That is not the issue here. Mr. Gessler says, in this case, for cross-examination, to a certain extent it is because we know there was a condo as such which the purchase was begun by Jose and Kitty Menendez during their lifetimes. To differentiate the next property as a townhouse, I believe, is a mischaracterization, at least as to what we know is a townhouse. Court says, I understand that part. Ms. Emerson says, I would like an opportunity, if I can, to talk to Mr. Stevens about when he did these things he did and where Erik Menendez was, to his knowledge at the time, and all of that. The court says, what for? It's not being offered as to Erik Menendez, and he's not being mentioned by the witness in his testimony. Ms. Abramson says then that witness becomes potential impeachment for the other witness who claims Erik Menendez was there at certain times. I say potential impeachment because until I go back and check my records, which are enormous, I can't determine at this point where my client was every day. The court says, okay, I don't see what I've been presented with so far would interfere with the testimony of Glenn Stevens and going forward with that. As far as the witness testimony, the one who's here from New Jersey, Mr. Sugarman, is it being offered as Ms. Sugarman, is it being offered as against both defendants? Is that the people's offer? Ms. Nahara says, at this time, given the new revelations, it would be. It was originally offered only as to Lyle. The court says the people are in violation of the discovery order issued in this case. Material should have been turned over immediately, which would have been on the 26th of October. And the defense is asserting that they are prejudiced by the disclosure at this time, and the court understands the need for investigation and verification of this witness's proposed testimony. The court will not permit her to testify until such time as the defense has had an opportunity to investigate. Whether that will be accomplished this week or sometime later, perhaps her testimony will be delayed until after the defense presents its case. But the people had an obligation, at the very least, to turn this material over on October 26 pursuant to the discovery order in this case. And I have been presented with no explanation that makes any sense as to why it wasn't, quite frankly. So he's mad that it wasn't turned over on time. And that's the only reason why he's fighting, sort of, with the defense by not allowing her to testify. Ms. Nahara says, that being the court's ruling on the subject, the people would not offer this then. We would just offer, as to Lyle Menendez, the original purpose she was brought out for, which was to verify that he, in fact, bought this patio home. Ms. Amerson says not offering it against my client isn't enough given the fact that we only have one jury. The court says perhaps there can be a stipulation to authenticate these records is basically really why she's here. Isn't that true? I'll let counsel discuss that matter. Mr. Gessler says, my problem is, Your Honor, that I need a chance to further talk to Ms. Sugarman. The court says, I'll give you that chance before I can entertain any stipulation. The court says, I'll let you do that sometime today. Hopefully we'll get some time to do that. I just don't want to interfere any further with the progress of the trial. Jury has been here at least 8:30, and they've been cooped up in the jury room since 9, and it's now 10:07. It's just unfair it's unfair to them to keep them waiting any longer. I'll give you time, whatever you need, to speak with her. Ms. Abramson says, we're still objecting to the next witness because we don't have adequate time to prepare for the next witness who also involves my client. The court says she should not be flown out until you have time to digest it and report back to me further, either later today or tomorrow. So so that's how we'll proceed. I'm not saying she'll be permitted to testify at all. As I understand it, her testimony won't be any different or add anything to what the stipulation will accomplish. Ms. Nahira says, that's a separate piece of property. There will be a need for a separate stipulation. The court says, again, those things could be discussed with counsel. Do it on your own time, not when the jury's here, is what I think he would be shouting. Um, yeah. Ms. Nahira says, okay. The court says, and if stipulations can't be worked out, she doesn't have to come in at all. Ms. Nahira says, okay. He's like, work it out with the defense counsel or she doesn't come in, pretty much. Be a grown up, do your job, talk to them respectfully and work things out like you're supposed to do as an attorney, and then get back to me. And if you can't be an adult, then you don't get your way. And that's how the world should work. All right, so the court says, so at this point, with the representation that Mr. Stevens will not mention Erik Menendez being present at any of these events because that's his recollection that he was not present, he'll be permitted to testify. And Sugarman won't be permitted to testify, and neither will the other witness, pending a resolution um, pending the resolution efforts to stipulate to the foundation for the admission of records. So either get a stipulation, come together and agree on something, or you don't get your witness. Mr. Gessler says, you were cross-examining Detective Zoeller at the time the juror asked for the recess. Ms. Abramson says, that's on the Islamenia matter. The court says yes. Ms. Abramson says, just to keep this up, the court has indicated that the court might take judicial notice of the fact that neither Erik nor Lyle in the first trial testified to the incident outlined in the letter, or that they had any contact with Islamenia in any sense. The court says they did have contact with Islamenia in some sense because it was referred to in some notes or so-called escape plan. Ms. Abramson says yes, but that did not. Well, the point is that neither defendant testified to any incident like the one described in that letter, to going anywhere, borrowing a gun, or anybody in any way. The court says, well, let me ask you this. It's something that possibly I could take judicial notice of, or it could be subject to stipulation, or if the defendants testify in the defense case, it can be brought out in their testimony and it wouldn't be subject to any impeachment. Ms. Amerson says, but I don't think that's appropriate to wait that long. The jury may have the impression that they testified to it. We can ask Detective Zoeller if he remembered and if he was present throughout their testimony, whether either of them testified to it. The court says, sure. Ms. Averson says, but I don't know what he's going to say, and I don't like fishing. The court says, ask him before you ask the question. Mr. Gessler says, may I have just a moment? The court says, sure. Saberson says, we don't want any ambiguity on this subject for obvious reasons. The court says, right. Ms. Amerson says it's not one of those areas we want to keep fuzzy. There's a brief pause. Mr. Gessler says, I think that we could discover it through Detective Zoeller, at least at this point, Your Honor. The court says, okay, let's get the jury out. Holy crap, that was a long argument. There was a lot of argument at the end of October 30th, and now October 31st begins with a bunch of argument. All right, so get the jury out. It's been kind of busy, says Mr. Gessler. May have just a moment to go to the restroom. Got it. He went in the restroom. Okay, so they take a break. Now they're back. Everyone is present. We'll have the jury out, please. Jeez, Lou, that took a while just to get back into the testimony. All right, the court says the jury is back in court. Good morning, ladies and gentlemen. I'm sorry for the delay. There was some last minute things that occurred this morning that required the court and the lawyers to have some discussions, and it was something that we weren't able to deal with yesterday. It only occurred this morning, so we had to, unfortunately, delay our start here. All right, we will now resume cross-examination of Detective Leslie Zoeller, who is recalled to the stand, sworn in, and still sworn in, I believe. Or, yeah, he's still sworn in. All right, so Mr. Gessler for Lyle Menendez. Good morning, Detective Zoeller. Good morning. When you received the letter from Lyle Menendez to Brian Eslaminia, that was in an envelope in the drawer of his nightstand. That's correct. Now, you mentioned that when you saw him in the district attorney's office on September 14th, that he was uncooperative in getting him there. In getting him there? I didn't state that. No. Was he cooperative in coming there? Yes. You had an appointment for him there? Yes. Was he subpoenaed to come there, or was this just a telephone call saying that this was when you should come? A request, to which he came. Was the request accompanied by a subpoena? No. Or was it simply, gosh, we'd like to talk to you about 6:30 in the evening on Thursday in the district attorney's office? Yes, that was basically it. So he wasn't in handcuffs, arrested, nothing like that? No. And then he talked to you and Mr. Khan and Miss Nahara a period of about an hour and a half to 2 hours? Approximately, yes. And this comment that he made, quote, I lie like a dog, how did that come about? It was, the way I look at it, it was stated in jest. Mr. Khan had asked him, you're an honest fellow, something like that? Almost with humor. With humor, yes. How's that humor? Um, Also with humor, yes, he says. And that's when, was he laughing when he said that, Mr. Khan? I don't know whether he was laughing or not, but it was certainly evident how it was. Was he smiling? Received, yes. And at that point, Brian Eslaminia said, I lie like a dog, and he also was smiling or laughing? I was behind him. I didn't see whether he was laughing or smiling. I didn't hear any laughter. At any rate, what? All right. At any rate, you got the distinct impression that what was said that it was said in jest between the two. Yes. So he also said, this is Mr. Eslaminia, quote, I would rather say nothing, but I'm going to tell the truth on the stand. That's what he said. That's what he said, isn't it? That's correct. And that's what you wrote down. That's correct. Incidentally, the first trial, did that begin in June of 1993? Yes. And you're familiar with that first trial, aren't you? Yes, I am. You attended it, got witnesses, things like you're doing in this trial. That's correct. In that first trial, Lyle Menendez testified, didn't he? Yes, he did. Did he ever say in his testimony in the first trial that he had sought a handgun from Brian? Mr. Khan says, objection. Mr. Gessler continues his question on Saturday morning. Mr. Khan says, objection, calls for hearsay. Court overrules that. The witness says, no, he never testified to that. Mr. Gessler says, and did Erik Menendez also testify at the trial? Objection, calls for hearsay. Overruled. How's that hearsay? The witness says yes. Mr. Gessler says, and at the first trial, did Erik Menendez ever seek a handgun from Brian Eslaminia on the Saturday morning before the homicides? Objection, hearsay, overruled. The witness says he testified to that, or he never testified to that. No. Mr. Gessler says, and nobody testified to that, did they, at the first trial? No, sir, they did not. Now, at the first trial, did Lyle Menendez ever testify to seeing a video in the company of Brian Eslaminia and his father? Objection calls for hearsay. Overruled. No, he did not testify to that. Did Erik Menendez ever testify to seeing a video in the company of Brian Eslaminia and his father? Objection, hearsay. Overruled. No, he did not. Did any witness at the first trial testify to that? Objection, hearsay. Overruled. No. Thank you. I have nothing further. Ms. Abramson says, wait, there's one more matter. Then Ms. Abramson says, I have nothing further, Your Honor. The court says, any redirect? Mr. Khan says, no. Court says, okay, thank you. You may step down. Your next witness. Mr. Khan says, at this time, the people will stipulate that the Brian Eslaminia letter that has been marked as 121 for identification, a Xerox copy of what has been marked as 144, was, in fact, written by Lyle Menendez. Mr. Gessler says, so stipulate. Ms. Abramson says, we'll stipulate to that as well, Your Honor. The court says, all right, there's a stipulation or agreement. Yes, ma'am. Juror number 8 says the first name of the person. The court says Brian Eslaminia, also known as Amir Eslaminia, both names. The juror says thank you. The court says, I don't know if he used that when he testified. He has both names. That's a stipulation by the parties. A stipulation means an agreement that all sides agree that that is a fact that's not in dispute, that the letter was written by Lyle Menendez. So you accept that as a fact proved by the stipulation. All right. The people may call their next witness. Ms. Nahara says, thank you, Your Honor. And she calls Glenn Stevens to the stand. Okay, so Glenn Stevens, called as a witness by the people, was duly sworn and testifies as follows. Ms. Abramson says, we need an admonition on this witness, Your Honor. Clerk says, raise your hand to be sworn in. He does so and spells his name. The court says the testimony of this witness is being offered and is to be received only as to the case of the people versus Lyle Menendez. So you should consider it only in relation to that, the case of the people versus Lyle Menendez. Remember, first trial, they had 2 juries, so they could send Erik's jury out so they never heard this information. However, you can't do that when you have 1 jury, so you can't it's really hard to set those facts aside and not think of both defendants in a group. So it's really hard for jurors to do that. So even if they are given this instruction, it really, it's they're prejudiced by not having the 2 separate juries in this case. Or at least in this situation. He says, so you should only consider it in relation to that, the case versus the people versus Lyle Menendez. Says, all right, you may proceed. Ms. Nahara says, thank you, Your Honor. Direct examination begins. Ms. Nahara says, sir, do you know the defendants in this matter, Lyle Menendez? Yes, I do. Is he seated here at counsel table at the end? Yes, he is. And when did you meet the defendant, Lyle Menendez? During the second half of my freshman year. I believe that would be the spring of 1988, I believe, or I'm sorry, 1989. So the same year of the homicides, same spring. All right, so how old were you when you met him? Oh, I guess 19 or 20 years old. And in February of 1989, did you socialize with the defendant Lyle Menendez? Yes. And did you and he socialize with other individuals at Princeton as well? Yes. And who all did you socialize with? Oh, we're many people, but the main group of friends was a gentleman by the name of Greg Guest, another one by the name of Hayden Rogers. We've heard his name before. And almost at the time, bubble it. I don't know why I did that. That was bothering me. Okay, sorry. There were many people, but the main group of gentlemen was Greg Guest, another one by the name of Hayden Rogers, and also at the time there was a non-student we were friends with at the name of Donovan Goodrow. We know both of those names. We've heard Hayden Rogers. I don't believe he ever testified, but he comes up in testimony. All right. And with regards to Mr. Goodrow, at some time during that semester at Princeton, and did Mr. Goodrow move in with Lyle Menendez? Yes, that's correct. And do you recall about when that took place? Oh, it was about halfway through the spring semester. And would that be approximately April of 1989? Yes, sounds correct. Now, sometime a little later, were you aware that Donovan Goodrow moved out of the place where he was living with Lyle Menendez? Yes. And do you recall when that happened? It was a few months later, maybe late May. And were you present when Mr. Goodrow left the place he was sharing with Lyle Menendez? Yes. And what happened on that day? Well, a group of us, Hayden, I believe, myself, Greg Guest, had confronted Lyle with information that Donovan had, without telling us what was said. Did you give some information to Lyle Menendez? Yes. Yes, exactly. And at some point that day, did Lyle Menendez ask Donovan Goodrow to leave? Yes. Remember, he found out that Donovan Goodrow was not really a student at Princeton and he was lying the whole time. So there's that. And it basically he lied about accomplishments, he lied about all sorts of things, it seemed, to kind of get in with this in crowd. He wanted to get in with the crowd, so it seemed like he was a fibber. All right, so at some point Glenn Stevens and Hayden Rogers tell Donovan Goodrow, or tell Lyle about Donovan Goodrow's real identity. He's not really a student, he's been lying, he's working where it's like the Cheesecake Factory or something, I can't remember. But he is uh definitely not a student. And did you see Donovan Goodrow pack his things? Yes. Well, they were sort of packed up for him. Yes. And were his things taken from the apartment or taken from the place where they were staying? Yes. Now, sometime after Mr. Goodrow moved out, did you see an item of his still in that room? Yes. And when was this? It was within an hour or so afterward. So, an hour or so after what? After Donovan left. And what was it that you saw? It was his wallet. And where was Mr. Goodrow's wallet? Well, when I saw it, it was in Lyle's hand. And was the defendant Lyle Menendez doing anything with it? Well, he held it up and said to me, I kept his wallet. And did he show you the wallet? Yes. And can you describe what it was that you saw? Well, I don't remember what color it was, just seemed like a small leather wallet. Was there anything inside? We proceeded to sit down on the bed, and Lyle went through and showed me what was in it. And what was in it? The things that I remember distinctly were Donovan's driver's license. There was a Wells Fargo card and also some Mac machine receipts. Now, with regards to the driver's license, did you see what, if anything, Lalo Menendez did with it? Well, he put all the contents back in the wallet and kept it. And what was his demeanor at the time that he was showing you this wallet? Well, he was joking when he showed me the wallet. I kept his wallet because he had wanted to try to retrieve some money that he assumed was taken by Donovan. And did you ever see the driver's license or wallet after this event? Well, the wallet for a while sat in a little black plastic case on a shelf in the room, and it was there for most of the year, if I recall correctly. And so the last that you saw of the wallet, was it in the black plastic case in Lyle Menendez's room? Exactly. Now, at the end of that semester, in the beginning of semester, June of 1989, did you go anywhere? Excuse me? At the end of that semester, beginning of summer, June of 1989, did you go home from Princeton? Yes. And did you keep in contact with the defendant, Lyle Menendez? We spoke a couple times over the summer. Had you made any plans for the summer? Yes. Well, originally we were discussing perhaps me going to stay out at the home in Beverly Hills and maybe working in the area. And did you end up going out to the home in Beverly Hills? No. And sometime before the beginning of summer, did you have a conversation with Lyle Menendez about a car that he owned? Yeah, well, he had mentioned that he owned an Alfa Romeo at home and had expressed, I think, more than once that it was a quote unquote a piece of crap or something to that effect. Okay, maybe it was. Maybe it broke down on him constantly. Maybe it wasn't reliable. Maybe there was a reason why he said it was a piece of crap. Maybe he didn't like it for whatever reason. Maybe it wasn't the car that he wanted and his father forced him to get it originally. I'm just saying. Have you not ever gotten like a hand-me-down or something that your parents were forced you to do when you were a teenager? Like really? But okay. We're gonna say that he's just like the spoiled brat because he doesn't like his Alfa Romeo when we know nothing about the car, we know nothing about its condition, we know nothing about the reason why he doesn't like it. But let's just make an inference that he's just a spoiled brat and doesn't like nice things that he's or handed by his parents. That's kind of what that says to me. But anyways, let's move on. And do you recall how many times he told you that his Alfa Romeo was a piece of crap? No, I couldn't say with any certainty. Did he tell you whether or not his parents had purchased this vehicle for him? I don't remember if he told me that or if I just understood it. Oh, actually, it was a graduation present, I think, if I remember correctly. A graduation gift from his mother and father? Yes. Now, was he coached for that? Because he seems to have forgotten and then was like, oh, yeah, I remember I was supposed to say that. I don't know. Just just observing. Anyways, so a graduation gift from mother and father? Yes. Now, in August of 1989, did you hear about the homicides of Jose and Kitty Menendez? Yes. And did you hear about their death, or when did you hear about their deaths? I believe the following morning I received a call from a family friend whose mother had worked with Jose at RCA in New York. And when you say the following morning, would this be the morning following the homicide? Yes. And when you heard this information, did you do anything? Did you react to it? Yeah, I was upset. I immediately tried to contact the family. And did you call Lyle Menendez? I called and spoke with Jose's personal secretary. And was this woman go by the name of Marcy Eisenberg? Yes. At some time, did you contact and were able to talk to the defendant, Lyle Menendez? I don't remember if I spoke to him on the phone before actually seeing him at the memorial service. I think somebody from the family called me and told me when and where the memorial service would be and that I should meet them there. So, sometime after you heard about the homicides and you spoke to Ms. Eisenberg, you heard about a memorial service, is that right? Yes. And where was the memorial service to be held? In Princeton, New Jersey. And did you live in New Jersey at the time? Yes. And did you go to the memorial? Blah, blah, blah. My lips keep mumbling my words. Sorry. I'm trying to slow down, but it's. And did you go to the memorial service? Yes. At the memorial service, did you have an opportunity to talk to the defendant, Lyle Menendez? Yes. And was he wearing a watch at the time? Yes, actually, I have to correct that. At the memorial service, I didn't get a chance to speak to him. There was a wake that evening, is when I actually spoke to him, and that is when I saw him wearing the watch. And when you saw him wearing the watch, did he tell you anything about it? He told me it was his father's watch and he was wearing it. And can you describe the watch? It was a solid gold Rolex. That's basically it. And did you later learn that this was a lie? I later learned that yes, this was not his father's watch, that he had purchased it after the homicides. And did you see the defendant, Erik Menendez, at the memorial service? Yes. Object, ask for an offer. The court says, well, other than this one question, did you intend to go further into that? Ms. Nahara says, not at this time, Your Honor. Court says, okay. Ms. Nahara says, now, at this service, did you have, at the wake, you testified you had a conversation with Lyle Menendez. Is that correct? Yes. And what did the defendant, Lyle Menendez, tell you at that time? Basically, I just gave my condolences and asked him how he was doing and his response. I remember stuck in my head, and because he said, well, I've been preparing for this for so long that the transition was quite easy, something to that effect. And did he tell you anything about the estate at the wake? I don't recall. Did he tell you anything about who would be in control of the family at the time? Well, Mr. Gessler says that could be answered yes or no, Your Honor. The court says yes. Can you? The witness says no. The court says, okay, your next question, please. Ms. Nahara says, did he ever tell you that he would be now in control of the estate? Objection asked and answered. Overruled. Later, yes. And when did he tell you this? We were having dinner one night in a restaurant, and he expressed to me that the will from the family had given him and his brother everything and that he would be in control. Now, calling your attention back to the night of the wake, when he told you that he had waited a long time to be in this position, did he tell you anything more during that conversation? Not that I recall. Now, sometime after the wake, did you see the defendant, Lyle Menendez? Sometime after the wake? After the wake. Yes, on and off, or for a long period of time after that. Now, sometime after the wake, were you aware that the defendant, Lyle Menendez, went back to Los Angeles? Yes. Now, before he left for Los Angeles, did you see him? Yeah, I'm sure he did. And do you recall, as you sit there, did you see him when he came back from Los Angeles? Yes. Now, at some point during this time, was this in late August, early September of 1989? Yes. The dates are vague, but I believe so. And it was after the funeral service. Yes, correct. When was it after the homicides in August of 1998? Right. That's okay. Now, I'm reading what's on the page. That's a confusing question. Or not that was a confusing answer. It's not an answer. Anyways. Now, at some point during that time, were you at the defendant's aunt's home, Terry Baralt's home? Yes. And did you see the defendant, Lyle Menendez? Yes. And can you describe, first of all, was he alone or was he with anybody when you saw him? He was with his bodyguards at the time. And was this in Princeton, in the Princeton area, or, excuse me, in New Jersey? Yes. And was this in the Princeton area? Yes. And can you describe what happened? Were you in the home? I had gotten I had gotten there before Lyle and was sitting on the couch in the family room with the aunt and some of the other family members. And I remember the door sort of swung open, and some bodyguards came in and looked around the house and then brought Lyle in afterwards. And when the defendant, Lyle Menendez, came in, and did you have an opportunity to talk to him? Yeah, we sat together all evening, if I remember correctly. And did you ask him why he had bodyguards? At some point, yeah. And what did the defendant, Lyle Menendez, tell you? His response was that there had been some threats, phone calls that had come in from whoever had taken his parents' lives, or at least the people said on the phone that they were whoever had taken his parents' lives, and he was afraid for safety and found it necessary to get bodyguards. And did he ever tell you anything about the mafia or organized crime? Not that early on, no. Did he later tell you on about that? Yes, later on he said that his father had some questionable business dealings with a gentleman by the name of Noel Bloom and some other people, and that perhaps the mafia had had something to do with it. And do you recall when after the homicides he told you this? No, I really don't. Was it after the memorial service? Yes. Was it before or after you saw him at Terry Baralt's house with the bodyguards? Most likely, the time continuum is difficult, but my guess would be after because the meeting at the Baralt house was very early on and I didn't learn the real circumstances until later. So it would be after that, most likely, yes, meeting. Now, did you once again begin Princeton the following semester, September of 1989? Yes, yes, that's correct. And would that have been your second year at Princeton? Yes. Now, in September of 1989, when you were at Princeton, did you see the defendant Lyle Menendez? Yes, he was back and forth between Los Angeles and the Princeton area often. So, whenever he came to town, we'd spend time together. And going back to that period after the memorial service in August of 1989, when the defendant was in the Princeton area, did you have an opportunity to go out to dinner with him one night and talk to him about going back to LA for a day? Yes. And do you recall, did you have a conversation with the defendant, Lyle Menendez? Yes. Do you recall about when this was that you had this conversation? It was very soon after he had returned from the day trip to Los Angeles. And you were aware that he had gone to Los Angeles for a day? Yes. And what did the defendant, Lyle Menendez, tell you about going to LA for the day? He told me that one of the family members had found an entry into the family computer that it was basically a menu of three headings. One said Menendez, one said list, and one said will, and that he said that he was nervous, that the original real will gave him and his brother everything, and that his father was not quite happy with him, and if there was a new will there, he wasn't sure that he wouldn't be in it. So, or that he would be in it. So he made a trip out to LA to try to get a computer expert to open up the will in the computer and see what was in there. And did he tell you whether or not that he succeeded in getting the computer person to open up the computer? Yes. And what did he tell you? Well, he told me he found a little Jewish guy in the Yellow Pages who worked for himself and nobody would be able to find to come over and try to get into the will in the computer and that he was unsuccessful. That whatever was in there was in it was el, ill, illegible why can't I say that word right now? It's like escaping my brain. Can't read it. It's not readable. So he asked the expert to erase it, whatever it was. And did he tell you whether or not this expert was an IBM expert with computers? Yes, he told me that the family computer was an IBM, so they needed an IBM. This is a lot of detail that this kid probably doesn't know or didn't know until he was prepped by the prosecution. I don't think this kid's truthful, and we'll find out more on cross, but I don't know. I feel like a lot of this could be coming from information that came out about the case later. I don't think it's necessarily coming originally from this kid, but we'll see. Ms. Nahara says, and did he tell you what happened did he tell you whether or not there was a problem with the computer after the computer expert erased it? He told me that his uncle or somebody had discovered that the computer was tampered with because they neglected to put back up the menu with the 3 listings. And did he tell you anything else about this trip to LA? Not that I recall specifically right now. Now, after he told you about getting the computer expert to erase the will because of his concerns, did you see him after that? After the will was actually erased? After you had this dinner where he told you? Yeah, sure. And starting in September of 1989, when you started school, did you see Lyle Menendez often? Yes. About how often did you see him? Difficult to recall, but every time that he came into town, it would be fair to say. Now, at some point, did the defendant Lyle Menendez lose a Rolex watch? Yes. And what kind? Was the gold Rolex watch the one that he lost? No. Was it another Rolex? Yes. And what kind of Rolex was it that he lost? A submariner, I believe. And do you know how he lost it? He was in one of the students' rooms one night and left it there by accident and then went back and couldn't find it. Yeah, somebody stole it, that's why. Do you know what he did after he lost this watch? He replaced it with purchased a new one. Do you know if this was identical to the first submariner watch that he bought? As far as I know. And what did he do with the new Rolex that he bought, if anything, if you know? Well, he wore it on occasion. He switched back and forth between the gold one and the submariner is a stainless steel one, depending upon where he was going. Now, at some point, did you go with Lyle Menendez to look at a property that he was interested in purchasing? Yes. And did you look at a property that he did in fact purchase? Yes. And was this during the August-September of 1989 period that you saw him in Princeton? Yeah, sounds correct. Well, was it before or after you started your school year at Princeton? It was right around that time. Maybe he came back to the Princeton area. It was maybe a week before I started school, so I was going to look at properties while I was at school and before I had started school as well. And when did you, if you recall, when did the semester start? It usually starts right after Labor Day, the week after. Ms. Nahara says, and Your Honor, I have a photograph that has been marked 102 for identification if I may show it to the witness. The court says yes. She says thank you. And sir, showing you what has been previously marked as Exhibit 102, would you take a look and tell me if you recognize what's depicted in the photo? Yes, I do. And what is that's depicted in the photo? That's the patio home. When you say patio home, can you give us? It was the patio home that Lyle was interested in purchasing. And did Lyle Menendez show you the inside of that patio home? Yes, that's correct. And what was it like? Quite nice. I remember the upstairs bedroom, the master bedroom had a panoramic view, windows in it. It was quite nice. And if you can tell us your best estimate, about how big was it? In excess of 2,000 square feet would be my guess. I'm not good at that kind of thing. Okay, did it have more than one bedroom? I don't recall from actually seeing it, but I know more than one person was supposed to live there, so my guess would be yes. And Your Honor, I have another, what appears to be a purchase contract, which I'd like marked People's 147 for identification, and this is previous 56. Court says, all right. And showing you what has been marked as 147, first of all, let me ask you, Did you go to the place where these homes were being developed? Yes, you mean the whole development, or do you mean the sales office? I mean the sales office. Yes, I had been to the sales office. And were you aware at some point that Lyle Menendez purchased this home? Mr. Gessler says objection as a conclusion. Court says sustained. Did you ever see any purchase documents with regard to the home that you've just identified the defendant, Lyle Menendez, showed you? I don't believe I saw any purchase documents on the patio home. Did you see any other real estate with Lyle Menendez? Yes. And Your Honor, what has been marked previously for this trial as 103, if I may approach? The court says yes. And showing you what's been marked 103, do you recognize what's depicted in that photograph? Yes. And what is that? It's one of the townhomes that he was interested in purchasing. And when you say he was interested in purchasing, is that Lyle Menendez? Yes. And Your Honor, I have a second set of documents I'd like marked 148 for identification so that this would be previous 57. Court says all right. To separate it from the previously marked document. And with regards to the second home or the second place that you saw with Lyle Menendez, can you describe what that was? It was a townhouse. It was basically an apartment in a cluster of apartments. And can you describe it? Describe the interior. Well, there were two of them, one of which I lived in later, and the other one which I had seen only briefly. Okay, starting with the one that you lived in, did you live in one of these condominiums that was purchased by the defendant, Lyle Menendez? Objection, Your Honor. Assuming a fact, not an evidence, court says sustained. Ms. Nahara says, did you live in one of the condominiums in this development? Yes. And who was your landlord? I paid rent to the condominium association, so I don't believe that the one that I lived in was owned by the defendant. And did the defendant, Lyle Menendez, show you a condominium similar to the one that you lived in? Yes. And was it your understanding that he was attempting to purchase that? Yes. And can you describe it for us? It was devoid of any furniture or anything like that, but it was basically a one or two bedroom apartment with a kitchenette and a dining room. Was it in the same neighborhood as the patio home that you had testified to and seen previously? Yes. And did you ever see any purchase agreements or paperwork on the condominium? I was with Lyle on one or more occasion when he went to the sales office to sign paperwork. And when he went to the sales office to sign the paperwork, which property was it for? I know it wasn't the patio home. I don't recall if it was paperwork on which of the other townhomes. But you recall it was on a townhome? Yes. And during the time that Lyle Menendez was showing you the townhomes that he was showing you property that he was intending to purchase, did he buy a new car? Yes. Showing you what's been marked as 104 for identification, do you recognize what's been depicted in that photograph? Yes. And what is that? It looks like Lyle's Porsche 911 Carrera Cabriolet. Is that how you say that? When you say Lyle's Porsche, is that the car that Lyle Menendez bought, the new car? Yes. Now, I guess it would be your fall semester at Princeton, starting from September to the end of the semester, did you see Lyle Menendez often? Like I said, every time he was in town, he'd come visit. And about how often was that, if you recall? It was quite often, but I don't know how many times, or sometimes he'd come and stay for weeks, Sometimes he'd just come just for a day or two. I don't recall. And during that period of time, did you ever go to New York with the defendant Lyle Menendez? Yes. And apart from yourself, was there anyone else who also was socializing with the defendant Lyle Menendez and yourself at that time? There were. There were many people around. I don't recall specifics. If you were to jog my memory, I would. Well, let me ask you this. At that time, after September of 1989, during that period, during the first semester of the Princeton year, did the defendant Lyle Menendez at that time have bodyguards? Yes. At some point, did he stop having bodyguards? Yes. They became too expensive and he dropped them. And as you sit there, do you recall when he dropped them? No. At some point, did he hire somebody else to work basically as protection for him? Not to work as protection for him. He hired Hayden Rogers to come in and run the restaurant which he purchased. And did he ever talk to you about Hayden Rogers providing some protection for him? Yes. And was this during the first semester at Princeton? Yes. I should say the first semester of your second year at Princeton. Right. It's around that time frame. I don't remember exactly when Hayden came out, but it was during that period from my first semester, sometime in that 6-month period from September to March or so. Now, did he at some point talk to you about obtaining a handgun permit for Hayden Rogers? Yes. And why did he want to obtain a handgun for Hayden Rogers? Because he wanted a bodyguard and figured it would be more efficient to have somebody who was already in his employment to serve in that capacity rather than hiring a separate bodyguard. And did he tell you why he wanted a bodyguard? That he feared for his safety. I testified before. That's as I testified before. And at some point, did you take Lyle to speak to somebody about the possibility of getting a handgun permit? Yes. And who was that person? It was an old partner of my father's who's owned an armed security guard agencies in New York City, and we went to ask him what the laws were regarding getting a full carry handgun permit. And were you present during the whole conversation between this person and the defendant Lyle Menendez? Well, for most of it, I stepped out for a few minutes to use the restroom. Now, at some point after this meeting, did you have a conversation with Lyle Menendez? Yes. And did he tell you something about the meetings? Yes. And what did he tell you? He told me that while I had stepped out to use the restroom, my father's ex-partner had leaned over to him and said, I think I know who was responsible for your parents' death, and I'll put out the word that you're to be left alone. So that's kind of suspicious. At this time, was the defendant Lyle Menendez still implying that the mafia was behind these homicides? Yes. And he told you this information that you were not present for. Is that right? Correct. So during Christmas 1989, did you go somewhere? Yes. Where did you go? I went to Los Angeles. And when you came to LA, did you visit somebody? Yes. And who's that? I visited Lyle in Marina del City, or Marina del Rey. Sorry. And did you stay with him in Marina del Rey? Yes. Did he invite you out there? Yes. And did he buy you a plane ticket to come on out there? Yes. And how long did you stay out here at Christmas time with the defendant? Oh, about a week. And while you were out here, did you see a woman named Jamie Pisarcik? Yes. And did you know Jamie? Yes, I had met her before. Was she Lyle Menendez's girlfriend at the time? Yes. And sometime during that trial, Christmas of 1989, did you talk with Lyle Menendez about possibly working for him? Yes. And what did you guys talk about? He had wanted me to drop out of school and to go to business with him, helping him run his various concerns. And was there a particular concern that he was interested in you running? Well, at the time he wanted to. I don't know if he was as specific at the time as to what he wanted to do, but eventually wanted me to go into the real estate business with him. He'd speed up a company called, or blah, blah, blah. He'd set up a company called Menendez Investment Enterprises and wanted to invest in commercial real estate. His uncle in Chicago had a business doing that and was going to help him pick properties and the like. And did he discuss with you working in his restaurant or working in a restaurant? That came later, after the arrests, when Hayden basically left town, went back home, but that he needed me to take over that part of the business. Let's talk a little about the discussion that you had with him around Christmas time. Did you talk to him about, did you talk about how much you would get paid for working for him in his real estate venture? I don't recall when the numbers started getting thrown about, but at some point I remember distinctly the number 50,000 was discussed. And is this 50,000 a year? Yes. And at some point, did you start working for Lyle Menendez? Yes. And how much did you actually make working for him a week? $600 a week. And apart from the $600 a week, was anything else provided by way of compensation? Well, I suppose we had negotiated basically at night an $8,000 sign-on bonus to help to cover some of my expenses for leaving school. When I eventually, oh my God, my brain is tired. Maybe I'll take a break and I'll come back. Let me finish this paragraph. So when I eventually did leave school to go work for Lyle, I had already started the second semester of my sophomore year and had forfeited some of the tuition, and some of the school loans were going to come due while I was out of school. So we had negotiated an $8,000 sign-on bonus, which never came to fruition. So apart from $600 a week and the sign-on bonus, was anything else discussed as part of your compensation? Well, they were going to help me procure a lease for a car, but I was supposed to make those payments out of the $600 a week. And at some point after you come back from the Christmas holiday, starting in January of 1990, did the new Princeton semester begin? Yes. And did you know when that began? First week of February, usually. Now, was that the semester that you had put up money for? The sign-on bonus was supposed to help allay the cost of. Yes. And when you say you lost money, was this money that you already had spent for the semester? Yes, I left school sometime in March. I think maybe the last day of February or the first day of March. I actually signed the papers to take a leave of absence, and I had already paid in excess of $2,000 for tuition of that summer. And was it your understanding that as a part of your deal with the defendant, that all of this would be compensated for? Yes. Now, in the end of February, beginning of March of 1990, did you start working full time for the defendant? Yes. And what were your duties at the time? Well, it was basically to be his bag carrier, his wingman, follow him while he looked at commercial real estate properties, while he looked at purchasing the restaurant, to just basically as an advisor on business dealings. Yeah, right. You're just a friend and he's just dragging you along. He's not doing business with you. You're not an advisor. You're not his peer. All right. And I mean, he is, but he's not. Like, Lyle is on a different level. They both are. Erik and Lyle are on a different level of just self awareness and whatnot, especially now. And did the defendant, Lyle, purchase a restaurant sometime in 1990? Yes. And was that in the early part of the year, January of 1990? Yes. Was that a restaurant called Chuck's Spring Street Cafe at one time? Yes. Showing you what's been previously marked as 101, is that a photograph of the restaurant that the defendant purchased? Yes, ma'am. And were you present when the defendant was involved with negotiations in the contract for that restaurant? Yes. And did you actually see the contract for the restaurant? Yes. Ms. Nahara says, and Your Honor, showing you what's been previously marked 54, I'd like to mark this document in my hands. For 149. Court agrees. Ms. Nahara says, thank you, Your Honor. I believe counsel sent it. And showing you 149, would you take a look at those pages and tell me if you recognize that document? Yes, it certainly looks like the contract for the purchase of the restaurant. And why don't you look at that and the various signatures and tell me if you recognize it? Yes. And when you say yes, is this 149, Exhibit 149, a copy of the agreement, the contract to purchase the restaurant? Yes. And when you were with the defendant, when he entered into these negotiations, were you ever with him when he actually took money or took a check to these negotiations? Yes. And what was the check for? It was a cashier's check, I believe, maybe out in the middle of made out in the amount of 300,000 for the first down payment on the purchase of the restaurant. And showing you the last page of the documents that you've just examined, does that appear to be a Xerox copy of the check that you saw the defendant with? Yes. To purchase this restaurant? Yes. Now, in March of 1990, after you started working for the defendant, Lyle Menendez, did you ever come back to Los Angeles? Yes. And do you recall when that was? It was the first week of March. And do you recall something significant happening this week in that you came back with the defendant? Yes. In terms of to the defendant, yes, the defendant was arrested. Now, with regards to the week that the defendant was arrested, did you fly back on a plane with the defendant? Yes. And while you were on that plane, did the defendant make a phone call? Yes. And who did he call? He called the restaurant and by the restaurant, Chuck's. We're talking about Chuck's Spring Street Cafe. Yes. Did it have another name? He had changed the name at some point to Mr. Buffalo's. And after the defendant, Lyle Menendez, called Mr. Buffalo's, did you have a conversation with him? Yes. And what did he tell you in this conversation? That the Beverly Hills police had been there looking for him. And by been there, was he referring to the restaurant? Yes. And after he told you that the Beverly Hills police had been looking for him at the restaurant, did he tell you anything else? Well, he became nervous. He pulled out a business card from his jacket or his wallet and handed it to me. It was a business card for his attorney, Gerald Sheliff. He also pulled out a significant amount of cash, somewhere up to $2,000, and split it between Hayden and myself. Said, if anything should happen to me while we're out in Los Angeles, call Gerald Shaliff. He and Mr. Oziel, or Dr. Oziel, are the only ones that know everything. Going to that statement, he told you that he, meaning Jerry Shaliff, Lyle Menendez's attorney? Yes. And a person named Dr. Oziel knew everything? Yes. Did he tell you who Dr. Oziel was? I asked him after he said after he said that, and he told me that Dr. Oziel was his psychiatrist and proceeded to tell me about some tapes that the doctor had that were in a safe deposit box. Oh boy. And what did Lyle Menendez tell you about Dr. Oziel's tapes in the safe deposit box? Well, I had inquired. Objection is non-responsive. Sustained. He told me that if the police ever got their hands on those tapes, I'm effed. And when he said, first of all, was it the defendant, Lyle Menendez, who said I'm effed? He said if the police ever get their hands on those tapes, I'm effed. Lyle was referring to himself, yes. And did he tell you anything else at that time? No, I don't recall any more specifics, no. Now, after you got off the plane and you arrived here in LA, was the defendant Lyle Menendez arrested within a few days? Yeah, within a week, yes. And after he was arrested, did you talk to Jamie Pisarcik? Yes. And did he ask you to do anything for the defendant? Mr. Gessler objects as to hearsay. The court sustains it. Ms. Nahara says, were you asked to do something for the defendant? Yes. Mr. Gessler says, objection, hearsay, sustained. Move to strike the answer, says Mr. Gessler. The court says, answer is stricken. The jury is admonished to disregard it. Ms. Nahara says, after Lyle Menendez was arrested, did you do something? Yes. And was this with regards to his car? Yes. By the car, I'm referring to the Porsche. Yes. And what did you do? I went to, upon the request of, Mr. Gessler says, objection to anything further. The court says, don't say anything about what's been told to you. The witness says, okay, I went to get a backgammon box out of the Porsche, which was in an audio shop, getting a stereo put in. Okay. Ms. Nahara says, and did you retrieve this backgammon box? Yes. From the Porsche? Yes. And were there times in the backgammon box? Were there items? Oh my God. If you look at these words so like quickly, it looks like time. Like it could be time. It could items also spells time. Well, without the us, but you know what I'm saying. So it's my brain just I swear to God, it's like dyslexic now. I don't know why. And the more tired I get, the more dyslexic it becomes. Anyway, so and were there items in the backgammon box? Yes. And what were those items? They were personal papers of the families, meaning the Menendezes. And did you look at any of these personal papers? Yes. And what did you look at? The two things I remember distinctly. Mr. Gessler says, I'll object to this, Your Honor, as hearsay. Sustained. Ms. Nahara says, now, after you retrieved this backgammon box with these papers in it, did you do anything with them? Yes. And what did you do with them? I brought them to Gerald Shellif's, Lyle's attorney. And do you know what happened to them after you gave them to Mr. Shellif? Objection, calling for conclusion, sustained. After you gave them to Mr. Shellif, did you ever see them again? See the backgammon box again? No, no. Is it a fair statement that you have no idea what happened to them after you gave them to Mr. Shellif? Correct. Mr. Gessler says objection, conclusion, overruled. The answer will stand. Now, after Lyle Menendez was arrested, did you continue working for him? Yes. And what were you doing at that time? I was asking to stay on and run the restaurant because Hayden left town to go home and there was nobody to manage the day-to-day affairs of the business. And did you run the restaurant? Yes, along with another manager, yes. And when did you, at some point, did you stop working for the defendant? Yes. And when was that? in July of the same year. And between March and July of 1990, when were you working at the restaurant? Did you have any items of Lyle Menendez's? Did he give you anything to hold for him? Oh, yes, actually, actually, before the arrest, actually, the week of the arrest, while we were out in California, he would have me wear whichever one of his Rolexes he wasn't wearing because he didn't want to lose it. And after he was arrested, were you in possession of one of those Rolexes? Yes. Which one? The Submariner, the stainless steel one. Did you do anything with that Submariner? Well, my father took the watch. Objection that can be answered yes or no. Sustained. The answer is stricken. The witness says yes. And what happened to the watch? My father took the watch from me because of the objection to anything further because. Sustained. Why did your father take the watch? Objection, conclusion, sustained. Did Lyle Menendez owe your father some money at the time? Objection, conclusion, sustained. You testified previously. That's some dirty shit right there, trying to get that in under all those objections. Ms. Nahara says, you testified previously that Lyle Menendez, excuse me, oh, I need some water. Hold on. All right, I'm back. You testified previously that Lyle Menendez was supposed to give you, as part of your compensation, a bonus to repay the expenses for school. Is that right? Yes. And who paid those expenses originally? Well, a combination of myself and my parents, and did Lyle Menendez ever pay you or your parents the compensation that he promised? No. Did you give your father the Submariner watch after Lyle Menendez was arrested? My father, well, exercised his authority and took it. And was money still owed to your father at this time? Yes. And would this be by the defendant Lyle Menendez? Yes. Now, sometime towards the end of June, before you stopped working for the defendant, Lyle Menendez, did you owe the money? Did he owe you money? Yes. And do you know how much money that was? Well, I had never received the $8,000 sign-on bonus, and also, I mean, it was understood that he would keep me in his employment for the entire year that I was off school. And at some point, there was a mechanism whereby money can be borrowed from the restaurant? Yes. And what was that mechanism? We were allowed to, on occasion, take out money from the register and leave IOUs to be repaid by our father, or to be repaid by our further paychecks. So these were advances on your paycheck? Yes. And towards the end of the time that you were working at the restaurant, did you take out any advances against your paycheck? Yes. When you stopped working for Lyle Menendez, did you take your final check or was that left to pay these? Well, I took it, but the payment had been stopped. So you didn't get paid the last amount. Is that right? Correct. If I could just have a moment, Your Honor. I have nothing further, Your Honor, at this time. He says, okay, cross-examination. Mr. Gessler asks, Mr. Stevens, you mentioned that you started your acquaintance with Lyle Menendez in the spring semester of 1989? Yes, that's correct. And that would be around the 1st of February. Would it mid-February? Yes. And you were a student at Princeton at that time? Yes. Lyle Menendez was a student at Princeton at that time? Yes. Were you in the same dorm that he was? No. How far away did you live from the dorm that Lyle Menendez lived in? A few hundred yards. You said that you socialized throughout the spring semester? Yes. And what do you mean by that? Well, we were in class together. We'd go out in the evening to the same dinner club together. We spent some evenings together in his dorm room. In fact, most evenings you spent in his dorm room, didn't you? Yeah, I would. Fair to say, I spent a great deal of time there, yes. As a matter of fact, at that time you considered him to be your best friend, didn't you? Yes, one of maybe two, yes. And at the time, it appeared that Donovan Goudreau was Lyle's best friend. Yeah, they had a very close relationship. And along with that, in the group were Hayden Rogers and Greg Guest. Yes. They were also students there? Yes. And you felt that Lyle was a lot of fun to be with. Yes, that's true. You considered him a good friend during that period of time when you were socializing? Yes. And his room was kind of an open room, wasn't it? Door was usually left open. Yeah, that's true. There was a computer in there. Yeah, if I remember correctly, yes. You and any of the other guys were free to use the computer if you felt like it. I never used the computer. Donovan would work on it often. And Lyle Menendez had clothing in the room? Yes, that's correct. If somebody wanted to borrow a sweater or something, they'd borrow things from him. Objection, calls for speculation. Overruled. I don't remember any specific instances where people would go in and borrow his clothes without his knowledge or anything, if that's what your Mr. Gessler says. Some money was missing from his room on one occasion, wasn't it? Yes, that's correct. What about $150? If I remember correctly, yes. And you've told Lyle Menendez that you suspected Donovan Goudreau of stealing that, didn't you? No, that's not. Objection, irrelevant, overruled. No, that's not true. I did tell him that I suspected Donovan Goudreau of stealing the money. I didn't tell him. I didn't tell him that I suspected Donovan Goudreau of stealing the money. Mr. Gessler says, did you, on several occasions, tell Lyle Menendez that he should get rid of Donovan Goudreau before the day that Donovan left? On one occasion before then, a group of us, Greg Guest, myself, and Hayden Rogers, had a discussion with him and suggested that Donovan had not been truthful in some past instances and we were worried about his motives. And at that time, did you say, and that's probably where the 150 went? I don't recall saying that. Did you tell Lyle Menendez that Donovan Goudreau had lied about intending to be a student at Princeton? Yes. Did you tell him he probably lied about other things too? Yes. Did you tell him that he probably was the one who stole the money, that you can't trust a liar? I don't recall that. Well, this was you who else that was telling Lyle Menendez that they should kick Donovan Goudreau out? Hayden, and I believe Greg Guest was there as well. So all of you were saying this. Yes. And did Lyle Menendez express great reluctance to do that? Yes, and we had also had a discussion at his aunt Terry's house about the same suspicions. You and Lyle Menendez and who else? His aunt Terry. At Aunt Terry's house? Yes. And when did that occur in relation to Donovan leaving? The week that Donovan left. But before Donovan left? Yes. And then you were present at a phone call that came to Lyle Menendez from his father, weren't you? Yes. That was on a speakerphone or something where you could overhear both parties? Yes. Was that the same morning that Donovan Goudreau left? I don't recall. In that conversation, Mr. Menendez said, you've got to get rid of Donovan Goudreau. Ms. Nahara says, I'm going to object to anything that Mr. Menendez would say as hearsay. The court says, is this a conversation that the witness had with Mr. Menendez? Mr. Gessler says, this is a conversation that you overheard between Lyle Menendez and Mr. Menendez, isn't it? Yes. Ms. Nahara says, objection, no, sustained as to what was being said by Mr. Menendez then. Mr. Gessler says, on Lyle Menendez's side, did he appear to be talking to his father in that phone conversation that you overheard? Objection calls for speculation. Overruled. The witness says he was speaking to his father and mother. They were on a cell phone in a car, driving somewhere. And in Lyle Menendez's end of the phone conversation, was he protesting that he didn't want to get rid of his roommate? Objection hearsay. Overruled. I believe so. And the conversation went on for several minutes, didn't it? Yes. And at the end of the conversation, Lyle Menendez seemed very sad, didn't he? He seemed sad when we actually asked Donovan to leave. I don't recall his demeanor after the phone call. Well, you asked Donovan. Objection, motion to strike, non-responsive. The court says overruled. The answer will stand. And you asked Donovan to leave very shortly after the phone call, didn't you? I didn't. The group did. And in the group was included Lyle Menendez. Yes. It's fair to say that Lyle Menendez was generous to his friends during that semester that you socialized, isn't it? Objection, irrelevant, overruled. Generous in what regard? He would, objection vague, he would order pizzas and put them on his student card for the group. Objection, irrelevant, overruled. I don't recall that, to be honest. Did you tell Mr. Rand that? I don't recall. Mr. Rand, Robert Rand, Bob Rand, he has been an avid supporter and advocate for the brothers for 35 years. And he did some interviewing of Glenn Stevens, and Glenn Stevens denied some things that he had admitted to in conversations with Lyle about experiences that he had growing up and some other lies and things that he was caught in. And so Rob Rand had to go on the stand in the first trial to impeach Glenn Stevens. So Mr. Gessler asks, did you tell Rob Rand or Mr. Rand that? I don't recall. Do you know who Mr. Rand is? Yes. He's an author, isn't he? Journalist, author, yes. And you were giving him some interviews toward a possible book he might write? Yes. Do you recall during those interviews telling him that Lyle was generous and would buy pizzas and things like that on his card? Lyle was generous, and with his money after his parents' lives were taken. Beforehand, we'd go out to dinners and the like, and I can't recall if he purchased on occasion. I don't recall any specific incident with pizzas or anything like that. At dinners, Lyle Menendez would purchase meals for you, wouldn't he? As I said, Your Honor, I'd object as vague as to time. Mr. Gessler says, I'll rephrase it. The court says, sustained. Before his parents' homicides, Lyle Menendez would purchase things for you at dinners, wouldn't he? Objection, irrelevant. Overruled. As I've said, I don't recall who paid. I was under the distinct impression that at the time we were paying for ourselves. Did you come from the same town at one point that Lyle Menendez had lived in? Objection, irrelevant, overruled. My home was contagious with a town that Lyle had grown up in for a period of years. Contagious. Not contagious. Contagious. Now my brain is tired. I'm sorry. Apologies. Mr. Gessler continues. And what was your town? Suffern, New York. What was the town that Lyle Menendez grew up in for a period of years? Objection irrelevant, overruled. Muncie, New York, says the witness. And you and Lyle took a trip up there for old time's sake, didn't you? Objection irrelevant and outside the scope. The court says perhaps we could have a time frame. Mr. Gessler says approximately, let me back up one day. Did you and Lyle Menendez get a dog? Objection irrelevant. The court says again, what time frame are we talking about? Mr. Gessler says on approximately May the 1st, Before his parents' homicide, did you and Lyle Menendez get a dog? Objection, irrelevant, overruled. The witness says yes. Did you name that dog something? Yes. And what did you name it? Objection, irrelevant, overruled. The name, according to the witness, is Muncie, as in the town that Lyle grew up in. All right, so by Mr. Gessler, so the next question is, why did you pick that name? Objection, irrelevant, overruled. He says, because a few weeks previous we had made a trip back to my hometown, and in driving through, Lyle seemed to recognize some of the buildings and said, "How far is Muncie from here?" And I said, "It's just up the road. I played hockey in Muncie." So we found it interesting that we had been friends for so long and didn't know that he had lived for a period of time literally a mile and a half from my house. Sort of a bonding experience. Now, it was Lyle Menendez who purchased the dog, didn't he? Yes. Purchased it on his credit card? Yes. But then you and he both shared the dog. Is that right? Yes. Objection, irrelevant, overruled. Witness says yes. Wasn't it the day before the dog was purchased that you went up there on your trip to Muncie? Could be. And on that trip, didn't Lyle Menendez buy you lunch at a place there on his credit card? Objection, irrelevant, overruled. I don't know why she keeps objecting to these because they keep getting overruled, but keep drawing attention to it, lady. I don't know. The witness says, I don't recall. We went out, actually. We went out to dinner that evening. Mr. Gessler says, was it a Japanese steak place? Yes. About $55 bill. Could be. I don't recall. Your Honor, I'm going to object to this line of questioning and ask to be heard. The court says, okay, the objection on grounds is of irrelevancy. Right. Overruled. Mr. Gessler says, is that correct? I don't recall how much the dinner was for. I remember having dinner with him in the Japanese restaurant. I don't recall who paid for it. He did. Okay. Your Honor, I'm going to ask to be heard at this time, says Ms. Nahara. The court says on the same objection. Ms. Nahara says on the same issue, and there's some information I think needs to be discussed. The court says, okay, perhaps we can go on to something else, and then we can take a break, Mr. Gessler, and deal with that. Come back to it. Mr. Gessler says, by the way, Lyle Menendez had fairly nice clothes in the room there, didn't he? Yes. Had a leather jacket? Yes. This is all before his parents' homicides? Yes. He had nice furnishings in his room? Yes. Some of those things were in his own personal property, right? Yes, they weren't the university's furniture, that's for sure. They weren't university issue, were they? No. Kind of a nice, comfortable room to come socialize in. Yes. Small, but comfortable. The wallet that Donovan Goudreau had that sat on the shelf the whole year that he was, or the whole semester that he was staying there with Lyle Menendez, didn't he? Yes, that's correct. Was this what was the plastic container you've talked about? I just remember it was like a black plastic thing where pens were kept and that type of thing, and the wallet would sit up there on the shelf on the black plastic container. It's vague, but I remember the shelving unit and there were like little containers on it. So it was like a little desktop storage organizer thing. And that was throughout the time that Donovan Goudreau shared the room there with Lyle Menendez, that wallet, yes, and plastic container stayed there. Yes. And in the period of time after Donovan Goudreau was asked to leave, then he stayed in the same place. Let me start over. And in the period of time after Donovan Goudreau was asked to leave, then that stayed in the same place, did it? The wallet? Well, I saw it that day in Lyle's hand. Now, were you there at the time that Donovan Goudreau drove away? Yes, I believe so. Did you help him load his truck? No, I did not. Who did that? Hayden did most of that work. Did Lyle Menendez do that? Load the truck? I don't think so. That was mostly Hayden. Yes. Hayden was a pretty big guy, wasn't he? Yes. And during that period of time when Hayden was loading the truck, did you see this wallet? No. Or the plastic container that it came from? I don't remember looking specifically over at the plastic container during that time. Lyle Menendez seemed very sad during the time that Donovan was leaving, didn't he? Yes, absolutely. Kind of stood up in the corner, didn't he? Yes. And then later that day, you and Lyle Menendez looked through his wallet. Yes. Do you remember if it was that afternoon, that night? When was it? I think it was very soon after, but I just don't recall if anybody else was in the room. I don't think it was. I don't believe it was right after Donovan had driven off because I don't believe anybody else was in the room when he showed it to me. And what did you do when he showed it to you? Did you take it in your hand? We sat down on the bed next to each other and he opened it and went through it. I don't remember if I physically touched it. Did you take anything out of the wallet? No, not that I recall. So you didn't take the license? No. Did you? Certainly. Did you try to get a hold of Donovan Goudreau then and say, Donovan, you left your wallet behind? No. Did you write him and say, gosh, Donovan, your wallet's still here? No. Telephone? Anything? No. After his parents' deaths, you were with Lyle Menendez when he went and got a Porsche? Yes. Were you there when he actually closed the deal for the Porsche? I believe so. I remember him bringing over a cashier's check there as well. To the Porsche dealer? Yes. Had you been with him as he was shopping for the Porsche? Yeah, I was there on one occasion for a test drive. And in the test drive, did you drive or did Lyle drive? Lyle did. Was there another person from the Porsche dealer who also was in the car with you at the time? At the time you took it out? Yeah, I believe the woman who sold the car to him was there. And did she sit in the front seat or did she sit in the back seat behind you? I don't recall. How long a test drive did you go for? Again, I don't recall. Well, enough to leave town, see how it handled out on the country roads? Yes. See how it accelerated? Yes. See how it handled going on right-hand turns and left-hand turns? Yes, I suppose so. Nice car, wasn't it? Certainly was. And you told Lyle, hey, this is a neat car, didn't you? I told him I wasn't a big fan of Porsches, but if you're a Porsche enthusiast, it was a nice car. And he asked your advice on it, didn't he? Yes. That's when you said you didn't like Porsches, but as Porsches go, this one's okay? Yes. And he offered to even have you drive it, didn't he? No. Did he ever offer to lend it to you? No, I don't drive a stick shift to this day. Never did. He lent it to Greg Guest, didn't he? I think it was taken without his permission. As a matter of fact, I know it was taken without his permission because Lyle was quite angry afterwards when he found out that Greg drove it during that period of time. Was this a period of time when Lyle Menendez was back in California? Yes, I believe so. That Greg Guest drove his Porsche? Yes. But you didn't drive. But you didn't because you can't drive a stick shift. Correct. And you don't like Porsches. If I could drive a stick shift, I'm sure I would have enjoyed taking it on a spin, to be honest. So he asked you about the Porsche when you were on the test drive. How do you like it? Things like that? Yes. And then he asked you again when he went to close it? I don't recall specifically if he asked me when he went to close it, but I was with him when he went to close it and purchase it. So that was the second occasion, right? Yes, I believe so. In other words, it wasn't the same day. He didn't buy the Porsche the same day that he drove it. No, I don't believe so. That was a demo, wasn't it? Yes. Had a couple thousand miles on it. Yes. Now, this patio house that you've mentioned, you went to see that with Lyle Menendez also? Yes, just once. Walked through the house, did you? Yes. Was that with a realtor or just with Lyle Menendez? I don't remember a realtor being present. Was this a model home or was this an actual home that he purchased? I don't think it was a model home because Ms. Abrams says, "Excuse me, Your Honor, at this point, I believe there's a witness who should not be in the audience at this point." The court says, "Who's that? Are there any witnesses here?" "Okay, why don't you wait in the hall, please?" Ms. Abrams says, "Thank you." Who was that? I don't know, but that's interesting. Mr. Gessler says, "Did you walk through the patio home with him?" "Yes." "And he was seeking your advice on the patio home too, wasn't he?" "He was showing it to me. I'm not sure if it was already purchased at that time. My distinct impression in recollecting is that he had already purchased it." He already purchased and was showing it to me. So he already purchased the patio home. And that's my distinct recollection. However, were you there when he presented a final check for the patio home? No. Did he tell you, "I own this patio home now"? It's a lot of years ago. I'm vague as to whether I'm saying in hindsight, I think I remember that he had told me, or I was under the impression that he had already purchased it. This is 6 years later. This is your impression? Right. And you can't recall any conversation in which he specifically said, "I've bought this patio home." Correct. And when he walked around in it, did he talk to you about carpeting or things like that? Wow, I don't remember. It was also what you've referred to as a townhouse that he was looking at. Yes. Would that also be called a condo? Yeah, exactly. Do you make a difference between a condo and a townhouse in your wordage? Well, yeah, there are condominiums that are not in townhouse format, I guess. Was this a townhouse format? I'm not exactly sure what you would refer to as a townhouse. I just know we're speaking about the same thing, the condo, the townhouse, whatever. At any rate, it was a unit that you would purchase but would have management by a common owner? Exactly. And this let's call it a condo for a moment. Okay. The condo was in the same kind of area or complex as the patio home that you talked about. Yes. They were contiguous. I think they went by different names, but they were managed by the same people, I believe. Without going into detail, was Lyle Menendez trying to make up his mind which of those two he was going to buy? I don't recall. Did he tell you he was trying to make up his mind as to which of the two he was going to buy? Not that I recall. May I have just a moment, Your Honor? The court says yes. Mr. Gessler says perhaps I can come back to that at a later time. Did he ask your help between choosing the patio home and the condo as to which would be best? Not that I recall. May I have just another moment again? May we approach the bench, Your Honor, as to this reading? It'd be line 16 through 22. The court says, okay, sure. Mr. Gessler says, page 8255. The court says, I don't have that with me. The following proceedings were held out of the presence of the jury with the court. So did they send the jury out or this was a sidebar? I think this is just a sidebar because they said may we approach. All right, so the court says, I don't have that with me. The following proceedings were held. Okay. So reading 8255, line 16 through 22. Question. Did he tell you why he had two of them? Why he was buying two? Answer. I didn't really. There were two condominiums and one patio home. I don't remember a second patio home. I think he was trying to choose between two of them. I don't know that he was going to purchase the two of them. The court says, okay, what was your objection? Ms. Nahara says, I object to that. That's speculation on the witness's part. I object to the question being asked in the first instance. It should have been, sorry, hold on. I got a really bad itch and I can't read while I'm itching my eye. It should have been objected to, and I'm objecting to it now. And it shouldn't be re-asked because it's clear he doesn't have firsthand knowledge. The court says, objection overruled. What was the other thing that you wanted to get into that we were going to ask to take a break? Something to do with Mr. Gessler says, oh, I had went into some purchases that he made on the credit card the day before the day before the dog was purchased, $55 for dinner, and the witness said he didn't remember who bought it. The purchase was the court says this is in your client's credit card. Mr. Gessler says it's his credit card, yes. Court says, what's your objection? Ms. Nahara says, our objection, Your Honor, is I believe this information as to his purchase power came out in the first trial as a result of the people bringing out in their case in chief the suggestion that Lyle Menendez was cash poor at Princeton, and that was brought out with both Donovan Goodrow and with Glenn Stevens, and Donovan hit the stand before Glenn Stevens in the first trial. That has not been brought out in the people's case in chief. And if counsel want to establish independently in their case in chief that the defendant had a lot of money before his parents' lives were taken, that would be something that would be more appropriate for their case in chief since we haven't opened the door. So you're trying to say that money is a motive, yet you're not bringing in the fact that his parents have money? I'm sorry, what? You're all of a sudden upset that the parents have money when you're using it as your motive for the brothers to have taken the parents' lives in the first place? Ay, ay, ay. The court says, I understand what you're saying, that you've tried to establish that he was spending a lot of money after the homicides of his parents, and he's trying to show that he was spending money before the parents' homicide. That's why it would be relevant and admissible in cross-examination. Ms. Nahara says, the court cuts her off and says, this is an area that was covered, the spending habits of the defendant. This is just more spending, so he's entitled to go into it. The objection will be overruled. 2 wins for the defense there. Ms. Nahara says, okay, that was our objection is because we had tailored this much differently this time. Court says, okay, well, overruled. Court says, okay, Mr. Gessler, offer to read from this witness testimony at the prior trial, Your Honor, at page 8255, line 16 through 22. Question, did he tell you why he had 2 of them? Why he was buying 2? Answer, I didn't really. There were 2 condominiums and 1 patio. I don't remember a second patio home. I think he was trying to choose between 2 of them. I don't know that he was going to purchase 2 of them. Your Honor, I would ask the court to take judicial notice that that's an accurate reading of the witness's testimony from the first trial. Court says yes. Ms. Nahara says, for the record, Your Honor, I believe Mr. Khan mentioned there wouldn't be any stipulations during the course of trial and counsel was aware of that. Court says, as to the readings of testimony of witnesses for the purpose of impeachment or rehabilitation of the witness's testimony, either way, if counsel for either side, any lawyer, reads something from the prior record, unless there's an objection that it has been misread or that it is somehow incomplete, the court will take judicial notice that that is the record for these proceedings. He's like, I don't want to do this every time. We'll just, unless there's a correction, we'll just take it as every time you read something from the first trial, I'll take it as judicial notice. Mr. Gessler and Ms. Nahara both say, thank you, Your Honor. Mr. Gessler says, may I approach the witness, Your Honor? The court says yes. Getting back to a subject I was asking you about earlier, your visit up to the environs of Muncie, New York. Yes. I'll show you this document and ask you if it appears to reflect the purchase from J.P. O'Neill Kennel of the dog that you and Lyle then named Monsey. Yes, sir. And directing your attention to the day before the Ramapo Forum diner in Suffern, New York. Does that appear to be the diner that you and Lyle had lunch in when you were making your trip up to Muncie area? That would make sense, yes. Does that appear to be on Lyle Menendez's credit card, that purchase? Yes, it appears to be. And again on April 30th, the entry for Mount Fuji Japanese Steak in Hilburn, New Jersey, 5770. Does that appear to be the Japanese dinner that you had mentioned to us? Yes, sir. Again, this appears to be on Lyle Menendez's credit card, doesn't it? Yes, sir. And these are both incidents that is the purchase of the dog and the trip in which he bought your lunch and dinner. All those occurred before his parents' death, didn't they? Yes, sir. Do you remember when the Porsche was bought? Early September? I don't recall. During that time, you considered yourself to be good friends with Lyle Menendez, didn't you? That is after the wake that you've talked about and the memorial service. Yes. You saw him every day? I don't know if it's every day, but quite often. And he would be at the wait for a while. He would be at the what? For a while, he was at the Hyatt there outside Princeton? Yes, that's correct. And you'd go see him there. Yes. You would have dinner with him. I don't recall having dinner with him there. It's possible that it happened. Say overnight? There was one evening, yes, I stayed overnight. And did you have meals with Lyle Menendez at the Nassau Inn? The Nassau Inn? I don't recall eating at the Nassau Inn at that period of time. Did you have some meals with Lyle Menendez during the first couple of weeks after the memorial service with his parents? My best recollection would be we must have. And he paid for those, didn't he? I don't know. And you don't recall if he paid for those or not? I don't. It's possible that he did, but I don't recall. Whatever, buddy. You know he did, so just admit it. I think the problem here is that he doesn't want to admit that Lyle paid for everything because he doesn't want to admit that his only real reason for being in the friendship was for the benefits that he got out of it, like Lyle paying for things and going places and doing things like that. So I don't know. I think that's a big problem for him to have to admit that because I, I think with the way that Jose and Kitty were and how image was everything, I honestly believe that they allowed Lyle and Erik to spend money to impress people, like to make friends and to do things like that. I don't think that they had any problem with that, to be honest. And if they did, that was between Lyle and Jose, and that never even came into trial. So I don't think there was ever really an issue, other than when he was flying back and forth from New Jersey um, to LA, and his dad got pissed that he was flying himself, his friends, like it was happening too frequently. He didn't like it. That he was spending too much and doing it too often. But other than that, like he never those were the only times that they ever complained about the boys spending money, as far as I know. So I really think and believe that the values that they did instill in the brothers, I think it allowed them to become generous souls because eh, to impress people and to be able to have that money, have the means to impress people, and a rich dad who had a credit card, and you had the room that had the computer when back then, you were probably one of maybe like two or three rooms total on the university that had its own personal computer in your dorm room. You'd have to go to like a computer lab usually, especially back then. Nowadays, like everybody's got a laptop, iPad, everything, but not then. So, of course, people wanted to be around people like Lyle and Erik because they had the nice things, they had the money. So, to me, this just really proves like the friends might not have been real friends, especially the way that they're coming off here. I don't know. What do you guys think? I don't know. I'm just kind of rambling, but those were some thoughts that I was having about growing up rich. Like, I'm sure it's not the easiest thing for a kid. Like, okay, yeah, it's nice, but you don't know who your real friends are. And are they with you because they like you, or are they with you because of what you can give them? So that was probably difficult too growing up. And I know that's like the least of the worries growing up in the Menendez home, but still. Anywho, let's move on. So he doesn't remember. It's possible, but he doesn't recall. He doesn't recall anything here. So you continued to do many things with Lyle Menendez throughout the fall, didn't you? Yes. You were very close to him? Yes. He was your friend? Yes. You were his friend? Yes. And you would accompany him as he looked at the patio home and the condo and the Porsche that you told us about? Yes. And during that same period of time, you were spying for the police, weren't you? Objection argumentative. Overruled. No, sir. No. No, sir. Could you use the word informing for the police? Would you do that? I had during that course of time, I had spoken to the police on a few occasions. The police, meaning Detective Zoeller from the Beverly Hills Police Department. Detective Zoeller and Detective Linehan came out in early September to the university to interview me. And after that, you called them several times, didn't you? I believe on two occasions between that September and the arrest. September 18th, did you talk to Detective Zoeller on that day? Yes. And that's during the period of time that you were looking at patio homes and getting the Porsche and doing different things with Lyle Menendez. Lyle was back in Los Angeles at the time that they came, but yes, it was during that same time period. Before and after? Yes. And at the time that you told the police, gee, Lyle Menendez is spending too much money, didn't you? Yes. This is when you were going with him during these times? Yes. And telling the police about him spending money? Yes. You developed a pretty good relationship with Detective Zoeller, didn't you? Later on, yes. Kind of felt he became your friend too, didn't you? Yes. When you came out to testify at the grand jury, he took you to a topless bar? Yes, that's true. What? On what planet is it all right for the lead investigator to be taking out these young, impressionable men to gentlemen's clubs to talk about witnesses in this case? Under what circumstances is that ethically okay? I don't get it. It almost seems like he's trying to sway him a certain way. Testify for me, testify this way for me. So, don't testify for your friend or for the defense. Come and talk to me, tell me all you know and testify for the prosecution. That's what that says to me. I think Zoller perhaps crossed some boundaries, befriended this kid, this young impressionable kid, because that's what he is. He's a college student and tried to get into his head. I don't know. What do you guys think about that? Wouldn't be, I'm sure, the first or the last time. All right, so he took you out for some drinks? Yes. Ms. Nahara, I'm going to object as irrelevant. Overruled. Good. This is all relevant. It's like he's trying to get a particular testimony out of this witness. Yikes, this is so problematic. All right, so Mr. Gessler says, in fact, you gave some information to a reporter from the Los Angeles Times about Lyle Menendez, didn't you? Yes. Mr. Johnson, I believe so. Who was writing a book? Well, he called me in preparation for an article he was doing on a follow up of how the brothers were getting along after the parents' homicides. And you told Mr. Johnson that Lyle was being condescending to you. I told Detective Zeller that Detective Zeller asked me if Lyle had changed and I said he was acting strange or if he had changed. I said yes, he was acting different toward me, and when the press called, they had asked me if the detectives had come out and interviewed me, and I told them yes. That was not answering the question. When you told the detectives Lyle was acting differently towards you, what did you say? That he was acting condescending? That he was spending a lot of money and acting condescending, yes. In what way was he condescending towards you, Mr. Stevens? Well, he would often snap at me and berate me like I was his employee. Were you at that time? No. Did you come back for more? I'm going to object. It's argumentative. Maybe he did. Maybe that was some of his I mean, if this is even true, maybe he learned some behaviors from growing up in his house where he, has a short temper and things. But that doesn't make him that doesn't make him a horrible person for having coping mechanisms because that's what it is. Anywho, so Ms. Nahara objects. The court says it's unclear what you mean. Mr. Gessler says when Lyle Menendez was snapping at you and treating you condescendingly, did you cut off the friendship at that point? No. So you continued to pretend to be his friend. I gave him the benefit of the doubt because his parents had just been their lives had just been taken, and who knows how people act, after something like that. So when you were with Lyle Menendez as your friend here, you were giving him the benefit of the doubt, is that right? Yes. But when you were talking to Detective Zoller about him, you were saying he's being condescending and arrogant and spending a lot of money, right? I was answering truthfully as I was asked. Did you tell Lyle Menendez, gosh, I told Detective Zoller I think they're spending too much money and you should be nicer to me? No. Did you mention to Lyle Menendez at all that you talked to Detective Zoller? No. Then when you talked to Mr. Johnson, you felt he was going to print it in the newspaper, didn't you? Yes. And he was going to say that Glenn Stevens said that his friend Lyle Menendez was being condescending and spending money. I was afraid that Mr. Johnson was going to print that the brothers were suspects. Well, you were also afraid that he was going to name you in some way, weren't you? Yes, in that article. Yes, and make you look bad in the eyes of your friend, Lyle Menendez. Yes. So you called Detective Zoller about that, didn't you? Yes, that's true. And you discussed that with Detective Zoller. Yes. And you said to Detective Zoller, well, if they print my name in the article as saying something about Lyle Menendez, I'll just lie and say I didn't say it. No, I said I'll just make it sound as if it was out of context. So did you say I'll say I was misquoted? Something to that effect. There are notes that Detective Zoller wrote of that. Actually, there's transcripts of that conversation. So something to the effect that if you got caught and your name was got printed in the paper, you'd tell your friend Lyle Menendez you'd been misquoted. Yes. So you hadn't been misquoted, had you? Well, no. I was never actually quoted, I don't think, but no, I hadn't been misquoted. But you were willing to lie to your friend Lyle Menendez and say, gosh, I never said that. Yes, that's true. And this is during the time that you were still his best friend? Yes, that's true. Although the fall of 1989, you were his best friend, weren't you? Yes, that's true. During that period of time, he was talking about giving you a job, helping in business with him. Yes. Helping him decide what investments to make. Yes. And as Mr. Menendez, Lyle Menendez, was telling you that, gee, why don't you come work with me? You were telling Detective Zoeller, gee, Lyle Menendez is spending too much money. I told him that on the occasion on September 18th, yes. And how old were you during the fall of 1989? As I say, probably 20. Probably, you don't know your own age. And you had a lot of background in investments, did you? No. A lot of background in real estate purchases? No. So, what expertise was it that you were going to bring to Lyle Menendez to earn this $50,000 a year that you're talking about? Ms. Nahara says, I'm going to object, assumes a fact, not an evidence, overruled. He talked about it in his direct examination. How's that not? Mm. Okay, Ms. Nahara. The witness says there was no specific expertise as far as the business ventures. So what were you going to do for that $50,000 a year? I was going to, like I said, act as his bag carrier, wingman. He wanted some input, some common sense, I guess. Input on real estate investments. Yes, he needed help. He couldn't do it himself. And you were going to offer that help. Yes. And what? Had you had a business course once at Princeton? Not even. Not even that? No. So you felt basically he was offering you a $50,000 job a year because you were his friend, didn't you? Well, yes. Certainly the friendship had something to do with it, not to mention the fact that, like I said, he needed help. He wanted to get into a lot of different things. He couldn't do it all on his own, and well, what things was he going to get into that he couldn't do on his own that you had experience and expertise to help him with? No, I didn't say it was logical. I just simply said that he asked me for my help. And when he asked for your help, as you said, you thought this was because you were his friend that he asked you instead of someone who did have some experience in the field, wasn't it? Oh, certainly. And when he talked to you about helping him in business and investments and things like that, did you say, no, Lyle, I don't think I should do that because I think you're spending too much money and I'm really working with the police? No, I did not. Did you say, gee, Lyle, yes, that sounds good and I'll take that $50,000 job offer? No, it took place over a period of many months that I decided to go ahead and finally work for him. In fact, at a certain point in time, he had written me off as not having agreed to do that. So you were planning on taking a year off, weren't you? Yes, at the end of my sophomore year, I discussed it with my parents. You were planning on doing that before the business opportunity with Lyle Menendez arose? Yes, that's correct. So the business opportunity just accelerated it slightly. Yes, it became convenience. So when Lyle Menendez was doing some negotiating to buy Chuck's, that's the chicken wing place, isn't it? Yes, you were involved. Yes, that's true. And those negotiations, they took place in what, November and December of 1989? Yeah, most likely. And the restaurant was purchased in January, so the negotiations you were involved with while you were still a student at Princeton. Well, he brought me along a few times to speak to Gus, the one of the managers at the restaurant. The actual business transaction, I was only there once, and that was at the presentation of the check. Well, were you there in some of the business transactions leading up to the purchase? No, I don't believe so. Did you ever meet with Carlos Baralt concerning this purchase of the chicken wing place? I spent a great deal of time at the Baralt's house on and off with Lyle. We'd go there for dinner and speak with the family, and I'm quite sure that the restaurant discussion came up during that time. Were you involved with Steve Goldberg at that time during those discussions? I don't remember when I met Steve Goldberg. Were you involved in any negotiations concerning buying the chicken wing place with Steve Goldberg? Not that I know of. So the only thing you know about the chicken wing purchase is you were there when Lyle Menendez presented a check. Well, we had discussed it several times before with business negotiations, with the parties, the owners, the sellers of the restaurant. No, not that I remember. It's possible, but I don't, like I said, I don't recall. Huh? So when you say we had discussed it, you mean you and Lyle Menendez and the sellers of the business all discussed it? No, myself, Lyle Menendez, and his uncle and aunt, and I think I may have met the owner of the restaurant once before it was actually purchased. What I want to know is, were you ever present when the owner of the restaurant and Lyle Menendez or somebody on his behalf were discussing the purchase of the restaurant? I don't recall. What were you adding at that point to the restaurant business? Well, nothing. I wasn't in his employment at the time. I was just basically being a friend, and I remember distinctly telling him that I thought the price of the restaurant was expensive. Did you tell that to Mr. Baralt? It's possible. So Mr. Baralt was the executor of the will, as you understood it, wasn't he? Yes. And this was estate funds that were being used for this purchase. As far as I knew. I thought it was from the insurance policy, actually. Then you left Princeton in about February? Yes. And how many weeks of the semester had passed when you left Princeton to go into Lyle Menendez's employ? Probably 3 or 4. And when did this semester begin? The first week of February. So this was late February when you left Princeton. I believe so. And the restaurant had already been purchased? Yes. Is there some reason why you didn't just leave began at the beginning that semester began to work for Lyle instead of waiting until you were already into your classes? Well, my parents had convinced me that I should probably wait until the end of the year to leave school. And then Lyle Menendez convinced you otherwise? Yes, I guess that was the case. So did you tell the Princeton authorities why you were leaving school? I told them, well, there were several reasons why I wanted to take some time off of school, and I told them, yes, why I wanted to take a year off from school. So you told them that you wanted to take the year off from school to go help Lyle Menendez with his business ventures. I don't believe I mentioned that, no. Then what did you mention? I told them that I wasn't quite happy at school, I was burnt out, I was going through a period of depression, and that I thought it would be a good idea for me to take a year off. And that's what you told the authorities at Princeton. Yes. Depressed, burnt out, needed a year off. Yes. Did they agree? I don't know. They told you you could come back in a year, didn't they? Yes. So they accepted your reason, apparently. Objection calls for speculation on what the Princeton authorities thought. The court sustains that. Mr. Gessler continues. Was the reason you gave the Princeton authorities true? Yes. So, in other words, you were burnt out, depressed, and felt you needed a year off. Yes, that's true. And that's what you told them. Yes. It was true. Yes. And that's what you did. Yes. But in taking the year off because you were depressed, burnt out, and wanted the year off, you got Lyle Menendez to promise you $8,000 for doing what you wanted to do anyway. Well, because the timing had made it expensive. The timing for you being depressed and burnt out made it expensive? No, I was going to take the year off at the end of the year, but I had already started the semester, and if I was going to leave, he was going to have to cover my costs or cover some costs. I guess I don't understand. You told Princeton that you were burnt out and depressed, and the time that you felt or the time that you left, didn't you? That's true. You didn't tell them that you were going to be burnt out and depressed in another 4 months so that you could take off at the end of the year. Objection, argumentative, overruled. I could have waited till the end of the year to make it more feasible for my parents. But you didn't tell Princeton that when you left. No. You said, I'm burnt out now, I'm depressed now, I want to leave now. Yes. And along with that, you got Lyle Menendez to pay you, or promise to pay you, $8,000. Yes, that's true. And that's because your parents were out $2,000 on the tuition they paid. As well as, like I said, some student loans were going to come due. I don't remember how we agreed to that figure, but it was an agreement that we sat down and came to. The student loans that were due were for prior years in college, weren't they? Yes, that's true. For the first semester there. Yes, that's true. That had nothing to do with Lyle Menendez, did they? That's true. The only thing you were giving up at that particular point was the 2000 that was non-refundable on the tuition, as well as expenses for books and the like. That's true. And how did you pay for books? Or how much did you pay for books? 6,000? No. A couple of $100s? Probably. Did you sell them back to the bookstore as used books then? I don't believe so. It's possible. I don't know. So you were out 2,200 out of pocket when you left because you were depressed and burnt out, right? Yes. Is this a good place to take the noon recess, Your Honor? I will be going for a while. The court says, okay, we'll take our recess and resume at 1:30. Don't discuss this matter with anyone. Don't form any final opinions. We'll resume at 1:30. All right, so we come back. The court says, we're ready to resume. Get the jury out. Court says, Mr. Stevens, get back on the witness stand. You may continue your cross-examination. Mr. Gessler continues. Mr. Steven, you've been known to embellish or exaggerate at times, haven't you? Yes, I know what you're referring to. Yes. The answer is yes. Yes. And when is it all right, in your view, to exaggerate or embellish? That's a tough question. I'm not sure it is all right. Well, you've done it from time to time. Yes, I would have to say that. Yes. And you would say that exaggerate or embellish means to stretch the truth, wouldn't you? Yes. And in fact, on your resume, you stretched the truth, didn't you? I have to clarify that's not exactly my resume. May I approach the witness, Your Honor? Yes. Let me show you what has previously been marked exhibit number 59. Does that have your name at the top, Glenn Stevens? It certainly does. And is that a resume that you have submitted to employers from time to time? That's what I'm not sure about. I don't recall a specific instance where I submitted that resume to an employer. Did you have this resume typed up? It was written by by a girlfriend of mine with a well-intentioned attempt to help me find a job. So he straight up lies on his resume, but he blames it then on his girlfriend and says it was just to help him find a job. Well, isn't that what a resume is for? I think if I was the girlfriend, I would have dumped him. And did you find a job with it? I don't believe so. Like I said, I don't recall a specific instance where I've used that resume. Did you have another resume that you submitted to somebody? Well, obviously, in the course of my lifetime, yes, I've submitted resumes that have procured employment for me. Yes. And at the time that you graduated from Princeton, did you have another resume besides this one? I'm sure I did. On this resume, did you put down that you had been the manager of operations at Chuck's Cafe restaurant? I don't recall. I don't recall. On the resume I'm showing you here, this resume that says Glenn Stevens on it. Yes. On this document that you're looking at, does it say that you kept accounting records of the business grossing $1 million annually? Yes, it does. But you didn't keep accounting records at Chuck's, did you? No. How much did Chuck's gross annually? I don't recall approximately. My guess would be about 700,000 annually. So 700,000 annually. Uh-huh. Before we purchased it, the defendant purchased it. So we, like it's his. He says we. And what about while you were managing it? I have no idea. So you were the manager and you don't know how much business you were doing? No. Well, by the time I took the restaurant over, business had dropped off considerably. So that 4 months that you took it over. Uh-huh. Do you know who Mr. Harry Mansman is? I think he's the accountant. That's the accountant? Yes, I do know who Harry Mansman is. And he's the one who came in to check the records of the business? He's the one who had to turn over the records to on he's the one we had to turn over the records to on a weekly basis for him to put them in a ledger. And at that time that he took it over, it appeared that the records of sale was down for that time that you were managing. Yes, that's true. After the arrest, the business floundered. But the purchases that you made hadn't gone down, had it? That is, the food that you purchased to sell? I don't know what the costs were. Gus was responsible for the purchases. What did you do as a manager? Basically, I was overseeing some of the payroll for some of the employees there. I was there every day, basically from 2 until 7, or 11, sorry, 2 until 11, just running the place. But in running the place, you don't know if the purchases that you made were down any from the year before? No, I don't recall. And you said you did payroll for some of the employees? Yes. How many employees were there? Well, there were, I guess, basically 4 or 5 full-time employees there. How many of the 4 or 5 were you doing the payroll for? Well, I was responsible for overseeing, for basically hiring people, making sure that that there were enough people working there and the like. Out of the 4 or 5, all of them. Well, on the document that bears your name here as resume, it says you supervised the payroll of 20 restaurant employees, didn't you? There was also a staff of 10 or 15 drivers that were responsible for doing deliveries and the like. So 10 or 15 drivers. Yeah, there were university students that would come in and work one night a week to deliver chicken wings to the university. And you provided 15 cars to them, did you? No, there was a little Volkswagen that they occasionally used. Some of them used their own car. So they didn't all drive the same Volkswagen at the same time, did they? No. So on this document, did you put down that you were a recipient of the Yale Book Award in June of 1989? 88, sorry, 88. Again, like I said, I didn't write this, but it's there. Is that true? That you weren't the recipient of the Yale Book Award? That's correct. Was there such a thing as a Yale Book Award? My guess is there was. From your high school? Yes. And do you know where the person who wrote this got the information that you might have won it? No. Well, the person who wrote it didn't get the information from me, that's for sure. Okay. Girlfriend, please leave him if you haven't already. I'm sure she did. I sure hope they're not married to this day. The actual Yale Book Award, the year that you graduated from high school, was won by Susanna Bridget Baker, wasn't it? Yes. Ms. Nahara, objection, irrelevant. Court says overruled. Mr. Gessler says yes. In fact, there's about 22 awards listed here from your high school. Objection, overruled. And you're not on any of them. I don't believe so. Why don't you check? No, I'm sure I wasn't. It's like, no, I don't need to check. I know I'm not. You caught me. And on this non-resume we're looking at here, you put yourself down, or somebody did, that you were valedictorian, didn't they? It says that. It's not true, is it? No. Also, on this document it says that you solicited over $200,000 in new customers for the Kemlin Services Corporation. I worked for them for a summer. I solicited a number of new accounts. I don't recall that if that number is accurate. Yeah, of course. Do you know it's nowhere near 200,000? Don't you? Actually, I'm not sure of that. So you're not sure of that? No. And you're not sure you ever submitted this to any employers? No, I don't recall. It also says in the document that you were a member of the Princeton peer tutoring program. Yeah, that's not true. It's on the document, isn't it? Yes, but it's not true. You were not a member of the Princeton peer tutoring program. That's correct. And for the Hudson metal fabricating plant, it says that you supervised the technical work of over 40 employees. Did you see that there? Yes, I do. But that's not true, is it? Well, I don't know the number of employees I supervised in technical work for a section of the plant. I don't know the number of employees. Was it more than 5 or 6? I don't recall. You don't recall the difference between 5 or 6 or 40? I do. May I have just a moment, Your Honor? Directing the court's attention, Your Honor, to 8333, lines 19 through 28. That would be lines 19 through 28, Your Honor, reading from your prior testimony in this matter, Mr. Stevens. Ms. Nahara says, "Excuse me, Mr. Gessler, I'd ask that you start at line 16. Mr. Gessler says, "All right," at line 16. The witness says, "I have to clarify, though, I didn't write it. My girlfriend at the time wrote it." Question: Did you give it to people when you were seeking employment? Answer: Yes, I did. Question: Did you read it before you gave it to them? Answer: Yes, I did. Question: Did you know you were presenting a false picture of yourself? Answer: Yes, that's correct. I probably would have been stupid not to. This was from, I believe, the first trial. And would the court take judicial notice that this is an accurate reading of the transcript, Your Honor? Court says yes. So that's how you impeach a witness. That's how you catch him in a lie. All right, so Mr. Gessler says, "Do you recall now testifying that way 2 years ago, Mr. Stevens?" Yes, I recall that. I read the testimony this week when I came out. So you read your testimony from the last trial? Yes. And you had forgotten between the time that you read the testimony and the time that you testified under oath today that that's what you had said 2 years ago? No. I remember saying that, but I don't recall specifically giving that to the employers. I don't know why I said it that date. I have no specific recollection of giving that resume to employers. I call BS on that one. So 2 years ago, when you testified, did you have a specific recollection of giving it to employers? I don't know. I was a bit flustered. You were just winging it. Ms. Harris says, "I'm going to object, Your Honor. That's argumentative." Overruled. He's like, "Yeah, go ahead." He lied. Let him go. The witness says, "I'm trying very hard to answer truthfully. I don't know why I said that, but I don't recall. It's possible that I did. I would be lying if I said that I absolutely didn't give it to employers. I don't remember." Yes. The truth hasn't changed in the last 2 years, then, has it? No, the truth certainly hasn't changed. Now, the $8,000 bonus that you say Lyle Menendez promised to you to make up for your $2,000 loss of tuition, did you tell Lyle Menendez you were out $8,000 to get that bonus? No, I don't believe so. We sat down with my parents and worked out a contract based upon what they thought was fair for me to leave school. What you worked out in that contract was that Lyle Menendez would pay you the $2,000 lost tuition, wasn't it? In addition to another portion of money for the other 6,000, which was also part of that. It was supposed to be an $8,000 payment. Was this all worked out in a written document of some kind? No. We sat down, like I said, with my parents and agreed to it on a handshake. We didn't have any lawyers or a contract or anything like that. And your recollection now of what you agreed to is $8,000, not two? Oh, I know that to be the case, says the witness. Ms. Nahara says, I'd object, Your Honor, it's not inconsistent. The court says, I'm going to overrule the objection. You can read it. Mr. Gessler says, Mr. Stevens, reading from your prior testimony at page 8359, line 15, question. Had you already paid a portion of your tuition? Answer. For that semester, yes, I had. I was already about 2 weeks into the semester when I left and had to forfeit, I believe. It was around something like $2,000. Question. Was any representation made to you by Lyle Menendez as to giving you money for the $2,000 loss? Answer. He was supposed to. He came to my house one night, sat down with my parents and myself, and worked out an arrangement that he was to be responsible for that. Question. Did he ever? Answer. If I was going to leave school and be in his employment, he was going to have to be responsible for that because my parents refused to let me leave school unless he would cover whatever cost it would cost me to leave. Question. Did you ever get your $2,000? Answer. No. Would the court take judicial notice that that's an accurate reading of the portion of the witness's testimony? The court says again, rather than each occasion, the court will just take judicial notice of the fact that the transcript has been accurately read and that this is the record in this case from the previous proceedings unless opposing counsel indicate that it has not been read accurately. All right, so Mr. Gessler says, did you also brag that you had some family members or friends who were in the mafia? No. Ms. Nahara says, I'm going to object as irrelevant. The court says, how is that irrelevant when you're talking about a mafia hit in this case? Ms. Nahara, or the court says, overruled. Mr. Gessler says, did you ever talk at Princeton about having a good friend or your father's that he called Uncle Fat Tony? No, he was Fat Tony. What I was referring to was a friend of my grandfather's 40 years ago or so, and there was a Fat Tony Salerno? No, and that he was quite well known, and at the time he had recently been put in prison, and I had mentioned to several people that he had been a friend of my grandfather's. At Princeton, did you mention this to the people at Princeton? Yes. So Lyle Menendez was among them. That's possible. And this was Mr. Negri, you said, in New York City. Yes. You set that up, didn't you? Yes. And he was somebody that was known to you rather than to Lyle? That's true. Now, Lyle Menendez hadn't mentioned to you anything about fearing the mafia, had he? Didn't that come from Richard Winskoski? He told me that he feared for his life. I'm not sure that he ever made a reference to the mafia, and I'm not sure if Richard made that reference. There was no mention of mob, mafia, organized crime, simply that he feared for his life? Yes. So you had come out to Los Angeles, I think you said Christmas 1989. Yes. And that's a trip that was paid for by Lyle Menendez. Yes. Incidentally, at the time, the Alfa Romeo was in the shop for repairs, wasn't it? Yes, that's true. Well, no, it was there in the parking garage, but it wasn't running. So maybe it was a piece of crap. If it wasn't running, ay, ay, ay. Okay. And this trap was paid for by Lyle. That was a gift from him. He didn't ask you to repay that? That's true. Then when you came out in March, he paid for your plane fare out too. Well, at that point, I was in his employment and this was a business trip, so the business was paid for. Yeah. Do the business Did the business buy a round trip ticket? No. Just a one-way out to Los Angeles? Yes. It was on that trip that he gave you and Hayden $2,000 for possible bail money? I don't remember the exact number, but it was something like that. And for you to call Jerry Shaliff if anything happened to him. Yes, and that he said the money was to be used for bail or something used for his benefit. Yeah, he made reference to that fact. And of the $2,000, you got more than half, didn't you? Yes. So how much did you get? As I said before, it was around 12 or 1400. And of that 12 to 1400, did you try to arrange bail for Lyle for Mr. Menendez? I called Uncle Carlos, who told me not to worry about it, that it was being taken care of. That was about within a half hour after the arrests. And did you give the 12 to 1400 to Mr. Shaliff? No, Uncle Carlos told us to keep it to finance our trip home. Now, at the time, it wasn't any longer 1200 or 1400. Over the course of the weekend of the trip, Lyle had taken several $100s of that back from us for various things. I don't remember how much was left at that point. So you took a car to get home. There was another gentleman out there by the name of Cole Kruger who was supposed to drive back with us. There was a Porsche Lyle was going to drive back, and he was to drive back his car. So we were going to make the cross-country trip together. So we used that money to finance Cole, myself, and Hayden's trip back. It cost you that much money for gas? No, well, it took over a week. We stayed in hotels. Like I said, it wasn't $1,200 left. Did you refund any of that money that was left after the trip to the estate? There wasn't any money left. So spent it all on the trip back. Yes, we got back to North Carolina and I flew the rest of the way. And that was several $100s. And you were wearing the submariner watch when Lyle was arrested. Yes. And that's the one that your father sold? Yes. And you never returned any of the money from that sale to Carlos Perrault or to the estate, did you? No, I did not. And at the time, you were out here for the funeral, weren't you? No, not out here. I'm sorry, you were out here at the time that Lyle Menendez was arrested? Yes. And after his arrest, you took some clothing out of the family home, didn't you? No, that's not true. You didn't take any suits, shoes, or anything else out of the house at the time? No, not myself, no. Not yourself. I didn't. Did you participate with somebody else in doing that? The wording here is very sus. No, I witnessed somebody else take clothes out of the house. I myself didn't take anything. So who was that? That was Cole Kruger. And you yourself didn't wear any of the clothes? Use any of those clothes? Absolutely not. Wear those shoes? Anything like that? No. You had an apartment as part of the arrangement that you made for your work there, the business. There was an apartment that Lyle had been living in that we took over, Gus and I took over the lease on, yes. And that was to come out of part of your $600 a week, wasn't it? Yes. Did you ever make any payments on that apartment? Yes, I paid rent monthly. You did pay? Yes. To the condo owner? Yes. How many times did you pay rent there? I don't remember how many months I lived there. Probably three months. I don't recall. May I approach the witness, Your Honor, for a moment? Uh, he says yes. Mr. Harris says, may I approach as well, Your Honor? Court says yes. Mr. Gessler says, page 8323, lines 13 through 18. Would you just read that part to yourself? The witness does. 13 to 18? Yeah. Mr. Gessler says, have you read that? Uh-huh, yeah. And at the time that you were asked this before, did you say, I really don't recall? I don't recall how many times I paid rent between March and the July, and that's still the truth. I don't recall how many times between March and July I paid rent. You had a car as part of your deal there? Again, I paid for myself with the exception, well, our original deal was that he was supposed to finance a car for me, but again, that never happened. Well, was a down payment made on the car? Yes. And did you make the down payment? No, that came out of the business. So when you got the car to drive, it had already had a down payment made on it. Yes, that's true. So how many payments did you have to make on it after that? I made the rest of the payments. It's a 3 or 4 year loan, and I paid out the whole price of the car beyond the down payment. Was this a Chevrolet or a Ford? It was a used Volvo, 1984 Volvo. What kind? 760 GLE. With accessories? Oh, accessories, yes, correct. All the GLEs come with that. So where's the car now? The car was totaled. Did you recover insurance? Sure. $10,000? No, not even close. 4 or 5,000, whatever the blue book value of the car was. When did it get totaled? Objection, irrelevant, overruled. My junior year in school, a couple of years later. Your junior year would have been about 1991? Something like that, 91, 92. Trying to think now. No, it must have been in 93 because the car that I've since leased is a 93 model. So the money that you got back from that insurance, did you give any of that back to the estate to make up for the down payment? No. Kept that just for yourself? It was my money. The down payment was your money? It was originally part of our deal. The fact that they reneged on the deal doesn't mean I have to give them back the money afterwards. Okay, buddy. So you kept the money because you felt you'd been kind of put upon by Lyle and by the estate. Deceived and betrayed. Well, there you have it. There's his motivation as to why he's testifying the way he is. Ms. Harris says objection misstates the statement of the witness. No. Overruled. The answer will stand. Mr. Gessler says when you took over the management of the business, the proceeds went down from 1,800 to about 500, didn't they? I have no knowledge of that. I don't remember what the proceeds were. Like I said, after the arrests, business was way down, obviously because of the publicity. Remember, I took over the restaurant the day after or the week after the arrests. And at one point, you started to put IOUs into the cash register? That's true. I had become aware of the fact that they were going to renege on my contract, and basically, I would be out the 8,000 that I had been promised and promised and promised. So yes, I put IOUs in the register in exchange for cash over the course of, say, the last 6 weeks there, totaling about $200 with no intent, honestly, with no intent to pay it back because I had become aware of this. So you just admitted on the stand that you were stealing from your employer. I'm just pointing this out. You were stealing from your employer because you were mad at them. This is good cross. This is really good cross. The whole total was $200 over 6 weeks? Yes. How is that going to make up your $8,000? Well, it wasn't, but I was really concerned about my next car payment being stuck for that. So let's see. You had the watch that was sold. You made up part of that 8,000 that made up part of that $8,000, I take it. That's true. So you still had the Volvo that the company had made the down payment on at the time. That's true. You kept that and made the payments. Uh-huh. And you were still living in his apartment, right? Paying rent. Except you don't remember how many times. I couldn't recall at the time how many months I lived there. You still had whatever was left over of the bail money, if anything? That's true. Although you just told us that there was nothing left. So there's that. So you had the IOUs in the register that you had taken the money for. Uh-huh. And then you stole some on top of that, didn't you? No, that's not true. Again, I testified. I guess I answered a question fleetingly at the moment last time, but no, I didn't take any money aside from money it would have been impossible because the register receipts had to match up with cash at the end of the day. You just told us you stole money and put IOUs in the register. Now, this last time what you said was you pilfered money, didn't you? Yes. And pilfered meant took the money, right? Yes. In fact, you told the district attorney that out at a break, didn't you? Yes. Because the defense counsel had mentioned the name of an accountant. Uh-huh. And you told the district attorney, gosh, I wonder if they're talking with the accountant because they know I stole money. The district attorney told me if they were asking about the accountant because they were trying to imply that I had embezzled money. I said I don't know. The only money I ever took was against IOUs, which she then felt compelled to bring up. Mr. Gessler says, may I have just a moment, Your Honor? The court says yes. Ms. Nahara says, I'm going to object, Your Honor. It's hearsay. I don't believe there's any question asked that relates to this. Court says, did you wish to be heard? Mr. Gessler says, I'm sorry, Your Honor. Yes, I believe it is inconsistent. Court says, all right, let's have a little discussion about it. The following proceedings were held outside the presence of the jury. So again, I think this is a quick sidebar, as they say in Massachusetts. All right, so Ms. Nahara says, withdraw the objection. I was looking at the wrong page. Mr. Gessler says, in addition, while we're here, it would be 8373, lines 4 through lines 12. Ms. Nahara says, why don't you just let me look at yours, line 4 through 12? Mr. Gessler says, yeah, that's fine. No objection. I'm sorry. Maybe I said the wrong page. Ms. Nahir says, I'm sorry. Okay, says the court. We're now back inside the presence of the jury. So that was a quick sidebar, I think. Mr. Gessler says, Your Honor, reading from this witness testimony at the last trial at 8357, line 23, question by Ms. Bazanich. Now then. Answer. You said something at the break that reminded me that during the end period that I was still in Mr. Menendez's employment, it became obvious to me that he was going to ask me to leave the restaurant and leave me in a state of financial distress. So he was mad that he might be fired. So for a few weeks there was a couple of occasions where I had pilfered some of the money from the cash register and thought that you should know that. Also, Your Honor, reading from this witness testimony at page 8373, line 4. Question. Okay, you would take money out and write IOUs sometimes, wouldn't you? Answer. IOU. Question. And put them in the register when you took money. Answer. That could be correct. I don't recall. Question. And other times you took money and didn't write IOUs. Is that correct? Answer. Yeah, well, I just admitted to that. The witness says, yeah, obviously, I was a little bit confused, but the truth is that any money that I took was against IOUs. He just or in trial one, he said that no, not always. So there's that he didn't always leave an IOU. He just took money. But now he's saying he must have been confused. The truth is that any money that I took was against IOUs, and as I testified before, it would be impossible not to because the money had to match up with the register receipts at the end of the day. Mr. Gessler says yes. What was confusing about those questions, Mr. Stevens? I don't know. When you sit up here for 7 hours, everything is confusing. What, you were there for 7 hours? Over the course of 2 days, yes, you get flustered. You mean like 2 hours one day and then a couple hours the next day? Several hours at a time. Didn't they take breaks during that time? Yes. I'm going to object as irrelevant, says Ms. Nahara. The court overrules that. This is just him making excuses. Mr. Gessler says, didn't you have a lunch that time, a lunch break? Yes. Didn't you have a mid-afternoon break? Yes. And you talked to the district attorney during those breaks? Yes. And this time, that you just testified to about taking money when you didn't leave IOUs, that came just after a break when you had talked to the district attorney, didn't you? Yes. Are you feeling flustered today or are you doing well? I'm a little or are you doing okay? He says a little bit, so he's a little flustered. Do you need a break? I'm all right. I can continue. So your mind is clear. Yeah, I'm trying. This is great. I like Mr. Gessler quite a bit in his questioning. So he goes on to say, well, if your mind becomes unclear, would you please tell me so that we can take a break and let you get a hold of yours? Stop saying things under oath that you shouldn't be. He says, certainly. You've asked a couple of people, how can I make money off this case? Haven't you? One person approached me and we discussed it, yes. Did you call a lady named Susan Seeger at the Daily Journal in the fall of 1990 and say, how can I make money on this case? I don't recall that. I never heard that name. Did you tell Bob Rand in May of 1991 that you were Lyle's best friend and wouldn't that help sell a book? Rob Rand approached me about perhaps helping him with a book. And did you say you were his best friend? Wouldn't that help sell a book? I don't recall making that statement. It's possible. Did you talk to Eric Tam about about trying to make? I spoke to Eric Tam twice. I don't recall speaking to him about anything like that. Did you say, isn't there some way to make money off this? No. If the truth, if the truth be known, I didn't make any money off of this where I possibly could have. Like you didn't make any money off of the watch and the car and the rent that you probably lived in for free, the apartment. I mean, come on, all the free meals, but whatever. If somehow he still thinks Lyle owes him, but okay. This money that you took from the business and keeping the car, the watch, that wasn't because you felt that there would be renegement on the contract, was it? Oh, sure it was. Did you tell the owner of the business that you were glad that Lyle lost it? That he lost the restaurant? Yes. I don't recall making that statement. Man, friends like these, who needs enemies? Do you know who a Mr. Aguirres is? John Aguirres? John Aguirres. He was the owner of the restaurant previously to Lyle. I guess he got it back in the default, but I don't know. I don't recall making that statement to him. As a matter of fact, I don't recall seeing him again after the actual date of the purchase. I might have, but I don't recall any particular meeting with him. Did you tell Mr. Rand that you had made a statement like that you were happy that Lyle lost the restaurant? Again, I don't recall. You might have, but you're not sure. Yes, I might have. I spoke to Bob Rand several times at length about this entire thing. Did you testify at the last trial that you were vindictive and that's why you took the money from the restaurant? I testified that I was vindictive about being deceived. Yeah. Wow, this guy does not look good. Did you say you never felt justified in taking any money from the restaurant? I said I believed that there's really no justification for that kind of behavior. But you did it anyways. Did you say that you took the money because you were vindictive? I said that I was vindictive. I don't know if I was referring to taking the money. I was vindictive basically because I felt deceived, and that's eventually when I came to believe that they had actually committed the crimes. That's Miss Amerson says, I'm going to object to that answer, Your Honor. First of all, it's non-responsive and instructs the witness not to refer to my client. The court says, well, at this point, let's start over with the question and answer. The question is stricken and non-responsive. Mr. Gessler says, reading from the witness testimony, Your Honor, at page 8374, line 14, question. And so you felt justified in making the money on your own, or taking the money on your own. Answer, I never felt justified in taking any money. I just took the money because I got vindictive. So there you have it. He testified to it himself, and now he's taking it back. The witness says, all right. That was my testimony. Mr. Gessler says, Mr. Stevens, you feel it's okay to lie in some situations, don't you? Objection, argumentative, overruled. Yes, I testified to that. And in talking about this trip that Lyle Menendez made to California, you said you had a meeting with him in a restaurant afterward. Yes, that's true. You didn't come to California with him, did you? No. You certainly never saw any will erased from a computer, did you? No, I did not. This was a conversation you had with him where he said that he had somebody to go check that computer out and erase it. Is that right? Correct. And he said that there was some headings, one of which was the word will. Yes. And did he tell you that there weren't enough letters in the computer to be an actual will? I don't recall that. I remember him telling me that it was illegible. For some reason, they couldn't read what was actually contained underneath those headings. So he never said that there was a will in the computer, did he? No, he did not. And also, did he tell you that Carlos Peralt had said any kind of document in a computer couldn't possibly be a valid will? Ms. Nahara says, I'm going to object as to what Carlos Peralt told him that was repeated. Court says overruled. Witness says, I recall hearing that at some point over the past 5 years, I don't know if he told me that on that occasion. Mr. Gessler says, did Lyle Menendez tell you that he was afraid of what his uncle Carlos Menendez might have done with that computer? I don't recall that. Now, you've also testified that you think the rules for telling the truth are different when someone may have taken the lives of their parents, haven't you? I don't recall that. I don't know what you're referring to, so no. That's Ms. Nahara says no objection. Mr. Gessler says, reading from the witness's testimony at the last trial, Your Honor, page 8365, line 2. Question. Do you think that whether you tell the truth varies on the circumstances? Is it okay to lie in some situations and not okay to lie in others? Answer. Yeah, I would say so. Question. So, in a situation like this, where you think that someone may have taken the lives of their parents, the rules are different than they are under normal circumstances? Answer. I think that would be a fair statement. Witness. Yes, what I was referring to is it's okay. You tell the truth in this circumstance as opposed to telling a white lie in other circumstances, which is okay. Mr. Gessler says, well, a white lie is something that you tell under oath? No, absolutely not. You lied at the grand jury in this case, didn't you? No, I did not deliberately lie to the grand jury in this case. Did you tell the grand jury that Lyle Menendez had never bought anything for you in Princeton before the deaths of their parents? Yes, I thought that he had never really bought me anything prior to the deaths of his parents. And you told that to the grand jury? That's true. Under oath. Yes. That was a white lie. No, I really believed that to be true. Hadn't he purchased that dog? Uh, hadn't he purchased that dog that you were partners in? So I guess his parents were alive at that time. Yes, but that wasn't purchased for me. He bought the dog for himself. Well, with you as a partner. Well, I shared some of the responsibility caring for the dog. He bought you the meals there that you talked about up in Muncie? Yes, I'd forgotten about those. He bought some meals at Princeton. Probably. You forgot about those. Yes. He bought you a belt that you admired, didn't he? That was after the deaths. The belt was after the deaths? Yes. It was a belt that cost $125. Yes. And in the testimony, it says that she asked me if it was before, and I said yes. But he handed it to me in the Porsche, so it wouldn't have been. Excuse me? You mean in the testimony in the last trial you said that the belt was bought before this happened? Yes. I answered that correctly, and I marked it and showed it to the DA yesterday. That was incorrect. because he handed it to me in the Porsche, in the parking lot, in the mall. There is a gift. He surprised me. If it was in the Porsche, it had to be after the homicides. So both before and after he tried to buy you things and you had refused to take them, he offered several times to buy me many large things and I refused. You didn't refuse the belt. No, he handed it to me. He had already purchased it. We were outside the store. I had admired it and said, "No, no, I can't take it." But he gave it to you anyways. That's true. And at the grand jury, you said you never accepted anything before or after. No, I didn't say I never accepted anything before or after. I don't think I said that. Mr. Gessler says, "Nothing further, Your Honor." The court says, "Any redirect?" And Miss Nahara says, "Yes." Miss Nahara asks, just to clear up a few things. You said that you didn't recall when you paid rent on that apartment. What did you mean by that statement? Well, I hadn't recalled exactly what period of time I had lived in the apartment and how many times, how many months was forced to pay rent for. Was forced. I like the term forced. Well, if you live there, you should pay rent, right? How is that being forced? Did you pay rent every month that you were living in the apartment? I believe so. So when you say you don't recall how many times you paid rent, you're not referring to skipping a rent payment the month that you were living there. No, I was referring to, I don't know what the time frame was that I lived there. So you said in response to a question by Mr. Gessler that you could have made payments on this case or you could have made money on this case and you didn't. Is that correct? I said most probably I could have, yes. Were there opportunities that were presented to you for a way to exploit the situation? Rob Brand had suggested that we go on a book together. Perhaps I could have easily picked up the phone if I shopped myself around. And did you do that? No. Now, you stated during cross that after Lyle Menendez's parents died, you said that he became arrogant. Do you recall that? Yes. Those weren't his words. And could you describe to the jury what you meant by this change that he had become arrogant? Well, he just had a different swagger about him. And there was one specific instance I remember. This is several months later when he had a meeting at the commercial office that he had leased where he had a group of friends together, and that some people that were working on his business ventures, and he was berating them one by one about different things. And was this the Menendez investment that you were asked about previously? It was the Menendez Investment Enterprises was the name of it. And this group of individuals that he had there, would some of these be some of his old friends from Princeton? Well, yes, Hayden was there, I believe. There was also another guy by the name of David Brose who was hired to do some paperwork and things for him. Now, when you said he berated them, did he do this in public or did he do it in private? Or how did he do it? Well, there was a group of us sitting around a conference table. It was sort of like a conference meeting. And when you described him as condescending, can you tell the jury what you meant by that? Well, exactly that. The way he would, berate us, laugh at people's suggestions as ridiculous, things like that. Yeah, can you give some examples, please? Did he laugh at people's suggestions as ridiculous? Sometimes, yes. At this time, would you have described Lyle Menendez as decisive? He made several decisions against the advice of others. Was he very decisive about what it was that he wanted? Yes, no doubt. Did you see him going out and getting things that he wanted? Yes. Mr. Gessler says, Your Honor, I'm going to object unless we have a time frame. The court says, sustained. The answer is stricken. Ms. Nahara says, You testified that on cross-examination, that the defendant had brought you a belt. Is that right? Correct. Had he been shopping when he bought you this belt for himself as well? Yes. So he bought the same belt for himself when he bought you that belt for himself as well. Yes. And did he for after the homicides at the time that you were objection to the question, Your Honor, says Ms. Abramson, and the court says rephrase. Did he after the homicides when he was back in Princeton, the time that you've described about, do a lot of shopping for himself at Princeton? Yes. Did he at one time spend approximately $11,000 in the mall? Mr. Gessler says objection as leading and suggestive. The court says sustained. Were you present when he went to the Princeton Mall and spent a lot of money? Yes. And approximately how much money did he spend? It was a lot over a period of time. There was one particular occasion where the salesman had told me that it was in excess of objection, hearsay, says Mr. Gessler. Court says sustained, answer stricken. Ms. Nair says, were you present when he spent a lot of money on himself at the Princeton Mall? Objection vague as to what a lot of money is. Sustained. How much would you view is a lot of money? What would you view as a lot of money you would spend on yourself at a mall at any one time? Anything in excess of several $100s would be a lot. So were you present when Lyle Menendez spent well in excess of $7,000? Yes. Were you present when he spent well in excess of several $1,000s? Yes. Were you present when he spent well in excess of $10,000? Well, yes. Was at the time after the homicides of Kitty and Jose Menendez, when you were spending time with Lyle Menendez, did he appear to you to be capable of making a decision? Yes. And did he sometimes ask your advice about various things he wanted to do? Yes. Did he always follow your advice? No, not always. Were there times that he didn't? Yes. And do you recall any of those times as you sit here? Yes. And where were these times that he didn't follow your advice? Well, like I said, I had objected once to the purchase price of the restaurant. I thought it was excessive. Also, I didn't think it was, I told him specifically, I thought it was unseemly for him to purchase the Porsche at the time that he did. Also, I didn't think real estate at the time was such a good investment. How is he allowed to just keep on going with this? But okay. At least not residential real estate like he was interested in purchasing. Now, despite your advice, he did purchase that restaurant, did he not? Yes. And he did purchase the Porsche. Is that right? Yes. And he did purchase real estate in Princeton. Is that right? Yes. Now, you were asked on cross-examination about some information that you provided to the police. After the homicides of Jose and Kitty Menendez, did you talk to the police? Yes. Now, in the period after the memorial service, but before the defendant Lyle Menendez was arrested, talking about August of '89 to March of 1990, in that period, did you talk to the police? Yes. And how many times did you talk to the police during that period? 3 specific times that I recall. And the first time that you talked to the police, was that in September of 1989? Yes. And why did you talk to the police in September of '89? They came to the university to interview me. And why did you talk to them? Well, because they asked me to. And at what time did you have, or at that time, did you have anything to hide? No. Did you know if the defendant Lyle Menendez had anything to hide? No. Did you think he was guilty of a crime? Not at the time. Now, sometime after that, in October of '89, did you have another conversation with the police? Yes. And why did you have a second conversation with police? Mr. Gessler says, objection, irrelevant. The court sustains that. Ms. Nahara says, in October of 89, did you, as Mr. Gessler asked, inform on Lyle Menendez in any way? What's the date? October of 1989. No. Did you talk to police on that time about something that was happening in your life? Yes. And what did you tell them? Objection, irrelevant, sustained. In the next two times that you spoke to police, did you talk to them about anything having to do with did you talk to them about Lyle Menendez? Well, yes, obviously the subject came up. Was he the focus of the conversation or was something else the focus of the conversation? Something else was the focus of the conversation. So what was the focus of the conversation? Mr. Gessler says objection irrelevant. Court says it was something other than relating to Lyle Menendez. The witness said it had. The court says, is that right? Yes or no? The witness says it was related to. The court says, okay, all right. If you want to pursue the objection, Mr. Gessler says, yes, Your Honor. We'll see you at the sidebar here. So, okay, Ms. Abramson says I'd like to approach and listen to this one, Your Honor. Following proceedings were held at a quick sidebar again. This is nice, not sending the jury out, just having the sidebars as opposed to what they've been doing. All right, the court says yes. Ms. Nahara says, if I may be heard, counsel. And the counsel implied that somehow this man had three conversations with the police where basically he was spying or informing on the police. She means on Lyle Menendez. In reality, one conversation was regarding what he knew about Lyle Menendez, and that's the statement about being condescending and arrogant. The next two conversations, one on October 24th, 1989, to inform the police that a reporter from the LA Times had wanted to talk to him, and at that time, the detective Zoeller said, well, if you talk to them again, let me know. Then he spoke again. The reporter called him again. These are two conversations initiated by reporters that he reported to the police that the reporters were getting to them, and that's completely different than what Mr. Gessler presented here. The court says, that's all we're trying to do. Ms. Nahara says, that's all. Ms. Abramson says, my only request is that he say nothing about his entering into any contact with Erik Menendez and calling the police to tell him that, because he did that on one of those occasions. Ms. Nahara says, no, if I could ask leading questions then. The court says, why don't you do that so we don't get into areas that implicate the co-defendant? Okay, we're back in front of the jury. The court says you may continue. Ms. Nahara says, Mr. Stevens, going back to what we were discussing, apart from the time in September of 1989 when you spoke to the police, when they asked you questions, you had two other conversations with the police. Is that right? Before the arrests, yes. And during both of those, during the 2nd of February, during the first of those two conversations, did you call the police to inform them that certain reporters had wanted to talk to you and you had given a statement? Yes. And is this why you initiated the conversation with the police? Yes. And at that time, you were asked to keep the police informed if any other reporters tried to contact you? Yes. And at the time you were asked to keep the police informed. Yeah, I just read that. Okay, yes. And in November of 1989, were you sometime during that time contacted again by reporters? Yes. And did you once again contact the police to inform them of this? Yes. And were those the only contacts that you had with police between the time of the homicides and the time that Lyle Menendez was arrested? Yes. So, in fact, one of those conversations was when they came down and asked you something at Princeton, and the other two had to do with reporters contacting you. Yes. And when you were on the airline with Lyle Menendez, and he told you that if the police got their hands on Oziel's tapes, he would be effed. Did you jump off the plane and immediately call the police and inform on him? No. Mr. Gessler says, object to that as beyond the scope of cross. overruled. Now, at some point, you were hired, you said, by Lyle Menendez to be something called the wingman. What is a wingman? That was just a phrase I used. Basically, he wanted to bounce ideas off of me and get my response to them to go along with him to see properties, and basically, he just wanted some common sense input. That's your job description? Really? And at that time that Lyle Menendez offered you the job in February of 1990, he knew that you were a student at Princeton. Is that right? Correct. And he had known you for at least a year. Is that right? Right. And did you represent to him that you were some kind of business expert? No. Did you ever fraudulently tell him that you were an expert manager, a business type person? No. And did you particularly want this job with Lyle Menendez? Well, I had spurned his advances for some time. I eventually, though, agreed to take it because at the time it seemed like the thing to do. Get out of here. No. I don't buy it. I don't buy it at all. When you say you spurned his advances at the beginning, did he come to you with this offer? Yes. And why were you initially reluctant to take this offer? Because I was still in school. It would put my life on hold for a little while. I just, I didn't know exactly in what capacity I would be working. And did you decided to work for him? What made you change your mind and decide to work for him? Well, there seemed to be a focus. We went out. His uncle Brian Anderson, I believe, out in Chicago, owns a real estate business. Lyle decided he wanted to go into commercial real estate development, and it was an opportunity for me to learn a business. His uncle was going to be advising him of these affairs, and I was going to be learning as much as I possibly could about real estate from his uncle, and then invest money in properties. And was Lyle Menendez, when he hired you, was he to be your boss? Yes. And was he your boss? Yes. And would you say that he was the person in charge? Most definitely. Oh, yes. When you say, oh, yes, what do you mean? Yes, he was in charge. I mean, anybody who worked for him did what he said. Now, on cross examination, you were asked about some items that Lyle Menendez purchased before the homicides on his credit card. Do you recall that? Uh huh, yes. And did Lyle Menendez have a credit card? Yes. And did he have a job? Not that I recall. Did he get an allowance from his mother and father? I think perhaps he did. Yes, I think he did. But he did not earn money on his own. Is that a fair statement? Yes, that's a fair statement. So what do you call managing a job and buying all this real estate up? And I assume he had plans to like rent it out and things, and that's what he was doing with the money. But let's just forget the fact that Glenn Stevens just testified that he wanted to go into commercial real estate. Lyle did. And that's why he was purchasing a restaurant. That's why he was purchasing these other places, I think, or looking at properties, at least looking. But whatever. So any money that he charged on his credit card was paid by his mother and his father. Is that right? Yes, that's right. Mr. Gesser says, I object beyond his personal knowledge, Your Honor. The court says, sustained, the answer is stricken. You don't know. Lyle might have his own funds that uh, you don't know. So you can't say. Ms. Nahara says, you knew he had a credit card that he used and you knew he didn't have a job. Is that right? Yes. Now, he charged on this credit card a dog. Is that correct? Yes. And did you ever give him any money for this dog? No. So when he charged it, it went on his credit card and that credit card was paid for by whomever paid for the credit card. Is that right? That's who paid for the dog. Yes. Did the defendant, Lyle Menendez, name this dog? Yes. Did he keep this dog in his dorm room? Yes. How? And when he went home, did he take this dog home with him? Yes. And did you feed the dog or help feed the dog? Yes. And did you help walk the dog? Yes. Is it fair to say that basically he pawned off the maintenance of the dog to you? Mr. Gessler says, object to that, Your Honor. Court says overruled. The witness says, we shared in the maintenance of the dog. I didn't do all of the maintenance. There were several people who helped in the maintenance of the dog. Ms. Nahara says, so the defendant, Lyle Menendez, had other people also helping with the maintenance of the dog? Yes. And this was his dog, was it not? Yes. You stated on cross-examination that you were with the defendant, Lyle Menendez, when he purchased the Porsche. Is that right? Yes. Were you there when he did some of the documentation on the Porsche? Yes. And were you there when he brought in a check for the Porsche? Yes. Ms. Nahara says, Your Honor, I have nothing further. Your Honor, I have another document which I would like marked, and the court says Exhibit 150 is next. Ms. Nahara says 150. Thank you, Your Honor. This is previously 55. Counsel has seen it. Mr. Gessler says, I haven't seen it for a long time. Ms. Nahara says, okay, may I approach, Your Honor? The court says yes. Ms. Nahara says, showing you what has been marked as 150 for identification, would you take a look at those documents and tell me, look at everything. Go ahead. Witness does. Tell me if you recognize what those documents are. Yes, all purchase paperwork for the Porsche. Okay, you recognize that as purchase paperwork for the Porsche that Lyle Menendez purchased? Yes. And were you there when he dropped off the check for that Porsche? Yes. How much of that? How much was it? It was $67,000, if I remember correctly. And I believe you told me earlier you recall there was some kind of discount with that? I remember something to that effect. I don't remember exactly what it was. So after the discount, it came out to somewhere around $67,000. Yes. Now, you stated earlier with regards to the Porsche and cross-examination that when Lyle Menendez purchased this Porsche, you thought that it was unseemly. Well, why did you feel it was unseemly? Mr. Gessler says, object to that, Your Honor, as irrelevant. His opinion on that, sustained. Ms. Nahara says, well, when you told him, and you testified previously that you told him it was unseemly, how did Lyle Menendez respond to that, to these concerns? Well, he had always wanted a Porsche and he had the money now. It was sort of silly not to get one. Is that how he responded? Yes. Now, on cross-examination, Mr. Gessler asked you about a statement that you had testified to earlier regarding the property that Lyle Menendez had purchased. And I believe he read to you from page 8255 of the transcript, starting at line 16 and going to line 22. Now, with regards to that, do you recall testifying at the time that there were 2 condominiums and 1 patio home, and that you didn't remember a second patio home? Yes, that's correct. Was it your understanding that Lyle Menendez only looked into the purchase of 1 patio home? Yes. And with regards to that statement, when you said, I don't remember a second patio home, I think he was trying to choose between 2 of them. What were you referring to? The question was asked about 2 patio homes, and I said, I don't remember a second patio home. There was a patio home and 2 condominiums, and he was, I think, trying to decide whether or not he was going to buy a patio home and live in it, or whether he was going to live in one of the condominiums. When you said, I don't know if he was going to purchase 2 of them, were you referring to the patio homes? Yes. Now, to the best of your knowledge, with regards to the real estate that Lyle Menendez was interested in purchasing, was there a patio home that he was interested in purchasing? Yes. And was there a condominium that he was interested in purchasing? Yes, 2 of them. Now, with regards to these 2 condominiums, had there been some attempts to purchase one of them before the homicides of Jose and Kitty? Yes, I was present at the Baralt home when the call came giving Lyle permission to get the first condominium. And then there was a second condominium over and above that Lyle also was interested in. Yes. And then there was the patio home separate and apart from these purchases. Yes. With regards to, I believe Mr. Gessler asked you about defendant Lyle Menendez's demeanor when Donovan Goudreau moved out. You testified on cross that at some point after the same day after Donovan Goudreau moved out, that the defendant Lyle Menendez kept his wallet. Do you recall that? Yes. And what was Lyle Menendez's demeanor with regards to the wallet? Well, he held it up and was laughing. He had a smile on his face and said, I kept his wallet, something to that effect. You were also asked about the conversation that you had with Lyle Menendez concerning the statement that he told you about erasing the computer. Do you recall that? Yes. And with regards to telling you that he had had the computer erased, he also described the individual who erased the computer. Is that right? Yes. And he gave a specific description, did he not? Yes. Of the IBM computer expert. Mr. Gessler says, I object and beyond the scope of cross. Sustained. Now, with regards to the conversations that you had with Lyle Menendez regarding the kind of input that you had in what he did when Lyle Menendez went to purchase the Porsche, were you against the purchase of the Porsche? Yes. Mr. Gessler says, objection, Your Honor, unless it's stated to Lyle Menendez, and we've got that, and we've gone through that. The court says, objection sustained, the answer is stricken. Ms. Nehir says, I'm sorry, Your Honor, I did not understand the objection. Court says, well, you said, as was the witness opposed to the purchase of the Porsche, his feelings are irrelevant. The issue is whether he said anything to Mr. Menendez. Ms. Nahira says, I didn't hear the word stated, and that's why I was. Did you tell Lyle Menendez that you were against the purchase of the Porsche? Yes. Mr. Gessler says, objection, asked and answered, move to strike the answer. Overruled, the answer will stand. Ms. Nahira says, was that your sole input with regards to Lyle Menendez's decision to purchase the Porsche? I don't know if it was my sole input. It was the conclusion I came to. Do you recall, as you sit there, any other irrelevant input you had in the purchase of the Porsche? I thought it handled well, and we test drove it, and I thought it was a nice car, but still, I thought it was unseemly. And with regards to that, you weren't involved in any kind of negotiations for the Porsche or anything like that? No. That was Lyle Menendez, wasn't it? Yes. And did he conduct his negotiations as far as you know? Yes. And with regards to your input in the purchase of the patio home, did you have any input with regards to the defendant Lyle Menendez's decision to purchase the patio home? No. And did you have any input with regards to the defendant Lyle Menendez's decision to purchase a condo? No. And with regards to the purchase of the restaurant, did you have any input apart from your presence with the check was when the check was delivered and at some meetings with regards to the defendant Lyle Menendez's decision to purchase the restaurant? Yes, with that we had discussed it several times. Again, like I said before, I thought that the purchase price was expensive. That was my general crux of my objection. So the only input that you had with regards to Lyle Menendez's decision to purchase the restaurant was that you thought the price was too much. Is that right? Yes, I thought it was. Also, I must say that I thought it was object to anything further as non-responsive. Sustained. Did you have any other input in the decision? Yes. And what was that? Well, I told him that I thought it was a great business. You thought it was a great business? Yes. But you thought it cost too much? Yes. Did he negotiate a lower price based on your input? No. Mr. Gessler says, objection, conclusion. The court says, sustained. The answer is stricken. Ms. Nahira says, with regards to what you've just testified to, that was the only input that you had with the defendant, Lyle Menendez's decision to purchase the restaurant, as far as I recall. And is it fair to say that the defendant made the final decision on what he was going to do? Yes. And is it fair to say that with regards to all of the decisions that he made, whether it was purchasing or any of the business, these business things he was involved in, he made all of his decisions, all of his own decisions? Mr. Gessler says, to which I object as conclusion of the witness. Sustained. Ms. Nahara says, I have nothing further. Any recross, and Mr. Gessler does have some. The court says, all right, you may. Did you want the document, Mr. Gessler? Mr. Gessler says, yes, I did. Okay. Mr. Gessler says, I don't need it at the moment, but I will in a couple moments. Thank you, Your Honor. Recross examination begins. All right, so Mr. Gessler says, Mr. Stevens, the Menendez enterprise that you talked about wasn't formed until several months after the deaths of Lyle's parents, was it? That's true. And during September of 1989, there was no Menendez Enterprises, was there? No. Nor in October or November 1989? No. So when you talked to Detective Zoeller September 18th, 1989, Menendez Enterprises hadn't been formed yet, had it? That's true. There hadn't been any business meetings with former Princeton associates with you and Lyle Menendez at that point, had there? No. And during the period of September and October 1989 is when Lyle Menendez was looking at the patio home and the condo, isn't it? Yes, I believe so. And that's the period which he was indecisive as to which one of them to buy. Yes. And as to the Porsche, he also bought that around September 1989. Yes. That's the one that you said handled well. Yes. Now, the shopping at the Princeton Mall that you told us about, that's when he spent in excess of several $100s? Yes. Ms. Nahara says objection misstates the evidence. The court says overruled. Mr. Gessler says, were you in the store with him there? Yes, several times. Well, was this one trip we're talking about in which he spent in excess of several $100s or more than one trip? Every trip. Every trip? Yes. And how many trips are we talking about that you were with him that you could tell us about? I don't recall exact numbers. Well, did you go in the store with him? Yes. On each occasion? Not each occasion. I'm sure he went, not on each occasion, no. Each occasion you're talking about, did you go to the stores with him? Yes. And did you walk around the stores with him? Yes. Did he consult with you as to what he was buying? Sometimes. Did you go up to the cash register with him? Sometimes. Did you sign the cash register invoice, the credit card receipt for him? I don't recall that. Well, you didn't, did you? No. I take it Lyle Menendez himself signed for whatever he was buying. Yes, of course. And you didn't look over his shoulder at it, did you? No. You didn't see the amount on it, did you? No. And you didn't pay the price yourself? No. So you're basically guessing at how much he spent. I know what the clothes cost. By looking at them, you mean? Well, there's very few inexpensive things in the stores that he went in. So you know that he was buying quality goods? Yes. And that he had a certain price to them, or that they had a certain price to them. Yes. So, I mean, you're going into like name brand stores. So you're going to be paying more for what you're buying. And you, in your head, were kind of totaling up what you thought what he was spending. Well, yes, I used to have discussions with the sales clerks about it. Mr. Gessler says, well, I moved to strike that the latter part of the answer, Your Honor, as non-responsive. The court says anything after yes is stricken as responsive. Mr. Gessler says, as to the spurned advances in the school, you said that finally he got you to come work for him, right? Yes. And what happened to the depression and the burnout that you told Princeton about? Well, that was still there, coincidental with that. So the depression and the burnout were coincidental to Lyle Menendez getting you to come work for him. Yes, they just happened to coincide at the same time. Well, as I testified before, it was sort of convenient at the time that I decided, okay, I want to take a year off now that there was a job offer there. But for months before that, before I had agreed to taking a year off from school, I had spurned his advances, yes. Because you weren't burned out or depressed at that time? It was getting there, but I hadn't convinced my parents to allow me to take a year off. That kind of thing. Mr. Gessler says, may I approach the witness for a moment, Your Honor? Court says, yes. This is the exhibit that the prosecution showed you concerning the Porsche. Yes. Exhibit number 150. Mm-hmm. And I think you looked through it, didn't you, when Ms. Nahara was... I didn't read it all, but I flipped through it, yes. I take it that's because you had seen the paperwork before. The scientific paperwork that I remember, the check also, oh, scientific, no, that's a specific. It's been a long day of reading. I need a break. The specific paperwork, we're almost done, I swear. Like we're right at the tail end of Glenn Stevens, and then we will conclude this stream, and the next stream will be Jamie Pisarcik. So we will get to Lyle's ex-girlfriend. He says he didn't read it. I take it that's because you had seen this paperwork before, the specific paperwork that I remember, the check, also the sticker on the car, these things. All right, you say these things. You're talking about the check? Did Lyle Menendez show you a check? Yes, I believe we even went to the bank to get the cashier's check together. And he showed it to you as to the amount for the Porsche. Yes. And he had you go through these documents with him to see if they were a good deal? I looked over his shoulder as he was signing some of the documents at the Porsche dealership. Whether or not I was advising him or as to whether or not it was a good deal, I don't recall. As you looked over his shoulder, you were close enough to say that this is the very document that Lyle Menendez was signing then. I said resembles the document that I saw that day. And are your initials on any of these pages here? No. So you've never gone through this document page by page, then, have you? No. Not until today when it was shown to you by the district attorney. That's true. I have nothing further, Your Honor. Court says any redirect. Ms. Nahara says no, Your Honor. The court says, all right, you may step down. Remember, this was a witness only for Lyle. And the court's going to remind them. The witness says, thank you, Your Honor. The court says, just to restate what I said before, this testimony of this witness is received only as to the defendant, Lyle Menendez, and it should be considered and may be considered only in regards to the case of People versus Lyle Menendez and not considered at all as to the co-defendant. All right, we will take our recess and we'll resume at 3:30. And when we come back in the next stream on Friday of this week, we will go through Jamie Pisarcik. Pisarcik? I'm going to have to double check her, the pronunciation of her name, but we will go over her testimony. And she's on the stand, I forget now. She's on the stand October 31st, November 1st, and some of November 2nd. So we will go through all of that. I'm going to try to do it in one episode, but that's a lot. So I might have to break that down. So we'll see, because that's a lot of testimony. We'll see how long the days are. Sometimes the days are shorter, and then I can get a full day in. but sometimes they are not. So I'm going to have to double check and see how long her testimony is. But we will proceed with Jamie. And following her, I did have this just up. It was following her is the uncle of the brothers, Brian Anderson. He was one of the last remaining relative. Well, he passed away a few years ago, a little while ago. And more recently, Milton, his brother, passed away, and these two were the two brothers that were against the Menendez brothers getting out. And so we will go through Brian Anderson's testimony, then Marcy Eisenberg's testimony. So that will conclude our week 4. And we'll go from there. So I will see you guys in the next one. Please don't forget to hit that like button for me. And thank you guys so much for watching. Take care. Bye now.